Court officer, court officer, court officer. Court officer,
ಸರಿ ಸರ್ ನಾನು ಇದು ಮಾಡ್ತೀನಿ ಸ್ಟೆಪ್ಸ್ಗೆ ಅಂದ್ಬಿಟ್ಟು ಇದು ಮಾಡ್ತೀನಿ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ಗೆ ಐತೆ
court officer, court officer. Court officer? Court officer? Court officer?
ಹೇಳಿ.
ಹಾ ಸರ್, ನಿನ್ನೆ ಹೇಳಿದ್ದೆ ಒಂದ್ ನಂಬರ್ ಬರ್ಕೊಳ್ತೀರಾ? 3ನೇ ತಾರೀಕಿಗೆ ಪೋಸ್ಟ್ ಆಗ್ಬೇಕಾಗಿತ್ತು. 3 ಅಂತ ಡೇಟ್ ಇದೆ.
ಹಾ
3868/17.
3868/70.
And 51 connected with 5193/17.
ಹಲೋ,
ಹಾ, ಎಲ್ಲ ಕ್ಲಬ್ ಆಗಿದೆ. ಇದು 5193/17 ಎರಡು ಒಂದೇ. ಇದು ಅದು ಒಂದ್ ಬಂದ್ರೆ ಎಲ್ಲದೂ ಬರುತ್ತೆ. ಕಳೆದ ವಾರ ಬಂದು 3ನೇ ತಾರೀಕು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು, ಬರ್ಲೇ ಇಲ್ಲ.
ಸರಿ ಸರಿ.
ಸ್ವಲ್ಪ ಹೇಳಿ ಸರ್, ಎಲ್ಲೋ ಮಿಸ್ ಆಗಿರ್ಬೇಕು. ನಾ ಪಾರ್ಟಿಗೆ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೇನೆ.
$34, $62, $61, $75, $43, $88, $21, next admission, $19, $14, $64, $26, $36, $36.
20.
$83, 85 connected case. 45. 67 connected. 09, 29, 209, 28, 81, 20, 52, 23, 93.
It's calculator. ಚಾಕ್ಲೇಟ್ ಅದೇ ಮನೆ ತಂದಿದ್ರ ಚೀಪು.
ಅಲ್ಲಿ ಕೊಡ್ತೀನಿ, ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀನಿ. ಅಪೀಲ್, ಇನ್ನೊಂದು ಅಪೀಲ್ ಇದೆ, ಇನ್ನೆರಡು ಕ್ಲೇಮೆಂಟ್ಸ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
How many? How respondent ಅಂತ ತೋರ್ಸೇ ಇಲ್ಲ. ಕುತ್ಕೊಳ್ಳಿ ಕುತ್ಕೊಳ್ಳಿ ಸರ್. ಹೇಳ್ತೀನಿ ನೋಡಿ ಹೇಳ್ತೀನಿ.
SC ಮ್ಯಾಟರ್ ಥ್ರೆಟ್ ಆಫ್ ಡಿಸ್ಪೋಸಿಷನ್ ನಾಳೆಗೆ ಅದು ಎರಡು ಮ್ಯಾಟರ್ ಮೂವ್ ಮಾಡಿದ್ದು, ಒಂದು ಮಂಡೇ ಬಂದಿತ್ತು, ಇನ್ನೊಂದು ಬೋರ್ಡ್ ನಲ್ಲಿ ಇದೆ, ಅದೇನು ಮೆಮೊ ಎಕ್ಸ್ಪೈರಿ ಅಂತ ಇದೆ ಸುಮಾರು.
For page wise adjournment, list number 1, page number 1, serial number 1 to 6. Page number 2, serial number 7 to 14. Page number 3, serial number 15 to 18. Page number 4, serial number 19 to 22. Page number 5, serial number 23 to 28. Page number 6, serial number 29 to 33. Page number 7, serial number 34 to 37. Page number 8, serial number 38 to 42. Page number 9, serial number 43 to 47.
My lord, serial number 43, my lord, 43.
Yes.
My lord, my appeal is 5872/19, my lord. I
Yes.
filed an IA for early hearing in this case actually.
Yes.
5872/19. Next week at any specific date may be given. Date ಕೊಟ್ರು ಕೆಲವು ಸಲ ಬರೋದಿಲ್ಲ ಸ್ವಾಮಿ.
No, that in this case service is not completed.
ಅಲ್ಲ, ಅದು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಹಾಕ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ರವಿ ಸಂಪ್ರತಿ.
Then wait, let the matter is reached. Let him file an application. Yes.
Page number 10, serial number 48 to 54.
My lord, serial number 53, my lord. I am appearing for the appellant.
Yes.
I have given NOC, my lord. That advocate will file wakalat within 1 week, my lord. Great. Kindly grant 1 week time, my lord.
Who has to file wakalat?
My lord, I have given on advocate, my lord. He said you would file, my lord. So,
Yes. At the request of counsel for the appellant, leave this matter next week.
ಸೀರಿಯಲ್ ನಂಬರ್ 52, my lord, 52. ಅದು ಪ್ರದೀಪ್ ವಕಾಲತ್ ಹಾಕ್ಬೇಕು. 1 week ಅವ್ರಿಗೆ ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ 1 week ಟೈಮ್ ಕೇಳಿದ್ದಾರೆ.
Yes.
Serial number
Request. At the
Specific date may be given.
respondent number 1, leave this matter next week. Yes.
Page number 11, serial number 55 to 58. Page number 12, serial number 59 to 61. Page number 13, serial number 62 to 64. Page number 14, serial number 65 to 70.
My lord, serial number 69, my lords. I am
Yes.
for respondent number 3.
Yes.
Kindly, my lords, 2 week then time may be granted, my lords.
Why, Mister?
Lords, some instructions has to be taken, man.
Yes, sir. The
I have
request of
informed my
counsel
other
for
side,
the
man.
opponent. Leave this matter after 2 weeks. Yes.
List number 1, preliminary hearing matter, serial number 1, Jai Prakash Reddy M for petitioner, Veena Kumar M.
respondent 4, my lord.
Who is that? Jai Prakash?
Last time also.
Jai Prakash Reddy, who is that?
My lord, I know him by face, but
No counsel for petitioner, release this matter.
we had sought to challenge the amendment, my lord, but.
No, the last occasion he was present. Yes, 2-9.
Yes, ma'am. They request for an adjournment.
Yes.
The amendment, however, is of no consequence in this case because 2009 alienation challenged in 2013.
Yes.
So even the earlier decisions of this court and the Supreme Court will not come in the way of this.
What is that limitation in this case to file for this thing?
There's no
Appear for petition, my lord. I'm seeking direction to the respond number 1 and 2 to consider my representation, seeking for permission to sell the property, my lord. As per Annexure C, my lord, 15 years, 15 ವರ್ಷಗಳ ಕಾಲ ಪರಭಾರೆ ಮಾಡಬಾರದು ಅಂತ ಇದೆ. As per condition number 8, my lord.
Who are you?
I am the daughter of the grantee, my lord, original grantee.
Who is the grantee? Yeah, where is the grantee?
Grantee is the Govindappa, my lord.
Govindappa.
Govindappa.
Who are
And,
that?
In the year 2017, my lord, the partition was taken place between daughter and the father, my lord. They have
There is
produced-
no other legal representative,
No legal representative. my
only a
lord.
daughter.
Daughter, only daughter, my lord.
Where is your application?
Application Annexure C, my lord. Annexure A and B are the application, my lord. Representation given to the respond number 1 and 2.
I think
Annexure
that
C
they
is
have
the
a
grant.
format. In that
C, my
application, huh?
Annexure C is the grant certificate.
Grant certificate, sorry. They have in a format how to apply for permission. Yes, Mr. Government Advocate, you take notice and verify. Government Advocate is directed to take notice, respondent number 1 and 2. Counsel for the petitioner is directed to serve 2 sets of copies.
Please. The date may be given, my lord.
2 weeks.
2 weeks.
Yes.
Serial number 3, Narayana Swamy PM.
Petitioner in this case. Virtually the land kind of 1968, Muniappa, madam. The petitioner purchased land 1991, madam. Muniappa was died, madam. The petitioner, the purchased land 1991, lapse of 25 years, madam. The respond number, LRs of respond number 4, madam. The filed petition before the Assistant Commissioner.
When?
Annexure B, madam, Assistant Commissioner, madam. 2017 has filed the applications, madam. Lapse of 26 years, madam, filed the applications, madam.
What is that AC has held?
Yes, madam, without only reasoning, madam, without self permission, the file is ready.
AC has allowed their application.
No, but allow the application. The
Now,
file-
what about the DC?
These are confirm the Assistant
From
Commissioner.
that,
Please, madam.
when that order has been passed?
Annexure here, madam. This are about
2024.
2008.
Yes.
Without giving any notice, madam, the petitioners, madam.
You are not appeared there.
No, madam.
Why?
Without giving any opportunity,
ಮೇಲ್ಮನೆ
madam.
ತಮ್ಮ ಅಪೇಕ್ಷೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ ಸದರಿ ಮೇಲ್ಮನೆ ನಿರ್ಮಾಣಕ್ಕೆ ಯೋಗ್ಯತೆ ಇರುವುದರಿಂದ ಅರ್ಜಿದಾರರು ರದ್ದುಪಡಿಸಿರುತ್ತಾರೆ. Yes. Out. Issue notice. Government Advocate is directed to take notice for respondent number 1, 2, 3. Counsel for the petitioner is directed to serve 3 sets of copies. Stay of annexure. A and B. Till next date of hearing.
Serial number 4, KL Srinivas.
For the petitioner, my lords, sir. Lords, the petitioner is the purchaser of the land bearing survey number 67.
Yes.
The land has been granted in favor of the grantee during the year 1955, my lords.
Yes.
Thereafterwards, the son of the grantee sold the land in favor of the petitioner during the year 1989.
89.
25/1/89.
Hmm.
Thereafter, my lords, his son, who is respondent number 4, filed the petition before the learned State Commissioner on 1/3/2013, after lapse of 24 years, my lords. That petition came to be allowed.
Where is that order of the AC?
That is at annexure E, page number 28, my lords.
Yes, application is filed 2013.
13. That is at page number 25, annexure D.
Yes. Then what is that Deputy Commissioner order?
My lords, the Deputy Commissioner has confirmed the order passed by the Assistant Commissioner.
When?
That is on 11/7/2024, annexure F, my lords.
Why what is that annexure D and E?
Annexure E is the order passed by the Assistant Commissioner.
What is annexure D?
Annexure E is the order passed by the Assistant Commissioner allowing the
D.
D.
Hmm.
D is the appeal memo, my lords. Petition
memo.
filed by the respondent number 4, seeking for resumption of land.
139/2013.
And they have not stated any reasons for the delay of 24 years. And
Yes.
that has not been considered.
Even DC is also confirmed that.
Please, my lords.
Or issue notice. Government advocate is directed to take notice for 1 to 3. Counsel for the petitioner is directed to serve 3 sets of copies on government advocate. Stay of further proceedings in. Stay of, which is that annexure, Mr.
Annexure E and F, my lords.
Annexure
E and F.
E and F till next date of hearing.
Serial number 5, Narasi Reddy G.
This case challenged the annexure A, my lord. The
Hmm.
order passed by the deputy commissioner. Highly similar. On 25/3/1981, the sixth respondent Tahsildar was granted the land in favor of the grandfather of the petitioners. My lord.
You are the grantee,
Yes, I'm
1981.
25/3/1981, my lord. Yes, my lord.
Hmm.
16/9/2025, my grandfather and his family members were sold the property in favor of the seventh respondent. My lord.
When?
At 16/9/2005, my lord.
2005.
Yes, ma'am. It is the clear violation of the section 4(2) of the SC/ST Act, my lord. The grandfather of the petitioner MB Sri Venkataramanappa died on 16/4/2010, my lord.
What is that assistant commissioner order passed?
Assistant Commissioner, my lord, this petition was not come under this one, my lord. What SC/ST ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಇದನ್ನ ಮಾಡಿದ್ರು.
Why?
Agnistment. ಇದನ್ನ ಯಾಕಂದ್ರೆ ಫ್ರೀ ಗ್ರಾಂಟ್ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು and then he has obtained the order from the sale permission ತಗೊಂಡು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. But clearly stated, they have not obtained the sale permission. They have created the false sale permission details.
ಕೆಲವರು ಸುಳ್ಳು ಎಂದು
ಹೌದು.
ಅರ್ಜಿದಾರ ಪರವಾಗಿ ನೀಡಿದ ಅನುಮತಿ ವಾದಿಗಳು ಹಾಗೂ ಅವರ ಕುಟುಂಬ ಸದಸ್ಯರು ಜಂಟಿಯಾಗಿ ಪ್ರತಿವಾದ ಕಾರ್ಯಪತ್ರ ಮಾಡಿರುತ್ತಾರೆ. ಅದು ಉಲ್ಲೇಖವಾಗಿರುತ್ತದೆ.
Kindly see.
ಅರ್ಜಿದಾರರು ಅವರ ಅರ್ಜಿಯಲ್ಲಿ ಹೇಳಿರುವ ವಿಚಾರವನ್ನು ಸುಳ್ಳು ಎಂದು ಸಂಖ್ಯೆ ಕ್ರಯ ಮಾಡಿ ಪ್ರತಿವಾದಿಗಳಿಗೆ
Ink page number 22, man.
No, what is that, the order which is mentioned in that sale deed?
Sale deed, my lord. Same sale deed mentioned, my lord. It was affected. Kindly see the annexure. This one, my lord. Annexure. Annexure. Ink page number 59, my lord. 58 is the first page. Annexure L.
There is the reference of government.
Here, my lord. Ink page number 59, my lord. Kindly see, my lord. ಈ ಸೊತ್ತು ಕರ್ನಾಟಕ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಹೌದು.
ಪತ್ರ ಸಂಖ್ಯೆ 80/89 ಸರ್ಕಾರ ಅಂತೆ. You government advocate, you verify that this is is there any order of permission?
It is, my lord. Deputy commissioner ಮುಂದೆ ಅಲ್ಲ 1 minute. Deputy commissioner ಮುಂದೆ ವೆರಿಫೈ ಮಾಡಿದ್ದಾರೆ. It is false. ಇದೆಲ್ಲ ಇದು ಬೇರೆ ಲ್ಯಾಂಡ್ ಗೆ ಸಂಬಂಧ ರಾಯಚಂದ್ರ ವಿಲೇಜ್ ಬೇರೆ ವಿಲೇಜ್ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
DC ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಅದೇ DC ಮಾಡ್ಬಿಟ್ಟು ಮತ್ತೇನೆ ಇದು SC/ST ಏನೋ ಬರೋದಿಲ್ಲ ವಿಳಂಬ ಆಗಿದೆ ಅಂತ ಮಾಡಿದ್ದಾರೆ. Kindly see the ink page number 22, my lord. I will read the relevant para, only one para. I will not read much.
Yes.
In para number, last para, my lord.
Yes.
ಉಭಯ ಪತ್ರರು ವಾದ ಮತ್ತು ಪ್ರತಿವಾದಗಳನ್ನು ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಮೇಲ್ಮನವಿದಾರರು ನಮ್ಮ ಮೇಲ್ಮನವಿಯೊಂದಿಗೆ ಸರ್ಕಾರದ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ದಿನಾಂಕ ಸೋನ್ಸೋ ನಕಲು ಹಾಗೂ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಅಧಿಸೂಚನೆಯ ಅಧಿಕೃತ ಜ್ಞಾಪನ ಸೋನ್ಸೋ
ಜಿಲ್ಲಾಧಿಕಾರಿಯಿಂದಲೇ ಪೂರ್ವಾನುಮತಿ ಕಂಡು ಬರುವುದಿಲ್ಲ. Why this assistant commissioner has held, Mr.?
ಹೇಳಿ.
Why can't you made him responsible?
It is the grant certificate and documents.
No, see, should you not verify when he is passing that order? DC has verified that is not related to this property. ಮಂಜೂರಾತಿ ಸಂಬಂಧಿಸಿ ಯಾವುದೇ ದಾಖಲೆಯನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಪ್ರಸ್ತುತ ಪ್ರಭಾರಿ ಆದೇಶ ಪಾವತಿಸಿದ ನಂತರ ಮಂಜೂರಾಗಿದೆ ಎಂಬ ಬಗ್ಗೆ ತಿಳಿಸಿರುವುದಿಲ್ಲ. ಮುಂದುವರೆದ ಸದರಿ ಜಮೀನು ಸಂಬಂಧಿಸಿದ ತಿಳಿಸ್ತಾರೆ.
Annexure J and K also produced, my lord. That is belongs to Raisandra village, some other village, not at all related to this
Issue
property.
notice. Government advocate is directed to take notice for why that KDB has been made.
KDB, my lord, subsequently during the pendency of the appeal, KDB was acquired the property. Now he is trying to withdraw that amount based on this orders, my lord.
Yes. Who is appearing in?
KDB Chandrasekhar has served the copy in
Yes.
last
Chandrasekhar.
session.
Initial ordo?
Chandrasekhar anta initial. What is it?
PV Chandrasekhar is directed to take notice for respondent number 2. 2 and 3. ಎರಡು ಅವರಲ್ಲ?
Awesome.
Government advocate is for 1, 5 and 6. Counsel for the petitioner is directed to serve 3 sets of copies on government advocate. 1 set of copies on PV Chandrasekhar. Issue emergent notice to other respondents. Stay of annexure A and
Email.
what is that interim order you sought, Mr.
They are trying to withdraw the amount, man.
B. Correct, A and B na?
Yes.
Yes, yes. A and B till next date of hearing.
Serial number 6, Shashi Kumar M for
Achha.
petitioner.
May I please,
Yes,
appearing for the learned
yes.
petitioner. My lord, challenging the initiation of the proceedings, my lord, before the Assistant Commissioner, section 5.
You are a purchaser or a grantee?
I am purchaser, my lords. Now, my lord, the original grant, my lord, may kindly see, grant is of the year 1958.
Yes,
Sold, first sale is 1995.
25.
That, my lord, by the original grantee, along with his sons, ever a consenting party, my lords.
Yes.
Then, my lord, thereafterwards, the present sale is 2007 again, my lords.
Yes.
There are 3 sales have taken place. Now,
Yes.
my lord, the application is filed before the Assistant Commissioner stating that in view of the amendment, now we are filing this application by the grandchildren.
Now, when the application is filed?
2024. January,
What is
20
the order of the assistant commissioner?
Assistant Commissioner, my lord, receives that application, my lord.
Hmm.
Along with the application, there is an application for condonation of delay.
Hmm.
My lord, nothing is, no order is passed on that.
Hmm.
Page 33,
Hmm.
an ex parte interim order is granted.
What is that interim order?
Interim order is mutation of 2014-15 is stayed. Page 33. Several hands have transferred the page 33, my lord, the
Yes.
please, my lord, at the top, my lords. ಪ್ರಕರಣವನ್ನು ದಾಖಲಿಸಿಕೊಂಡು ತಹಶೀಲ್ದಾರ್ ಅವರ ಆದೇಶ ಸಂಖ್ಯೆ ಡ್ಯಾಶ್ ಅದಕ್ಕೆ ಮುಂದಿನ ವಿಚಾರಣೆ ದಿನಾಂಕ ತಡೆಯಾಜ್ಞೆ ನೀಡಿದೆ ನಿಗದಿಪಡಿಸಿದೆ ತಡೆಯಾಜ್ಞೆ is being continued.
Yes.
My lord, the land has been converted long back. Now the application is filed by the grandchildren after, my lords,
No, now that
29 years.
still case is pending.
Still the case is pending. My lord, initiation of the proceeding, my lord, after 29 years by the grandchildren is impugned before, my lord, on the ground.
Mr. What is that hurry for your officer, Mr.?
Copy was not served, no file is there, my lord, let them serve the copy.
See, admittedly, they have sold the property.
Yes.
Admittedly, they have filed an application for restoration. That means to say they don't have in the position. When proceedings is initiated, before he is passing that order, how can he pass an interim order? It is admitted fact that they are not in the position. Yes. Or issue notice. Government advocate is directed to take notice for respondent number 1. No, idrna ask your colleagues to correct it. It is not state government represented by assistant commissioner. How can that assistant commissioner represent?
I will ask.
Yes, you make
Please,
it assistant commissioner as a.
That has to be corrected. We will get it.
Yes.
Sorry, it also missed my attention. Grateful to the Honorable Court for enlightening us.
Directed to take notice for respondent number 1. Directed to serve 1 set of copies. Issue emergent notice to other respondents. They have further proceedings in annexure A till next date of year.
And further proceedings. Please,
Serial number 7, Satish K for
grateful.
petitioner.
Similar matter, my lord.
I
purchased in 98. The first purchase is 95. That's 104 purchase is 95. I purchased in 98. I developed the property. 3/7/2024, in view of the amendment, not proceedings are initiated.
Hmm.
That's all. I am questioning the Act 30 as well as proceedings, both.
No, you contesting matter before the assistant commissioner. What is that?
My lord, when I am questioning the Act, kindly see my prayer.
Hmm.
My prayer is Act number 30.
Even this amendment is not there, they can also file it. Even if it is your petition for challenging the validity is upheld, there is no bar for him to file an
Right.
application.
This court will not examine the identical question, my lord.
Hmm.
In fact, it appeals.
No, ultimately,
Yes, my lord is
he
right.
has to reject his application,
Right.
AC and
At
DC.
the same time, Lord, since
And
Act
in so many cases, they have done it. In view of that, why
But-
you
but
have rushed to this court?
question is, my lord, they can't initiate the proceeding. No notice is issued.
No, there is no bar for initiation even without amendment. The
But
reason is,
since-
yes, initiation, there is no bar.
Not-
But thing is that the delay, they have not explained, then it has to
Lord,
go for.
Itself is not
Lord, since the Act number 30 is questioned, application cannot be entertained at all. That is my, Lord, plea.
Okay, take notice.
Lord, this court, in fact, identical situation, in writ appeal, examine the amendment also. My lord knows that.
Yes. No, now that even that all matters in respect of constitutional validity also, its matter has been heard. Sometime it's pending for consideration.
Yes, yes.
See, it will not make any difference for the amendment. You have seen that.
Yes, yes. Yes.
That's what the division bench also
Yes, yes,
considered.
also.
Because earlier also there was no limitation. Now by amendment, they said there is no limitation.
But the appeal, 3724, application is filed in view of the amendment. Otherwise, my lord, he says in the appeal.
Yes. Heard. Issue notice. Government advocate is directed to take notice for respondent number 1 and 2. Counsel for the petitioner is directed to serve 2 sets of copies to government advocate. Stay of further proceedings pursuant to annexure
H.
H. Yes.
Admission matter, this is serial number 8, Kaveri Timmoya for petitioner.
But notice to R3 and R4 may be.
No, all other respondents notice, sir.
Yes.
Only government you have to serve a copy.
Yes, yes.
My lord, I appear for the petitioner husband. We have sought for the transfer of the divorce petition filed by the wife at Bangalore to Shimoga, my lord,
Yes.
on the
Submit
grounds that the
notice to
husband has
respondent
lost 100% vision in both eyes.
Publications. In web. And Kannada Prabha, Bangalore edition. Pursuant to that, petitioner has filed in a memo enclosing that paper notification, paper publication. Respondent
Shilpa Kala P.
is called. None appear. The memo is accepted. Service of notice to respondent is held sufficient. Please this matter next week.
My lord, this order was passed on the last date of hearing. My memo was accepted on the last date of hearing, day before yesterday, my lord.
Petitioner submitted pursuant to the order of this court, taken notice to the respondent way up for the reason stated in that summons. Which date? 12/7.
Day before yesterday, my lord. Matter was listed on the 9th.
Petitioner. No, it is not listed on 9th.
It was, my lord.
Total.
And the order accepting my memo was passed and the matter was then listed for the 12th.
Yes, let us see. Leonard Council petition supports the pursuant to the order, memo is taken out. Wait for acceptance, the purpose along with the copy of the memo is taken out. And called out service of notice, ಆಯ್ತಲ್ರಿ ಮತ್ತೇನಿದ್ರಿ ನೋಟಿಸ್ ಯಾರ್ರಿ ಅದು ಯಾರು ಪರ್ಸನ್ ಅವರು ರಿಜಿಸ್ಟರ್ ಜುಡಿಷಿಯಲ್ ಪರ್ಸನ್ yes madam
May I commence with the arguments? my lord?
yes
As I was submitting, my lord, we have sought for a transfer of the divorce petition filed by the wife at Bangalore to the family court at Shimoga on the ground that the husband has lost 100% of his vision in both his eyesight. And it would be difficult for him to travel all the way from Shimoga to Bangalore, which is a distance of close to 300 kilometers. In fact, if your lordship would also look into the petition of the wife, she has also stated that the husband has lost his vision. The parties last resided in Shimoga. Hence, the court at Shimoga also has jurisdiction. Page number 18
now
of,
what is that wife doing here
my lord, she left the matrimonial house in 2020 and she filed this petition. In her petition, she
No.
states,
is she doing any work here what
we are not aware of that, my lord, but she has filed her petition saying that she's currently residing in Bangalore.
where is that
My lord, the petition is at Annexure B, page 15. And on page 21, para 30. Para 30, the last paragraph, she states the petitioner is resident of the above said address at Bengaluru.
no which is that actual residence of petitioner wife
She states that she's residing at Bengaluru. Her parents are from Chikmagalur.
they are from Chikmagalur yes their parents are there in Chikmagalur or
Yes, their parents are, her parents are there.
then she is working here housewife she has given housewife
Yes, my lord, but I'm not currently aware of her whereabouts as well, because when we tried to serve even through hand, she was not at the address, and that is why this honorable court had directed us to take out
what has
paper
happened to that
publication.
notice sent by the
I have also been informed that subsequent of
application and paper publication 3 times they have to take the have you served the council appearing before the trial
I have, my lord, and I filed the memo also
Yes.
reflecting the same.
where is that ನೋಡಿ ಅದು research ಮಾಡಿ.
On 13th September 2023, I'd filed the memo.
Yes, what is the stage there now, case?
The divorce petition here, your honor, I obtained an interim order of stay. We had just entered an appearance and thereafter I'd gotten a stay here. I've also been informed that after we filed this transfer petition, the petitioner husband filed a petition at Shimoga for restitution of conjugal rights. Therein the wife had appeared, she'd entered appearance, but when the trial commenced, they stopped appearing. It's been posted for judgment, my lord. My petition for restitution of conjugal rights.
Rights. Where that council has represented by her.
Yes, earlier represented, but at the stage of trial, they stopped appearing.
Where is that she said he is blind? Have you produced any medical?
Yes, I have produced his disability certificate as well.
Yes.
But if your lordship would also look into her petition, page number 18. Page number 18, para 13. The petitioner submits that the petitioner wife.
Yes.
Para 13, the petitioner wife submits that the petitioner tolerating everything was living with them. Further, the petitioner was taking him to different hospital for giving proper treatment for his eyes. In spite of her hard, good efforts was in vain, as finally in September 2016, he lost his eyesight.
No, how? It is not by birth.
No, my lord, it's not by birth.
What has happened?
He has been diagnosed with a disease called bilateral retinitis pigmentosa. In fact, in para 17 in the following page,
Yes.
my lord, para 17, she also says the petitioner wife submits that however petitioner has tolerated everything for a child and a family. Between this, the respondent lost his eyesight completely. It is after marriage that he lost his eyesight, and I have produced the disability certificates and
That,
page number 24 onwards, my lord.
oh, where is that petition filed by you for restitution of conjugal right?
My lord, that was filed subsequent to filing the transfer petition, so I haven't filed that
What is that
petition.
number?
MC 70 of 23, my lord.
70 of 23.
Please, ma'am.
It is pending there.
It's posted for judgment, my lord.
Yes.
And if my lord,
Really. So and so learned counsel appearing for petitioner husband contended that. Which was that matrimonial home?
Shimoga, ma'am, which is also admitted by her in her petition.
Yes, after the matrimonial dispute, respondent wife has left the matrimonial home residing in Bangalore. She has filed MC 4754 of 2022 for dissolution of marriage before Principal Judge Family Court, Bangalore. The respondent husband has filed MC number 70 of 2023 for restitution of conjugal right before Family Court,
Shimoga.
Shumaga. In that case, respondent has appeared through their counsel and prosecuted. Further, the respondent, the petitioner is suffering from blindness. And he has also produced disability certificate too. He has 100% blindness, and it is difficult for him to come to Bangalore to prosecute the case. Hence, he sought for allowing that civil petition. The respondent the petitioner has taken a notice to respondent. Since notice is not served and has filed an application for substituted service, they have taken a paper publication in New India Express and Kannada Prabha in Bangalore edition. And they have also served a copy on the counsel appearing for respondent in the trial court. In spite of that, the respondent is not appeared. Hence, service of notice to respondent is held sufficient. Heard the learned counsel for the petitioner. The petitioner and respondents marriage was solemnized on 16/5/2010 at Raita Bhavana, BH Road, Tarikere, Chikmagalur district, as per that Hindu rites. Due to marriage, any issues, child born,
They have a 13-year-old daughter, my lord,
daughter with whom? With
with the mother.
mother. Due to wedlock, the female child was born. Now she is 13 years. After the matrimonial dispute, respondent wife left the matrimonial home residing in Bangalore. She has filed MC 4754 of 2022 for dissolution of marriage before Family Court, Bangalore. Respondent petitioner husband has filed MC 70 of 2023 for restitution of conjugal right before Family Court, Shimoga. In that case, respondent wife appeared through counsel and prosecuting the same. The specific case of the petitioner that he is suffering from 100% blindness. To that effect, the disability certificate issued by Medical Authority, Shimoga, has been produced. Even in the MC petition, the respondent wife itself has pleaded that which is that paragraph?
Page number 17, my lord. Para 17, my lord.
Para 17.
Para 13 and 17.
Yes. Has pleaded that the petitioner has lost his eyesight. In view of the above, it is difficult for the petitioner to come to Bangalore for prosecuting that case. From Shimoga to Bangalore, it's about
300 kilometers.
300 kilometers. Considering that inconvenience made out by the petitioner husband, the above civil petition required to be allowed. Accordingly, CP is allowed MC number 4754 of 2022 pending before first additional principal judge Family Court, Bangalore is withdrawn. Same is transferred to Family Court, Shimoga. ಆಫೀಸಲ್ಲಿ ಕೋರ್ಟ್ ಆರ್ಡರ್ಗಳು ನೋಡೋದಿಲ್ಲ. ಈ ಲಾಸ್ಟ್ ಕೇಸಲ್ಲಿ ನಾನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ, ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಅಕ್ಸೆಪ್ಟೆಡ್ ಅಂತ. ಇವತ್ತು ಮತ್ತೆ ಹಾಕಿದ್ದಾರೆ. ನಾವು ವಿಲ್ ಸಿ ಓನ್ಲಿ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಫೈಲ್ ತೆಗೆದು ನೋಡೋಕೆ ಮತ್ತೆ ಟುಡೇ ಆಲ್ಸೋ ಐ ಹ್ಯಾವ್ ಡಿಕ್ಟೇಟೆಡ್ ದಟ್ ಅಕ್ಸೆಪ್ಟಿಂಗ್ ದ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್. ಇದು ಮೊನ್ನೆನೂ ಯಾವುದೋ ಹಿಂಗೆ ಮಾಡಿದ್ದಾರೆ. ಅಡ್ವೊಕೇಟ್ ಹೆಸರು ತೋರಿಸೋದಿಲ್ಲ, ಆರ್ಡರ್ ಶೀಟೇ ನೋಡಲ್ಲ, ಜಸ್ಟ್ ಇನ್ಫಾರ್ಮೇಶನ್. ಎಸ್ ಎಸ್.
Serial number 9, Vishnu Murthy for petitioner, Sharath S. Gowda.
For the respondent, my lord. My lord,
Yes.
previous hearing alli, if there are any chance of mediation anta helidre, my lord. My lord, my client is not ready for mediation, my lord. Avarge divorce beda, but petitioner wants divorce, my lord. So we'll undertake that will not harm the petitioner, my lord.
My lord, in this
Yes, you
case,
argue that what is that?
my lord, in this case, the wife is in Carpet. Husband petitioner is in Hole Narsipur. Earlier, within 3 months of the marriage, he left and went. So we had filed a restitution before this court, which he took a transfer to Carpet. So he was appearing there. There he was assaulted and even a case was registered, FIR is there, I have produced. Later, they came all the way to Hole Narsipur also, and there is case and counter case which is not appearing. So my prayer before this honorable court is, I don't want in Hole Narsipur or Carpet, kindly transfer to Bangalore where we can have a settlement. And last time we spoke for mediation also. She doesn't want to join. She doesn't want to give divorce. She wants to stay. See that only he should not get married. That is her intention.
No, that now which is the place which you want to seek transfer?
From Carpet to Bangalore.
You file an affidavit.
Yes, my lord.
See, we will permit him to appear through VC. We'll direct the court to whenever, if court wants his personal appearance, If whenever he is appeared, you have to file an affidavit from you and your family members will not threaten him.
Yes, my lord.
If there is any threat, we'll also direct the police to give an assistance to you. Have you filed it?
My lord, I'm filing it.
What is that?
Affidavit, my lord.
What is that?
Under,
Have you
my lord, para number 5, my lord.
have you served the copy to her?
No.
Yes.
Para number 5, my lord.
Hmm.
I state that in spite of the petitioner making false allegations against my parents and brother, however, I hereby undertake that me or my relatives or anyone on my behalf would not threaten, assault or interact with the petitioner inside or outside the court, except for negotiation for settlement in the mediation center or in the presence of respective counsels.
Negotiation of settlement in the mediation center or
If any, my lord, if any in the future.
They would
No,
not assault.
hereby undertake anyone may not threaten, assault to
Or interact with the petitioner
petitioner
inside or outside the court.
outside the court,
Except
except negotiation for settlement.
Only
if
for
there is
negotiation.
any
they
negotiation in
assault.
the future, my lord,
Hmm.
that too will be done in the presence of counsels itself, my lord.
No, negotiation ಅಲ್ಲಿ ಏನ್ fight ಮಾಡ್ತಿರ್ರಿ? You are saying that in the negotiation you are fighting.
Yes.
My lord, only if there is any interaction for negotiation, we'll speak to them, my lord. Otherwise, there will be no interaction with the.
No, you speak, there is no, we will not restrict for speaking husband and wife. But why do you mention that except negotiation for settlement?
In the mediation set, in the future, my lord.
ಆಯ್ತು mediation ಅಲ್ಲಿ negotiation ಮಾಡ್ಬೇಕಾದ್ರೆ ಮಾತಾಡ್ದೇನೆ negotiation ಹೆಂಗಾಗತ್ರಿ? Why you have add this, mister? Yes, whatever you said in the first 4 lines is correct.
Yes.
Outside the court, except negotiation for a settlement in that mediation center or in the presence of, see, will not threat outside the court or inside court,
Yes, my lord.
except negotiation for a settlement ಅಂದ್ರೆ settlement ಅಲ್ಲಿ I will threat ಅಂತ.
ಅಲ್ಲ threat ಅಲ್ಲ, my lord, interact, my lord.
See, except negotiation for settlement in the mediation center or in presence of the respective counsel. See, however, I hereby undertake that me or my relatives, anyone on my behalf would not threat, assault or interact with the petitioner inside or outside the court, except negotiation for a settlement. Under what is that meaning? File it proper this thing.
My
In
lord,
accept
last
this,
time,
This is permission for you to threat.
No, my
except
lord.
that other than that.
I'll correct it, my lord.
Yes.
last time there was an assault inside the court. Only then it was withdrawn and FI. So my lord, I was,
Will
at
protect the
least
interest of the
mediation, at least one mediation in Bangalore.
She
that's
is
what
not
was-
interested, will not force them. Yes. We have advice, still she don't want that. Yes. When do you want? Next week?
Oh, my lord.
My
Yes.
lord, she is not even interested in joining and living. She should not play a victim card. They should be transferred here because when we filed restitution,
No,
she
see,
transferred.
we are not deciding here
Yes, my lord.
merit of any case. Only thing is inconvenience of the party. It is under
Kindly,
22. I
No,
can't go beyond
because-
that.
Kindly, my lord, because when we
See,
filed
inconvenience,
restitution,
even act says it is for inconvenience of that wife.
yes.
Second thing is that we have also see that interest of the husband and the threat has to be protected.
Yes,
All
ma'am.
that will be protected. We'll pass an order. You file an.
Because restitution, she got it transferred. And now they're telling she's ready to join. So when we file anything, she's only making use of this, my lord.
Yes, yes. You take use of this all submission in
Kindly,
that
my lord, yes.
MC matter, not here. Yes. Next week.
Serial number 10, Hanumanta Reddy, Y, S for petitioner.
For petitioner, my lord. My lord, the petitioner is a woman, a lady with a child of 7 years old, my lord.
Hmm.
And she has to travel all the way from Mysore to Bangalore to attend the MC matter here. And whereas the respondent has filed GNWC at Mysore.
Hmm.
And even the petitioner has filed maintenance at Mysore. 2 cases are pending before Mysore court, my lord.
Hmm.
But this one has been filed here in Bangalore. So on that grounds,
He has filed for what?
MC here.
MC for what?
Divorce, my lord. Dissolution of marriage.
Dissolution of marriage. Yes.
And
now
she has
that, she is residing in Mysore.
Mysore, my lord.
She
And
has
every time she
filed
has to
an-
leave the child alone and she has to come.
She has filed case for maintenance.
Maintenance, yes, my lord. That is pending before Mysore court.
Yes. Heard. Issue notice.
My lord, I may be permitted to serve the notice on the respondent advocate, my lord.
Yes. Serial number ಎಷ್ಟಿದೆ?
Sir, 10.
Yes. Heard. Issue emergent notice. In addition, petitioner is permitted to serve copy on the council appearing for respondent. Very good.
Serial number 11, Sridhara Rao, NG.
Yes.
Serial number 11, Sridhar Rao.
Password.
Serial number 12, Govinda Raya Kamath ke.
For the petitioner, my lord.
Hmm.
Petitioner is the wife. They got married with the respondent in 2007. 2009, there is a girl child born. They were residing in Mysore, my lord.
Yes.
In the year 2021, the respondent abandons her and stays separately. They had obtained a housing loan. By virtue of non-payment of EMIs, the bank people, they take under 13.2 and 13.4, they take the possession. So she is ousted from the house. Now she has, in 2023, she comes back to Bangalore, where her parents are residing, and she is staying here now. During that time in Mysore, my lord, there was a GNWC filed, which the impugned order what I am seeking transfer. Here in Bangalore, soon after she came, she has filed a GNWC before the family court in Bangalore, and there is a stay order granted not to forcibly take the child outside the jurisdiction of the court. And one more 125 petition, like CRPC petition is pending. Now the petition, I am seeking transfer from Mysore to Bangalore, the one filed by the husband, GNWC, my lord.
Now, where is the child residing?
Bangalore.
Bangalore, with
Yes,
that
sir.
mother.
Awesome.
Is it that Mysore is the matrimonial home?
It was the matrimonial home, but they were ousted by virtue of 13.4 proceedings under DRT.
When she has left the matrimonial home?
2023 March.
Now it is.
April, she files a case before family court in Bangalore. After she comes here, she files a case before Bangalore family court, and he obtains an interim order in Bangalore by producing the child before the court. And the child is going to school here, my lord, in Bangalore, Basangudi.
Yes. Out.
IA1 have filed.
Issue notice. Stay of further proceedings in GNWC 63 of 2023, pending in the file of third additional principal judge family court Mysore till next date of it.
Much.
Serial number 13, Sachin BS.
Petition seeking transfer to principal family court Bangalore to Nanjangud, Malaysia. Husband filed a petition seeking restriction of conjugal rights, Malaysia. Husband filed MC number 4500 of 2014, Malaysia, 2024, Malaysia.
Husband has filed for what?
Restriction of conjugal rights, Malaysia.
Restitution of conjugal right. Has she filed any case?
No, Malaysia.
She has not filed. Due to wedlock, any,
One the Mogu ಇದೆ, Malaysia.
what is that age?
4 years, Malaysia.
Girl or boy?
Bye.
Boy. Third, issue notice. Stay of further proceedings in MC number 4500 of 2024, pending on the file of first additional principal judge family court Bangalore till next date of hearing.
Serial number 14, Suresh Kumar HM for petitioner.
The transfer petition filed by the wife from Bangalore to Chikmagalur, Kadur. She has wife is the housewife. She is residing with the parents. He has filed in Bangalore for divorce. She is unable to travel from Kadur to Bangalore in all the way.
What is the distance?
Distance is 250, 258 kilometers.
Yes. Then has she filed any case?
No,
She has not filed any case.
no, my
yet.
lord.
Due to wedlock, any issues?
Yes, my lord.
What is
Male,
that?
male, 3 years,
3 years. It is with the mother.
mother.
Third, issue notice.
Stay the further proceeding.
Yes. Issue emergent notice.
Stay, my
Where is that? You have not sought for interim order, Mr.
lord.
Yes. You have not filed any application. Yes.
Serial number 15, Chandrasekhar.
My lord, date may be given. I'll file the
Huh?
application. I'll date.
File ಮಾಡ್ರಿ.
Date may be given. I'll file. day
You
after-
want that notice or you want adjournment?
No, adjournment. I will file application first time.
Yes, leaves this matter, at the request, leaves this matter next week.
Date.
Serial number 15, Chandrasekhar.
Please, my lord. My lord, petition filed by the wife, my lord. Chanagiri to Bangalore, my family court.
Husband
Husband
Is-
conjugal rights file ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲಿ
ಎಲ್ಲಿ?
ಚನ್ನಗಿರಿಲಿ.
ಚನ್ನಗಿರಿಲಿ
ಹೌದು, ಇವರು 125 ಇಲ್ಲಿ ಹಾಕಿದೆ ಮೇಂಟೆನೆನ್ಸ್
ಎಲ್ಲಿ?
ಬೆಂಗಳೂರು ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್.
In that case, he has appeared.
Please.
Husband is appeared.
ಹೌದು,
What is the distance between?
300 ಕಿಲೋಮೀಟರ್ ಇದೆ. ಆಮೇಲೆ 2 ಮೇಲ್ ಚಿಲ್ಡ್ರನ್ ಇದ್ದಾರೆ. ಒಬ್ಬ UKG, ಒಬ್ಬ ನರ್ಸರಿ ಓದ್ತಾ ಇದ್ದಾರೆ ಇಲ್ಲೇ ಬೆಂಗಳೂರಲ್ಲಿ.
Heard. Issue notice. Stay of further proceedings in MC number 8 of 2024. Pending in the file of Senior Civil Judge JMFC Channagiri till next date of hearing.
Please.
Serial number 16, Rangegowda NR for appellant. Connected matter, O Mahesh.
16.1 ಅಲ್ಲಿ rising out of same accident. Service ಆಗಿದೆ connected 16 ಅಲ್ಲಿ. As per the general order basis, so and so. Second time, neither cover nor acknowledgement is served. Filing recalling application, ಏನ್ರಿ ಇದು? Second matter, what is that recalling application? Non-compliance of office objection. Dismiss ಆಗಿದೆ. ಹೌದು.
ಅಲ್ಲಿಯೇ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೇಳಿದ್ರು, ಆಮೇಲೆ ರೀಕಾಲಿಂಗ್ ಹಾಕೊಂಡಿದ್ವಿ.
Case in filing recalling application is pending. IFR recalling the order so and so.
No interest for that period.
Yes. No, I have not yet recalled my, still I
Hey.
have, yes. Four weeks time is granted for influence office objection filed, which office objection now complied. Comply ಮಾಡಿ. I will verify, my lord. Yes. Pending consideration of IA 1 and 2 of 2021. Petitioner is permitted to comply of subjects. You comply, then we'll read.
Serial number 17, B Vachan for appellant, Mustaq Ahmad.
For the appellant, my lords. But in this case, the instructing counsel has passed away. I have no instructions from the client, my lords. The lordships will have it next week. I shall send a notice to the client and file a memo of retirement, my lords.
Yes, madam.
Respondent to your.
What do you want?
I'm just appearing for this.
Yes. Who is the respondent number 1?
He is the
Yes, or the
claimant.
request. You are appearing for whom, Mr. Owner?
For the employer, my lords.
Employer.
Please, respondent number 1.
But the request of counsel for the appellant. Reach this matter next week.
Serial number 18, Ashok N Patil for appellant. Connected matter, S Maheshwara.
Yes.
Connected matter, advocate.
Connected matter.
ಏನಾಗಿದೆ?
Take notice, my lords, for.
Yes, Maheshwarappa ilva?
ಇಲ್ಲ, my lords, he has expired, my lords, recently.
Then court notice has to go.
But I'll take, my lords, I'll take notice
Yeah.
for him, the company, my lords, in this case.
Respondent number?
For 1 and 2, my lords, notice is, my lords, needs to be furnishing of, my lord, copies. So I'll do the needful, my lords, within 10 days' time. It's a company appeal, my lords, which is filed by S Maheshwarappa.
Yes, yes, yes.
Arising out of the same accident, my lords, there are two
Then you
appeals.
are appearing in the connected matter.
Yes,
You
ma'am,
can
I am
take that.
appearing in connected. matter.
Yes.
Yes, ma'am.
First matter may be disposal of my lord. Sir, in the year 2013 accident was.
Wait,
Please.
first let, yes. Office is directed to delete the name of S Maheshwarappa. Patil is directed to take notice. And directed to show his name for an appellant. What about the respondent?
But I have to take steps,
Yes.
because, my lords, it's
Grace. Weeks time to pay the process, issue notice to. Thus,
a 10
what
days
about
time.
that first matter?
10 days time may be granted.
Yes, 2
But
weeks.
in the first matter, my lords, we have challenged, my lord, the liability
Hmm.
is on the ground that, my lord, the check which was issued
Hmm.
towards premium, my lords, has been bounced.
Hmm.
And, my lords, we have intimated, my lords, prior to the date of accident.
Intimated.
Please, my lord, the owner has also admitted in his cross-examination, my lords, that he is aware of the check bounce. Because he, my lords, he received a message on his mobile phone that, my lord, the check is bounced. But
Yes,
he is
Mr.
aware on two counts.
you?
First responder, claimant, my lord.
Claimant.
Claimant, my lord.
But you go and execute stay ಇದೆಯಾ?
ಈ-
ನಿಮ್ಮ ಮೇಲೆ liability fix
ನಮ್ಮ ಮೇಲೆ ಆಗಿದೆ.
Yes, my lord, they will challenge
Why?
again.
But the, on the ground that the pay and recover, one ನಿಮಿಷ. I'm sorry.
Pay and recovery order ಮಾಡಿದಾರ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
No, ಆಗಿಲ್ಲ.
Absolute liability ಆಗಿದೆ, ಇದೆ ಸ್ವಾಮಿ.
No, why in spite of that there is a this thing?
But what he says, my lord, the tribunal at paragraph, my lords, 16. But it is discussed in elaborate, this, my lords, and, my lords, may I read, my lords, on
Yes, yes. Para 16.
para 16, my lords. It is not in dispute that the respondent number one is the RC owner of the offending Bolero Jeep, luggage Jeep bearing number so and so. The respondent number two has taken contention that if correct policy particulars are furnished and he would, would there be a policy issued by the said respondent, then only liability is strictly in terms of policy and provisions of the motorway. In the absence of policy particulars, this respondent cannot be so and again, except this contention, no other contention in the part of the respondent number one regarding cancellation of insurance policy for dishonor said to be issued by the respondent number one towards premium. The petitioner number two examined his legal manager as RW1. On perusal of his evidence reveals that respondent number one had issued check bearing number so and so for a sum of rupees 13,550 drawn on SBM in favor of respondent number two towards premium. On receipt of the said check, the respondent number two had issued policy cover note subject to realization of the premium paid through check. On presentation of the said check for encashment through its banker, the same was returned as uncashed with bank endorsement for insufficient funds. On receipt of such information, cancelled cover note from its inception. Then the respondent number two informed the respondent number one about dishonoring of the check and subsequent cancellation of cover note policy from its inception. During the course of cross-examination by the learned counsel for the respondent number one, only cover note was issued in respect of offending vehicle but not policy. After dishonor, the check, he was intimated to respondent number one on 31/3/2000.
Plain cash ಅಂತ ಬರ್ದಿದ್ದೀರಂತೆ?
It is only his version. It is only his version. There is no
Now
policy.
that,
which is
have you deposited that amount subject to stay? No, any here stay as file an application for withdrawing that.
ಅಲ್ಲ ಮುಂದೆ ಇದೆ ಸಮಯ ಪ್ರೀಮಿಯಂ ಅಮೌಂಟ್ ಚೆಕ್ ಅಮೌಂಟ್ ದೇರ್ ಇಸ್ ಎ ಡಿಫರೆನ್ಸ್. ಪ್ರೀಮಿಯಂ ಅಮೌಂಟ್ ಇಸ್
Merit ಮೇಲೆ ಆಯ್ತ್ರಿ in the service.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು that was a previous policy.
No, even then
Previous year policy, the amount,
for the
therefore there is a
climate
difference.
is concerned, pay and recovery is there.
ಇಲ್ಲ ಬರೋದಿಲ್ಲ, because we have
Check
intimated
box special
prior
amount
to the
is-
date of accident.
Huh?
Prior to the date of accident, we have informed.
No, that check bounce case ಅಲ್ಲಿ even then if it is check is bounced, pay and recovery ಯಾವ್ದೋ ಇದೆಯಲ್ಲ judgment.
But in case, if it is informed, my lords, later on, my lord, there is a,
No, if later on he informed, there is no in escaping the liability.
ನೋಟಿಸ್ ಸರ್ವಿಸ್
Only you can recover the check amount.
but
ನೋಟಿಸ್
here,
ಸರ್ವಿಸ್ ಆಗಿರೋದಕ್ಕೆ they have not
merit from
produced
the
any
evidence,
documents.
ಆಯ್ತ್ರಿ merit ಮೇಲೆ wait. Yes.
but here,
Either you are not assisting the
the-
court.
the owner also, my
Producing
lords,
the judgment.
kindly
Have
see,
you
my lords,
produced the judgment of? ಏನು judgment ಏನ್ ಹೇಳುತ್ತೆ ಕೊಡಿ. Pay and recovery is there.
ಪ್ಲೀಸ್ ಮೇಲ್
Then we'll permit him to withdraw that. Non-payment of premium due, bonds check, respondent company undertake the third. The owner of premium white check dated which was dishonored and so on so. Respondent company frequently cancelled insurance policy and informed the vehicle to accident taken place on. And the contract issuance substitute recent failure of on principle of law, insurance company is not liable to the extent but report in excess. See, ಇದರಲ್ಲಿ
yes, ma'am.
ಇಂಟಿಮೇಟ್ ಮಾಡಿ ನೀವು ಇನ್ನೊಂದು ಯಾವ್ದೋ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳುತ್ತೆ, ನಾಟ್ ಓನ್ಲಿ ದಟ್ ಯು ಹ್ಯಾವ್ ಟು ಇಂಟಿಮೇಟ್ ದಟ್ RTO ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೆಟ್ ಪೇ ಅಂಡ್ ರಿಕವರಿ.
But here, kindly see, my lords, may I read from the evidence, my lords, what the
No,
Oh, insured is saying minutes about this,
no,
his own.
even if it is admitted that
Yes.
you have intimated everything, we are just seeing about the third party. Third party, let him withdraw that.
And let him make an application minutes, the
Yes.
connected matter,
We
I'll take
file
steps
an
minutes,
app-
so that
application
it could be taken
for
up together
withdrawal.
minutes.
Withdraw that. We'll
Please, ma'am.
consider on that time. There is a judgment. Yes.
So that minutes, there is a division bench judgment minutes recently passed minutes, I'll also place it on
Yes,
record.
now this is Supreme Court. Yes. Yes. Yes, please.
Serial number 19, D. Vijay Kumar for appellant, Pawan Chandra Shetty H.
Yes, for additional documents, non-filing of acknowledgement for having depositing the amount. Yes, Mr. Vijay Kumar, they have deposited that amount. 2 weeks. Yes, you file an execution. There is interim order is subject to condition. There shall be a principal senior would be subject to the deposit of the amount within a period of 4 weeks. If they are not deposited, there is no interim order.
Please.
Executed. Yes. None appears for the appellant. Leave this matter of.
My lord,
2
the
weeks.
LCR already, my lord, secured, so that, my lord, it can be disposed of, my lord.
No, see, the problem is,
Hmm.
in all matters, KSRT is taking a stay. They are not depositing the amount because, because of their financial this thing. They should comply that court order at
Yes,
least.
ma'am. Yes.
Yes.
Boss. My lord, kindly post it for, my lord, admission or hearing on next date, any date, my lord. I will ready to assist the honorable court, my lord.
No, why can't you file an execution?
I
Then
will file to that effect, my
and
lord.
then they will come immediately.
Immediately, please.
Yes.
Serial number 20, Suresh M. Lathur for appellant. BC
Appearing for
Shivan-
the appellant in this case, my lords.
Yes.
Kindly post it for next week, my lords. I need to file an citation in this case, my lords.
ಒಂದ್ ಮೆಮೊ ಹಾಕಕ್ ಹೇಳಕ್ ಹೇಳಿ ಯಾವ.
No, have you filed a memo in the registry not to post that matter?
I have made a filing, madam. I have filed it, my lords.
Then why that office is posting? ಯಾಕ್ರಿ ಅವ್ರದ್ದು ಯಾವ್ದು post ಮಾಡ್ಬೇಡ್ರಿ ಅಂತ ಹೇಳ್ರಿ. ಸುರೇಶ್ ಎಂ ಲಾತೂರ್ ಅವ್ರದ್ದು.
Yes,
Then
sir.
he has not moved that memo also. Why it is posted? ಬೇರೆ ಕೇಸ್ ಯಾವ್ದಾರ post ಮಾಡ್ಬೋದಾ?
Sorry.
Yes. At the request of counsel for the appellant. Is this matter? ನೋಡಿ next matter ಅವ್ರದ್ದೆ. After 4 weeks.
Serial number 21, Suresh M. Lathur for appellant. B.
For appellant in this case, my lords. Pray for time in this case, my lords.
Is this matter of 4 weeks?
Serial number 22, Nagaraj AC
ಒಂದ್
for.
ಕೆಲಸ ಮಾಡಿ. Both heard admit.
Serial number 22, Nagaraj AC for appellant. B. Purandara.
Yes.
Serial number 22, Nagaraj.
RP ಮೂರ್ತಿ ಏನಿದು ಕ್ಲೈಮೇಟ್ ಪಾಸ್ವರ್ಡ್
Serial number 23, BC Shivanegowda.
R1 to R5 are the LRs of the deceased R6.
R6. Quantum. ಯಾರು ಹೋಗ್ತಾರ?
ಮಾಡಿದ್ದಾರಲ್ರಿ
ಮಾಡಿದೀವಿ, ಇದ್ರ ಮತ್ತೆ ಬಂದಿದೆ, ಇದ್ರಲ್ಲಿ ಏನಿಲ್ಲ, ಟು ಕ್ವಾಂಟಮ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ದೇ ಹ್ಯಾವ್ ಡನ್ ಇಟ್.
ಆಗಿದೆ, ಇವ್ರು ಯಾಕೆ?
ಏನ್ರಿ ಆಫೀಸ್? One shall be treated as a legal representative. Deceased R6, the appellant is permitted to carry out the necessary corrections filed in the amendment. ಎಲ್ಲ ಮಾಡಿ permitted to serve a copy of the appeal memo to carry out the necessary to file an amended cast title. I filed it. ಆರ್ಡರ್ ಆಗಿದೆ ಇಂದ ಅದೊಂದು ಹಾಕ್ಬಿಡಿ. Yes. Memo for treating act ಬರಬೇಕು. Filing of amended cast title ಅಂತ ಬರಬೇಕು. Yes, at the request of appellant leaves this matter next week.
Serial number 24, Chetan Desai for appellant. HS Lingaraj.
Appealing for respondent number 2, my lord. TCR may be necessary, my lord. Injury was.
For appellant. TCR ಮಾಡಿ.
ಹೌದಾ? Okay. ಇಂಜುರಿ ಒಂದೇ ಇರೋದು.
Yes, Mr. Chetan.
Yes,
Mr. Lingaraj, ready?
Kindly pass on.
Password. Yes. At the request of appellant, leaves this matter next week. Serial number 25, Chetan Desai for appellant. HS Lingaraj.
Appealing for respondent number 2, my lord. TCR may be necessary, my lord. Injury was.
Password. Yes.
Serial number 25, Chandrasekhar R, KV Nayak, Krishnoji Rao for appellant, SV Agde Mulkund. Serial number 25,
Yes, pass over.
serial number 26, Muralidhar MB for appellant, BC Shivane Gowda.
Number 2. Yes, pass over.
ಇಲ್ಲ ಅವ್ರೇನು ಅವ್ರಿಗೇನು ಡಿ ಎಸ್ ಶ್ರೀಧರ್ ಅಪೇರ್ ಆಗ್ಬೇಕಾದ್ರಲ್ಲಿ ಅವ್ರಿಗೆ
Sridhar ಇದೆಯಲ್ಲ, DS Sridhar.
ಅವ್ರು ಬರ್ಬೇಕು, ಅವ್ರೇನು ಬಂದಿಲ್ಲ.
Yes, heard, admit.
Serial number 27, Kailash Shankar PS for appellant, Ravi Shankar A.
Yes.
ಕೇಸ್ ಆಫ್ ಇಂಜುರಿ ಮೇಲೆ ಫಾರ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್.
Ravi Shankar A.
Yes, Mr. What is?
The date of accident is 4/5/2018 minute. And his age 50 years as on the date of accident.
Is there any dispute regarding that liability?
No, only enhancement.
Yes.
He has sustained fracture of both bones of right leg, middle, spare hand, and other injuries. And he was inpatient for 11 days at Balaji Nursing Home. Doctor assessed lower limb at 43%, whole body at 14%, my lord.
Where is that?
But he is doing business that and he is continuing the business also. He has admitted in cross examination. So tribunal has not taken that aspect.
Medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ.
In other words, 30,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Pain and suffering.
Pain and
He was
suffering.
inpatient for 11 days, 3,300 ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಮೇಲೆ laid up period
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
laid up period only 20,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Sorry,
Pain and
9,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
What are the injuries?
Both one fracture of right leg.
Yes. Medical expenses, loss of income due to the permanent disability. Food and nourishment.
Serial number 4 ಅಲ್ಲಿ ಪರ್ಮನೆಂಟ್ ಡಿಸಬಿಲಿಟಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಬಟ್ ಅದು ಬಂದು ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್.
Yeah. Yes, Mr. Ravi Shankar.
Leave it to my lord. ಎಲ್ಲ ಈ ಕ್ವಾಂಟಮ್
Loss of immunities.
ಅದೇ ಅವರು 20 the total body disability
Because he has not awarded loss of income during the later period.
ಅಲ್ಲ ಮಾಡಿ
ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್
ಇದೆ.
Disabilities.
ಪರ್ಮನೆಂಟ್ ಡಿಸಬಿಲಿಟಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ.
See,
Loss of income due to permanent
due to the-
disability ಅಂತ ತಪ್ಪು ವರ್ಡಿಂಗ್ ಆಗಿದೆ.
ಹೌದು. ಅದು
9,000 ಕೊಡಿ.
ಅಲ್ಲ 20,000. 20,000.
20,000.
See, since he has continued his business, immunities they have to give more. Yes.
In pain and suffering also.
Pain and suffering.
ಮಾಡ್ಬೋದು.
Okay. We'll enhance it.
ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಖಾಲಿ only 20,000 is awarded. That has to be.
How the 20,000 they have assessed? The income.
10,000 per month ಅಂತ assessment. Para number 19.
What is the date of what is your claim?
My claim is income he is earning 50,000 per month.
ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
Tribunal taken only 10,000 ಅಂತ ಇದು ಮಾಡಿದ್ರು.
ಆಯ್ತು.
Notional
Notional
income
income will take that. Yes. So and so learned counsel appearing for. The claimant has contended that due to that accident, claimant has suffered grievous injury. He has examined the doctor. He has assessed whole body disabilities 14%. The claimant has to suffer the disability and unhappiness throughout his life, and he has suffered lot of pain during the treatment. Compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence sought for enhancement of compensation. Per contra, Ravi Shankar learned counsel appearing for insurance company has contended that even though doctor has assessed the disability 14% for whole body, due to that disability, he has not suffered any loss of future earning since he has continued his business. Secondly, he has contended that the evidence of doctor and injury suffered by the claimant and considering that medical records, compensation awarded by the tribunal for pain and suffering, loss of immunities, Other incidental expenses are just and reasonable. The interest awarded by the tribunal, 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 4/5/2018 due to rash and negligent driving of rider of motorcycle bearing registration number KA 51 EV 4747. Due to that accident, claimant has suffered the following injury. He has examined the doctor as PW2. In his evidence, he has deposed that claimant has suffered 43% disability to lower limb and 14% to whole body. He has to suffer this disability and unhappiness throughout his life. And he was inpatient for a period of 11 days. He has suffered a lot of pain during the treatment. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 30,000 to 60,000. Loss of amenities from 10,000 to 75,000. Loss of income for later period has to be granted for 3 months at the rate of 12,500 per month. Enhanced compensation amount carries 6% interest.
He is a impatient for 11 days, but court awarded only 3,300.
ಏನಕ್ಕೆ? Food and nourishment has to be enhanced from 3,000 to 10,000. Yes.
Office objection, first time matter, serial number 28, Deepak DC for petitioner.
My lords,
Yes, Mr.
small office objection is that
In the chronological order in the synopsis,
one mistake.
annexure should be stated in the prayer. Scheduled property to be stated in the writ petition after interim prayer. Age of the petitioner, verifying affidavit doesn't tally with the cost title. You carry what, you will pass it over?
Grateful.
Yes, pass over.
Serial number 29,
Same man.
Same, pass over.
serial number 30, Subramanya PD, Dattatreya Hegde for petitioner.
Here for
Yes,
respondent.
Mahendra.
Yes.
Objection is only, my lord, regarding service of copies on the caveator. It is already been served, my lord.
Caveator.
What is the acknowledgement also? They have appeared in the matter. Copies are served, my lord.
That is the only office objection.
Objection, my lord, according to.
Copy to be served upon the caveator with respect of CP so and so, acknowledgement to be filed. Yes.
Please.
Learned counsel for the petitioner has submitted that. Copy has been served to the caveator. Yes. Submission is taken on record.
Kindly
My lord,
next
the
week,
include order, my lord, attaching annexure V and annexure V1.
Want next week?
Lord, my only difficulties, my lord. They have, my lord, during the pendency of the proceedings before the assistant commissioner, they have converted the part of the land. And during the pendency of the assistant commissioner has allowed the application.
Now, who are you?
I am the grantee, my lord. I am the legal heir of the grantee.
Hmm.
But I applied application for the assistant commissioner.
Hmm.
That was allowed. Then, my lord, it was carried before the deputy commissioner. During pendency of the appeal, my lord, the another portion of the land has been converted. And they
ಆಯ್ತು
are-
ಕನ್ವರ್ಟ್ ಮಾಡಿದ್ರೆ ಏನಂತೆ ನಿಮಗೆ ತಾನೇ
ಅದೇ-
ನಾಳೆ if it is
they,
succeeded.
they may alienate, my lord.
That will restrict not to
That is
create
what-
third party
that-
interest.
Not for create third party interest.
Khata has been made out in the name of the fifth respondent after passing of the order by the deputy commissioner.
ಆಯ್ತು ಖಾತಾ ಮಾಡಿ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿ
Not to alienate, my lord.
you large ಮಾಡಿ
Yes, my lord.
you build in a palace also, no
Yes, ma'am.
objection, but not to create third party interest.
Yes, my lord.
Again, one more person has to be made as a party and all.
And
Yes.
it will defray my interest,
Yes.
delay the process, my lord.
Huh?
That is why, it will delay the process. if
Yes.
Third party interest is created.
Yes, yes, again, it will be that problem. Now, why that DC has been, when is the date of
Sir,
grant?
The deputy commissioner says that, my lord.
What is the date of the grant?
Date of the grant, my lord, year in 1934-35, my lord, Tagoli treaty was issued.
It is sold.
Please, my lord.
When that property has been
Please, my
sold.
lord, as per the chronological event, my lord, the synopsis I have mentioned,
Hmm.
in the year 1956, my lord, the legal heir of the grantee has created a mortgage. Then, my lord, in the
When-
year 1956, my lord, he
When
sold
when the application is filed?
application filed, my lord, in the year 2014, it is numbered. In fact, it is in the 2011 itself, my lord, application was made. It was not numbered, not taken up.
11 ಆದ್ರೂ delay ನೇ.
14 regular number was made, regular number was.
Even assuming 11 is also delay.
Delay, my lord, then that, my lord, new of the subsequent amendment.
That is pending, we'll see that.
And.
Can I make submission, my lord?
And my lord.
Before the assistant commissioner, my lord, they have not produced this Agwali cheat. And also grant certificate also they have not produced. Caste certificate also they have not produced. None of the documents they have not produced.
Document ಇದೆ.
No document has been produced by the assistant commissioner, nor the deputy commissioner.
The annexure B, my lord, annexure C, my lords. The document, it is of the year 1956. Here it is caste is mentioned as Vadda and Bovi. And before the authority, caste certificate was produced. Along with the application, took the caste certificate. He belongs to Bovi community, my lord.
No, all that issues will be arises only after that validity has been considered.
Annexure B, my lord,
See,
the
if
record
that
of rights.
If that validity has been upheld, then that issues will be arises. Otherwise, that only on the limitation we have to decide.
Yes, my lord.
Yes, you take notice. You have the caveat, government advocate is directed to take notice for 1 to 4. Counsel for the petitioner is directed to serve 4 set of copies. Government advocate. The caveat are you are for who, which?
Respond number 5, my lord.
Yes. Caveat are appearing for, caveat are for respondent number 5 undertake to appear for.
6 also there.
It's also there.
6. Caveat has undertake to appear for respondent number 5 and 6. Caveat so and so or resurrected. The respondents are directed not to create third-party interest in respect of property.
Granted land, I mentioned.
Which is that property, Mr.?
The survey number.
132 by 132, my lord.
Property bearing survey number 132 measuring 12 acres, 27 guntas. 12 acres grant madidra.
12 acres, 27 guntas was granted.
Granted.
No document has been produced except annexure B record of rights.
Kotte, Gangan,
Sominikappa village
and village, Kasba Hobali, Shimoga Taluk and district. Kottige Gangur.
Kotte Gangur.
Kotte Gangur. Village, Kasba Hobali, Shimoga Taluk and district. Till next date of hearing. Please.
Instead of granted land, my lord, it has to be modified as disputed land, disputed.
Who said granted land? I have not said granted land.
Yes, my lord.
I said not to create third party interest
Yes,
in
my
respect of this property.
I will file my objection, my lord.
Yes.
Permit us to file objection.
Is there? Nobody is object. Yes.
For orders.
Date may be fixed, my lord.
Let them.
For orders, serial number 31, VB Siddaramaya for petitioner, Prasanna DP.
Respondent. My lord, there is no possibility of a settlement, my lord. ಅವ್ರು ಬರ್ತಾನೆ ಇಲ್ಲ ಅಲ್ಲ last time ಹೋದಾಗ ನಾವು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಈ ಸರಿ ಅವರೇ ಬಂದಿಲ್ಲ ಅಲ್ಲಿ.
Yes, awaiting.
ಇದು ಶಿವಮೊಗ್ಗ ಆಗ್ತದೆ ದೂರ ಆಗುತ್ತೆ ಇದು ಹರಿಹರ ನಿಮಗೆ ಶಿವಮೊಗ್ಗ ಆಗ್ಬಿಡಿ. Lord, we are transfer from Tirthalli to Davangere family court.
Parties to appear.
Middle ಆಗುತ್ತೆ sir.
Davangere mediation center.
Please, madam. ಶಿವಮೊಗ್ಗ.
You, last occasion, you have taken the time that one more opportunity. Now you are changing the stand. Yes. Yes, what is your case, Mr.?
Lord, we are seeking a transfer from Tirthalli to Davangere, my lord, Davangere family court. Lord, respondent has filed a MC before the senior civil judge at JMFC at Tirthalli for restitution of conjugal rights, my lord. And
Now that, what is the case filed by the husband?
for restitution of conjugal rights, my lord. MC 5 of 2024.
Restitution of conjugal right.
Please, my lord.
He has filed in where?
In senior civil judge at JMFC at Tirthalli, my lord.
5 of 2024.
2024, my lord.
Yes.
My lord, petitioner has filed I filed one document, my lord, on 15/4/2024, my lord. My lord, a petitioner has filed a MC 150 of 2024 for
MC
MC 150 of 2024, my lord.
150 of 2024. For what?
For
You don't know. You don't know why you have filed in a case, mister. Yes, mister. 5, 6, 3. Yes, due to that wedlock, any issues?
ಒಂದು ಮಗು ಇದೆ ಮೇಡಮ್.
What is the age?
4 years ಮೇಡಮ್.
She is residing with whom?
Her parents ಮೇಡಮ್.
Mother or?
Her parents. ಅವ್ರ ತಂದೆ ತಾಯಿ ಜೊತೆನೇ ಇದ್ದಾರೆ.
ಯಾರು?
ಪಿಟಿಷನರ್ ಮೇಡಮ್.
No, I am asking that.
ಹಾ ಮೇಡಮ್.
ಅವರಿಬ್ರು ಮದ್ವೆ ಆಗ್ಬಿಟ್ಟು ಒಂದ್ ಮಗು ಆಗಿದೆ, ಮಗು ಯಾರ ಹತ್ರ ಇದೆ ಅಂತ ಕೇಳಿ.
ಅವ್ರ ತಾಯಿ ಹತ್ರ ಇದೆ. ಪಿಟಿಷನರ್ ಜೊತೆ ಇದೆ ಮೇಡಮ್. ಪಿಟಿಷನರ್ ಜೊತೆ ಮೇಡಮ್.
ಅದನ್ನ ಹೇಳಿ ಮತ್ತೆ. ಪಿಟಿಷನರ್ 4 years.
Please ಮೇಡಮ್.
Daughter?
No ಮೇಡಮ್, ಸನ್ ಮೇಡಮ್.
Son. What is the distance between Davangere and Tirthalli?
Approximately 130 kilometers ಮೇಡಮ್. 130 kilometers ಮೇಡಮ್.
Yes, mister.
ದೂರ ಆಗುತ್ತೆ ಮೇಲಾಡ್. ನಮ್ಗೆ 140 ಆಗುತ್ತೆ. ಶಿವಮೊಗ್ಗ ಆದ್ರೆ ನಮ್ಗೆ ಹತ್ರ ಆಗುತ್ತೆ, 60 ಆಗುತ್ತೆ. ಆ ಕಡೆ ಮಿಡ್ಲ್ ಆಗುತ್ತೆ ಸರ್ ನಮ್ಗೆ.
Yes.
ಶಿವಮೊಗ್ಗ ಆದ್ರೆ ಓಕೆ.
Yes, Tali. So and so learned counsel appearing for petitioner wife. Even though matter has been referred to mediation center, since respondent has not appeared on the day fixed for mediation, it appears that they are not interested in settling the property. Hence, matter was heard. Then mediation, it has not been this thing. Learned counsel for petitioner wife contended that after the matrimonial dispute, she is residing with her parents in Haryana, along with her 4-year-old son, 4-year-old minor son. She has filed MC 150 of 2024 for dissolution of marriage before family court Davangere. ಏನಾಗಿದೆ ಆ ಕೇಸು? The respondent husband has filed MC 5 of 2024 for restitution of conjugal right before senior civil judge Tirthalli. From Tirthalli to Shimoga, it's about 130 kilometers. It is inconvenience for the petitioner to go to Tirthalli to prosecute the case and sought for allowing CP. Learned counsel appearing for the respondent submitted that respondent is resident of Tirthalli. He was residing with the parents.
Awesome.
What is he doing? ಏನ್ ಮಾಡ್ತಾ ಇದಾರ್ರಿ ಅವರು?
ತಂದೆ ತಾಯಿ. ತಂದೆ ತಾಯಿ.
ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾ ಇದಾರೆ ನಿಮ್ ಕ್ಲೈಂಟ್?
ಜಿಮ್ ಟ್ರೈನರ್ ಮೇಡಮ್. ಜಿಮ್ ಟ್ರೈನರ್
in Tirthalli. He is doing a private business. It is inconvenience for him to go to Davangere for prosecuting the case. Therefore, sought for dismissal of the petition. Heard the learned counsel for the parties. Peruse civil petition paper. It is not in dispute. Petitioner is the legally wedded wife of respondent. Their marriage was solemnized on ಯಾವಾಗಲೂ ರೀ ಮದುವೆ ಆಗಿದ್ದು ಡೇಟೇ ಹಾಕಿಲ್ಲ. old minor son. She has filed MC 150 of 2024 for dissolution of marriage before Family Court, Davangere. Respondent husband has filed MC number 5 of 2024 for restitution of conjugal right before Senior Civil Judge Tirthalli. From Tirthalli to Shimoga, it's about, from Tirthalli to Davangere, Harihara, it's about 130 kilometers. It is inconvenience for the petitioner to go to Tirthalli along with her 4 years old minor son to prosecute the case. Considering that inconvenience made out by the petitioner and the judgment of this court, civil petition required to be allowed. Accordingly, CP is allowed MC number 5 of 2024 pending in the file of Senior Civil Judge JMFC at Tirthalli is withdrawn. Same is transferred to Family Court at Davangere.
Serial number 32, Abhishek A.
Please, my lords, beg to appear for the petitioner. My lords, the matter was before the learned trial court on 9/9 and it stands posted on 7/11.
Yes.
It is brought to the notice of the other side before the trial court that the transfer petition is pending before my lords. And it may kindly be taken up next week, and liberty may be granted for me to serve a copy on the council for the other side before the learned trial court. So this matter may be taken up next week, my lords.
Awaiting service of notice to respondent. In addition, petitioner is permitted to serve a copy on the council appearing for respondent in trial court.
Serial number 33, yes, Krishna Kishore.
I appear for
Yes,
respondent, my lord. First respondent, one submission is there, my lord, in this case. After satisfying entire award and receipt of the award amount by the claimants, this appeal has been filed. So regarding maintainability, I have my own doubt.
Yes, Mr. What is this?
ಕೇಶವ ಪ್ರಶಾಂತ್ ಅವರಿಂದ ಬ್ರೀಫ್ ಬಂದಿರೋ ಸ್ವಾಮಿ. ಒಂದ್ ವೀಕ್ ಟೈಮ್ ಕೊಡಿ ಸ್ವಾಮಿ. ಆ ತರ ಇದ್ರೆ
No, if you are satisfied that, then are there challenging on the maintainability? No, liability also.
Yes, my lord, challenging the liability, but after satisfying.
death and injury.
But you have paid that amount.
And they have received the amount. Sorry.
ಇದರಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಏನಾಯ್ತು ಅಂದ್ರೆ ಸ್ವಾಮಿ, ಅವ್ರು ತೀರ್ಕೊಂಡ ಮೇಲೆ ಕೇಶವ ಪ್ರಶಾಂತ್
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು, you want to get in.
ಫೈಲ್ಸ್ ಸಮೇತ ಬಂದಿಲ್ಲ. ಒಂದ್ ವಾರ ಟೈಮ್ ಕೊಡಿ ಸ್ವಾಮಿ. ಆ ತರ ಇದ್ರೆ ನಾವು ಚಿತ್ರ ಮಾಡಿ.
Verify that.
ಪ್ಲೀಸ್.
Yes.
ನಿಜ ಸರ್ ಆಗಿದೆಯಾ?
At the request of counsel for the appellant, read this matter next week.
Serial number 34, HR Renuka for appellant.
Yes, madam.
Needful done, my lord.
Alternate counsel for the appellant submits that needful has been done. Office to verify and proceed further.
Serial number 35, Sanat Kumara KM. 35,
Lal Kumar, the branch manager, Indian Insurance Company Limited, served airport. Also, you are a private party. Review law. You are a branch manager and the person. Correct address to R1 for second time. R2 ಏನಾಗಿದೆ ನೋಡ್ರಿ. Unauthorized.
R2 review served.
Served. None appear for the appellant. Week's time is granted to pay the process, issue notice to respondent number 1.
Serial number 36, O Mahesh for appellant.
I appear for the appellant, my lord.
Yes, Master.
The notice issued to R1, the petitioner. Cause shows that the consignment detail not found.
ಏನಾಗಿದೆ?
On website also I checked up, but nothing is forthcoming.
Then what you want? You want to take first step or?
They permitted to take more substituted service.
Yes. Learned counsel for appellant praise 2 weeks time to file necessary application to file a necessary application for substituted service of notice to R1.
Please.
Serial number 37, Prakash MH for appellant, EI Sanmati.
I am for the appellant, Your Lordship.
Yes,
Your
ma'am.
Lordship, I'll file a dispensation memo wherein the liability is joint and several in respect of respondent number 1 and 2.
Dispute. Where is Sanmati? What is that case of death?
Please, Your Lordship.
Any liability dispute, madam?
Your Lordship, there is a contributed negligence on the deceased on par of 25%.
You are ready? Records ಬಂದಿದೆಯಾ? Learned counsel for appellant has filed a memo seeking dispensation of notice to R1 and R2. Well, R2 and R3. Notice is taken on record. Memo is taken on record. Notice to R2 and R3 is dispensed at the risk of the appellant. Office is directed to secure original records from the tribunal.
Serial number 38.
Oblige, Your Lordship.
Gopala Krishna Murthy C for appellant.
Appellants, my lord. Respondent number 2 is United Insurance, but the Shara is said that my lord, the not known. I have paid the process earlier.
United India Insurance Company ಯಾರಿದ್ದೀರಾ? Gowda, you are there? Nagaraja. So and so is undertake to, directed to take notice for respondent number 2. Learned counsel for. Yes. Counsel for the appellant is directed to serve one set of copies on K. Nagaraja. Respondent 2 is directed to deposit award within 2 weeks to. Yes, there is no dispute liability.
No,
You
liability.
want to dispense?
Will file dispensation.
Learned counsel for the appellant has filed a memo seeking dispensation of notice to R1. Notice to R1 is dispensed. Yes, you serve a copy.
Serial number 39, Sharadamba AR for appellant, Ashok N Patil. 39.
Yes. Week's time is granted to do the needful.
Serial number 40, R Shashidhara for appellant, Ravi S Samprati.
Respondent. Can be disposed.
ಮಾಡ್ಬೋದು injuries.
Pass over. Yes, pass over.
Serial number 41, O Mahesh for appellant, B Pradeep.
My lord, I appear for the appellant. My lord, notice was taken to the, my lord, the address available in the cause title and also in the record, my lord, but they say that insufficient address. I may be, R1, my lord, is the claimant.
Yes.
I may be permitted to take, my lord, substituted service on
Learned
R1.
counsel for the appellant prays 2 weeks time to file necessary application for substituted service of notice. ಅದ್ ಕೊಡ್ರಿ R5 ಯಾರು? ನೀವ್ ಯಾರಿಗಿದ್ದೀರಾ?
Bajaj Alliance.
ಇದರಲ್ಲಿ ಬಜಾಜ್ ಪ್ರದೀಪ್.
ಪ್ರದೀಪ್ R4.
R4 ಇದೆ.
ಹೌದು ಬಜಾಜ್.
ICIC. Bajaj also is there. You'll, who is?
ಅವ್ರು ನಾವು ICIC ಇದರಲ್ಲಿ ಅವ್ರು ಬಜಾಜ್.
Three insurance companies are there, my lord.
ಶ್ರೀರಾಮ್ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್.
ನಾನ್ ತಗೋತೀನಿ.
ಪ್ರದೀಪ್ ಇದಕ್ಕೆ ಯಾರಿದ್ದಾರೆ? ಬಜಾಜ್ ಇವ್ರು ನೀವಿದ್ದೀರಾ?
ಬಜಾಜ್ ನಾನಿಲ್ಲ. ಅವ್ರು ಪ್ರದೀಪ್ ಯಾರು ಹಾಕಿರೋದು?
ಅಲ್ಲ, ಪ್ರದೀಪ್ ಅವರು ICICಗೆ.
ಹಂಗಾರೆ ಶ್ರೀರಾಮನ್ ಅನ್ಕೊಂಡು ಅವ್ರು ಶ್ರೀರಾಮ್ ಗೊತ್ತಿಲ್ಲ.
ಅವ್ರು ಶ್ರೀರಾಮುಲು.
ಬಜಾಜ್ಗೆ
ಹೂ ಇಸ್ ದೇರ್ ಫಾರ್ ಬಜಾಜ್?
HS ಲಿಂಗ್ PB ರಾಜು.
PB Raju. Yes. PB Raju is directed to take notice for respondent R5 is served unrepresented. PV Raju is directed to take notice. Yes, at the request of respondent number appellant, 2 weeks time is granted to file necessary.
Please.
Substituted service.
Serial number 42, Ravish Bendy for appellant.
Yes. Furnishing of PF cover recommended. Ravish Bendy. Yes, call this matter along with that sounds.
Serial number 43, Ravi S. Samprati for appellant, Shripad.
Filing memo for dispensation of notice to second respondent.
Yes.
ಇಲ್ಲಿ
ಅವ್ರೇನೋ
Government
ಶಾಸ್ತ್ರಿ
appeal
ಇನ್ನೊಂದಿದೆ ಅಂತ ಹೇಳಿದ್ರು. ಇನ್ನೊಂದು ಯಾವ್ದೋ ಇದೆ ಅಂತ.
5872 of 2019.
Yes, Learned Council for the appellant has filed a memo for seeking dispensation of notice to R1 notice to R1 is dispensed.
R1 ಅಲ್ಲ R2.
R2 ಅವ್ರ ಶಾಸ್ತ್ರಿ ಇದಾರೆ.
ಅಲ್ಲ R1 ಶಾಸ್ತ್ರಿ.
R2 ಅಂತ ತೋರಿಸಿದಾರೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
ಇಲ್ಲ ಕ್ಲೈಮೆಂಟ್ R1.
Sir.
ನಮ್ಮ ಆಫೀಸಲ್ಲಿ R2 ಅಂತ ತೋರಿಸಿದಾರ.
ಇಲ್ಲ R1 ಗವರು.
Seeking dispensation of notice to R2. And accordingly notice to R2 is dispensed. ಅವ್ರ ವಕಾಲತ್ ಏನಾರ R2 ಅಂತ ಹಾಕ್ಯಾರ ನೋಡ್ರಿ ಶಾಸ್ತ್ರಿ ಅವರೇ.
Serial number 44, Rajanna for appellant, Ravi S. Samprati.
Second respondent.
This case I appear for appellant, my lord.
Delay may be condoned. Records ಬೇಕಾಗುತ್ತೆ. Claim petition is dismissed against the insurance company.
ಅಲ್ಲ R1 ಯಾರು?
R1 owner of the vehicle.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಂಗಾರೆ ಅವ್ರಿಗೆ.
Notice ಹೋಗ್ಬೇಕು. Weeks time may can be granted. my
Weeks time is granted to pay the process issue notice to R1.
lord. My
Serial
memo
number
may kindly- Memo may kindly be allowed, my lord.
Memo for what?
That to death of appellant number 3, my lord.
ಏನದು? Death
Number
certificate.
3 is dead,
ಹಾ.
my lord.
Who is R3?
Father of the deceased, my lord.
Petitioner number 3 na, respondent number 3 na?
Appellant,
Appellant.
3, yes. Who is this LRs?
ಬೇರೆ petition.
Yes, 4, my lord. Appellant number 4, my lord.
4 ಏನಾಗ್ಬೇಕು?
Wife, my lord.
1 and 2 ಯಾರು?
Deceased wife and child, my lord.
Deceased wife and child. 3 is the father.
Please, my lord.
Now
Deceased
that
father. 4 is the mother.
4 is that his wife, deceased wife.
Please.
ಮೆಮೊ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀವಿ.
ಏನಂತ ಹಾಕಿದ್ದೀರಿ?
ತೀರೋಗಿದ್ದಾರೆ and
Treat them as
appellant
LRs.
number 4
Petition
is
number 4 may
the
be treated as LR of the
Yes.
appellant number 3.
Learned Council for appellant has filed a memo stating that respondent number 3 is dead. Leaving behind respondent number 4 is the only legal representative. Memo is taken on record. The respondent number 4 is treated as LRs of deceased to respondent number 3. Counsel for the petitioner is permitted to amend the, appellant is permitted to amend the cost.
1 week time may kindly be granted to
ಅದು ಹೇಳಿದೆ 1 week for payment of process.
this.
Serial number 45, Kumara KG for appellant. Keshav Prashant.
ಯಾರು ಇದಾರೆ ಕೊಡಿಯೋದು? Shriram General Insurance Company. Keshav Prashant ಬದಲು you will take notice, Mr. Office is directed to delete the name of HN Keshav Prashant for R2. Show the name of Shivanegoda for respondent number 2 in the cost list. Steps to be taken in respect of Aurigan. Yes.
Serial number 46, PS Kailash Shankar for appellant, K Nagarajaya.
And for the second respondent, only quantum.
Notice to R1 is dispensed. 1 day delay in filing an appeal is condoned. Yes, Mr.
We are challenging 15% contributory negligence and also enhancement quantum.
Then records necessary.
ಹೌದು
Contributory negligence.
ಸೆಕೆಂಡ್
Records ಬಂದಿರ್ಬೇಕು.
Records bandila. Office is directed to secure original records.
Last time.
Post immediately after receipt of the records. PCR received ಅಂತಿದೆಯಲ್ಲ.
Kind submission, even judgment alle clear ಆಗಿ ಬಂದಿದೆ ಅದು. ಅದನ್ನ ನೋಡಿದ್ರೆ ಮಾಡ್ಬೋದು ಸರ್.
ಕ್ವಾಂಟಮ್ ತಗೊಂಡು ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ.
Yes, records ಬಂದಿದೆ next week. Office ಅಲ್ಲಿ. Post. Along with that records next week.
Then I have done 18th.
ಯಾಕೆ?
17, 16 personal inconvenience ಇದೆ ಅದು.
18th ಬರೋದದು.
Serial number 47, Nanjunda Swami and for petitioner.
Matter, my lord. Offer for petitioner, my lord. Idರಲ್ಲಿ I have complied, my lord. I have filed the NOC wakalat, my lord. NOC of
What is
the
this, Mr.
previous council.
Nanjunda
Lord?
Swami.
Tell me,
is this matter?
my lord, this is matter, my lord. The office objection regarding, my lord, a non-filing of wakalat, my lord. We have filed a NOC wakalat now.
You are complied.
I have complained, my lord.
Obtain
NOC
a
wakalat is
form on records council in that. NOC wakalat filed by the council for the petitioner obtain a from on record council. You have obtained that NOC from the earlier council.
Other council, my lord. Who is appearing for MFA, miscellaneous first appeal.
Yes, is there any other objection?
All other objection complied, my lord.
Yes, in response to the.
The only one objection.
Yes. Learned council. Submission of learned council for the appellant has submitted that office objection has been complied. NOC from the earlier council has been filed. Submission is taken on record. Post this matter for admission next week.
Notice, sir, the delay is there. Kindly issue notice to the respondents.
Now, what is this matter, Mr.? Why that?
Madam, my lord, the appellant, my lord, the petitioner filed this appeal MFA, my lord, MFA 845 of 23, my lord, against the order passed on A number 9, which is filed for, my lord, a permanent injunction restraining the respondents herein from interfering with our peaceful possession and enjoyment over the social property, my lord. Admittedly, my lord, we have the petitioner is a resident of, my lord, first floor of premises, which is filed, which is admitted by the respondents in the written statement. In the written statement, they have not denied our residence.
Post this matter next week. IA post madbekala notice. Yes.
There is a delay. Kindly issue notice on IM.
No, IA is not posted today. Therefore, it post next week.
Grateful.
Then we can.
Grateful.
Yes.
Great.
Serial number 48, Varun Jaikumar Patil for petitioner, government advocate.
Awaiting
Lord, I appear for the 10th respondent, Lord.
Yes.
Lord, but what has happened is, Lord, they have filed a repetition, but challenging, Lord, the order which is passed in 2019. Lord, they initiated proceedings under the PTCL Act after lapse of 68 years. In fact, Lord, the recent decision, Lord, of the division bench, Lord, holding that, Lord, the new act will not make any difference. And Lord, the plethora of cases, Lord, they have held that delay on sole ground, Lord, the entire case has to go. In fact, land is also converted. So, Lord, on multiple facets, Lord, the entire matter, Lord, will be dismissed because 68 years delay.
No, petitioner is the grantee.
But he claims to be the grantee. First sale it is 1943, Lord.
What is the date of the grant?
Lord, there are no grant documents available.
No,
according to
even as per the AC DC order, what is the date of the grant?
Please, Lord. According to the order, Lord, the grant, Lord, is of the year 1936-37.
36.
The first sale deed, Lord, is 1511 to 1943.
43. When is that application is filed?
Lord, application, Lord, is filed before the Assistant Commissioner in 2011-12.
There is a delay. Yes, notice
Yes,
is.
Lord, 68 years delay, Lord.
Yes. You are
And
appealing
Lord,
for
land is converted. Therefore, my lord, by virtue of the full bench decision, my lord, on that count also, my lord, the entire matter, my lord, has to go.
Now that you are appearing for whom?
My lord, I appear for the 10th respondent
I appear for respondent number 11.
who purchased the property.
Yes.
My lord, I have in turn, my lord, sold the property in favor of the 11th respondent on 2024.
You are appearing for
Respondent number 11.
11. What about that other respondents? You are appearing for whom, mister?
But other respondents, my lord, will have no say in the matter because, my lord, now it's only 10th and 11th respondent, my lord,
Yes.
who are affected by this order. My lord, lords have granted an order of status quo,
Yes.
which
Now
is
what you
affecting,
want?
my lord, my rights.
Yes. Now
Lord,
what you want, Mr.
I would request, my lord, that the interim order not be continued. On the contrary, the petition itself can be dismissed on that count, my lord, because matter is covered.
No, now that you file an application for vacating, we'll consider and pass an order. On main matter, I can't decide because constitutional validity challenge is pending before the court.
No, my lord, I'll just pass on one judgment, my lord, of the division bench. But
No,
kindly
that
permit
is-
me to just show that judgment. But can I seek for a pass of, my lord, at 2:30, my lord, I'll come physically. Lord, may kindly pass it to, Lord, I'll come at 2:30, Lord, physically.
Yes. We'll have it next week. In the meantime,
Great.
you can file an
Lord,
application also. Yes. To give an
Lord, I have some
notice
urgency
to
in the
other
matter,
side.
Lord, because,
No, you given a notice to other side. Go that.
Lord,
we
may
are
kindly
going-
pass it over, Lord, I'll come at 2:30.
Yes.
Lord, may kindly pass it over, I'll come at 2:30 and make my submissions.
Yes. Pass on.
2:30.
Yes. 2:30.
Grateful.
Hearing interlocutory application matter, serial number 49, Girish B. Baladare for appellant.
Appear for petitioner, my lord. I
Yes.
for paper publication filed by.
Which is that IA? IA 1 of 2024 is filed by that appellant seeking permission of this court to take out notice to respondent to paper publication in Vasadiganta daily newspaper circulated in Hassan district for the reason stated in that accompanying affidavit. IA is allowed. Appellant is permitted to take out notice to which respondent?
Only one respond.
Take out notice to respondent through paper publication, Vasadiganta daily newspaper circulated in Hassan district on or before
14th October,
hearing date.
6th November.
Yes.
Interim order may be extended.
Interim order granted earlier is extended till next date.
Serial number 50, Harish Babu KN for appellant, FS Dabali.
Yes.
Claimant's appeal for an assessment.
Hmm.
It can be disposed of.
Yes.
Only quantum we are questioned.
Yes.
He has sustained fracture of both bones on right leg.
6884.
Please.
Hmm.
6884.
I start from which paragraph, Mr.?
Paragraph number 28, page 22. In para number 29, it has been mentioned that exhibit P14 wound survey which disclosed that the petitioner has sustained.
Start from para 26.
So for petitioner is concerned, the petitioner deposed that he is aged about 23 years at the time of accident. In proof of the same, he has produced his Aadhaar card. On perusal of same, it is date of birth is so and so. So as on the date of accident, he has aged about 23 years. The multiplier is 18.
There is no dispute that.
Regarding, there is no dispute.
What is that now you are claiming?
Pain and suffering for fracture of both bones, they have given only 40,000.
Disability any there?
ಡಿಸಬಿಲಿಟಿ 44.5% ಹೇಳ್ತಾರೆ ಡಾಕ್ಟರ್. ಸೊ ಇಟ್ ಕಮ್ಸ್ ಟು 13.5% ಬರುತ್ತೆ.
ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
12 ತಗೊಂಡಿದ್ದಾರೆ.
ಅದನ್ನ ಕರೆಕ್ಟ್ ತಗೊಂಡಿದ್ದಾರೆ.
ಇನ್ಕಮ್
what is that
8,000 ತಗೊಂಡಿದ್ದಾರೆ. 8,000 ತಗೊಂಡಿದ್ದಾರೆ. 9,500 ತಗೋಬೇಕು.
ನೀವ್ ಎಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಿ?
ನಾವು 15,000 ಕ್ಲೈಮ್.
Year of accident?
Year of accident is 2016.
Yes. How many days you were in that hospital?
He was totally 24 days he was in the hospital. 4, 4, 8, 10, 24 days. On
Yeah.
various time.
What are the injuries, Mr.?
Fracture of both bones. Compound fracture type 3 both bones. Right leg.
Medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ, nourishment, future earning, amenities during the later period.
Later period ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
Future medical.
Amenities ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes, Mr. Dabali.
Amenities ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ. Amenities.
Yes.
23 years old.
Yes, interest will. Yes.
Interest.
So and so, learned counsel appearing for the claimant has contended that due to that accident, claimant has suffered grievous injury. He has examined the doctor as PW3. In his evidence, he has deposed that claimant has suffered 13% permanent disability to whole body. He has to suffer this disability and unhappiness throughout his life. He has suffered lot of pain during the treatment. Compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses is on lawyer side, sought for enhancement of compensation. Per contra, Shri Dabali Learned Counsel appearing for corporation has contended that even though doctor has assessed whole body disability is 13%, tribunal, after considering that evidence of doctor and medical records, has granted just and reasonable compensation for pain and suffering, loss of amenities, other incidental expenses. The interest awarded by the tribunal, 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Perose, judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 12/8/2016 due to rash and negligent driving of driver of KSRTC bus bearing registration number KA 13 F1567. Due to that accident, claimant has suffered the following injury. He has examined the doctor as PW3. In his evidence, he has deposed that claimant has suffered 40.44% disability to particular limb, 13% to whole body. Considering that evidence of doctor and injury suffered by the claimant, tribunal has rightly assessed whole body disability is 12%. Even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Under those circumstances, notional income has to be assessed as per the guidelines. For 2016, 9,500 has to be considered. The multiplier applicable to that age group is 18. Accordingly, loss of future earning has been reassessed as follows.
9,500 into 12 into 18 into 12%, 2,46,240.
Due to that accident, claimant has suffered the above said injury. He was inpatient for a period of 24 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 40,000 to 60,000. Loss of amenities from 15,000 to 40,000. Loss of income during the later period for 3 months. Enhanced compensation amount carries 6% interest.
Delay ಇದೆ.
ಎಷ್ಟು ದಿನ ಇದೆ?
10 ದಿವಸ.
Delay is condoned. Yes.
Serial number 51, FS Dabali for appellant, RV Shivananda Reddy.
Yes, Mr. Dabali, ready? Delay of 44 days is condoned. ಏನ್ ಲಯಬಿಲಿಟಿ ಏನಾರ ಕ್ವಶನ್ ಮಾಡಿದಿರಾ?
Yeah, question about negligence, but
Huh?
there is no case about negligence. Was a
Negligence.
pedestrian. Right?
Negligence ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಾ?
ಮಾಡಿದ್ದೇವೆ, but he was a pedestrian murder, accident took place murder.
2016. BTM BN to belongs to respond driver rash and negligent murder Dodballapura dash technician who was walking on his left side of the road. Fell down. Response to the notice, respondent council filed in a claim petition. So on.
Accident took place at about 8:50 PM.
Huh?
During the night time murder, when it was raining. He was a pedestrian murder, but.
Advocate for
Find
the contended that FIR and the complaint indulging charge sheets of the claim petition. Point said, carefully scrutinize the document. Was that immediately after the accident, petitioner shifted to the hospital. He was one day delay in complaint lodging.
The 2 days delay,
Was not possible for him to lodge the complaint immediately. Accident now very.
but FIR charge it has been filed murder.
One of the passenger in the bus itself has eyewitness.
Charged complaint. After 2 days,
He himself is the eyewitness.
eyewitness.
Yes, what about that?
Quantum not-
Quantum ಏನು ಇಲ್ಲ.
Here not the doctor not who has not treated the claimant not has assessed the disability of 18% to the whole body and 36% to the particular limb. He has sustained a fracture of both bones of right leg, tibia and fibula. But the doctor here the trouble has taken 18% blood instead of 12% blood. That is only murder.
ಅಷ್ಟೇ.
He is
ನಿಮ್ದೇನ್
not
ಅಪೀಲ್ ಇಲ್ಲ. ಇಂಟ್ರೆಸ್ಟ್ ಏನಾರ ಇದೆಯಾ?
interest ಇಲ್ಲ 6%.
ಆಯ್ತು ತಗೊಳ್ಳಿ.
Only disability not 12% has to be.
I will take your contention.
About
See,
it-
Dabali Learned Council appearing for.
Income is taken and for it.
Huh?
Income is taken and for it.
But you have you have not filed an appeal. No, we can't increase what is granted by the tribunal. ಅವ್ರದ್ದೇನಾರು reduce ಆದ್ರೆ ನಿಮ್ದು calculation ಮಾಡಿ we can come to that whatever granted, but can't beyond that without your appeal.
But disability not the doctor who has not treated not has stated.
I will consider that you, according to you, 4% is more.
12% would have been taken murder.
I will
Of
consider.
18%, 6% ಜಾಸ್ತಿ.
Yes.
ಅವ್ರು 8,000 ತಗೊಂಡಿದ್ದಾರೆ income ಅದು, ಅವ್ರು 4%.
Income ಜಾಸ್ತಿ ತಗೊಂಡು ಅದರ್ ಹೆಡ್ ಅಲ್ಲಿ ಕೊಟ್ರೆ it will same, mister.
ಅಲ್ಲ ಅದು ಕಡಿಮೆ ಆಗುತ್ತೆ.
Huh?
2,46,000 ಬರುತ್ತೆ.
2 lakhs.
2,46,240 ಬರುತ್ತೆ. 9,500 12% ತಗೊಂಡ್ರು. Loss of future income 2,46,240 ಮಾಡಿ it comes. ಅದು 3,11,040 ಕೊಟ್ಟಿದ್ದಾರೆ.
2,46,000.
46,240
Amenities ಗೆ ಒಂದ್ 25,000 ಮತ್ತೆ
ಕೊಟ್ಟಿದ್ದಾರೆ.
ನರಿಶ್ಮೆಂಟ್ ಅದಕ್ಕೆ ಮಾಡಿದ್ರೆ it will comes to that 3 lakhs again. 11,000 ಡಿಫರೆನ್ಸ್ ಬರುತ್ತೆ ಅಷ್ಟೇ. Yes. So and so Learned Council appearing for corporation has contended that It has taken 2 days. There is a delay of lodging the complaint. There 2 days delay in lodging the complaint. ಅಲ್ಲ ಈ ತರ contended that the accident is occur due to the negligence of claimant himself. The tribunal has error in held that driver of the bus alone is negligent in causing that accident. He further contended that there is a delay of 2 days in lodging the complaint. They, afterthought, they have filed a complaint against the driver of the bus. Tribunal has failed to consider spot case sketch and spot major. IME report ilva?
IME report.
Without considering that above documents only on FIR complaint and charge sheet has held that driver of the offending vehicle is driver of the bus is negligent in causing that accident. In respect of quantum, he has contended that injuries suffered by the claimants are minor in nature. PW3 doctor is not a treated doctor. The whole body disabilities assessed by the doctor 18% is on higher side.
36% to the limb and 18%.
Since particular limb disability assessed is 36%. Even if it is 1/3 is calculated, it should be 12%. He further contended that considering that injury suffered by the claimant and medical records, the overall compensation awarded by the tribunal is on higher side. Sought for dismissal. Learned counsel appearing for the claimant has contended that there is a delay of 2 days in filing in a complaint. The claimant has explained that reason for delay. Immediately, due to that accident, claimant has suffered a grievous injury. He was not in the position to lodge a complaint. The family members are busy in
injury.
Huh?
Injury case. Case of injury.
ಅವ್ರಿಗೆ ಆಗ್ಲಿಲ್ಲ. Family member, they are busy to give a treatment to him. Therefore, anybody can give a complaint. They are busy in shifting that since the claimant has suffered a grievous injury, the family members are attending that petitioner claimant. Therefore, they can't lodge the complaint immediately. Further contended that the complainant Muniraju himself is the eyewitness to the accident who has a passenger in that bus. The tribunal, after considering that documents produced by the parties, has rightly held that driver of the bus is negligent in causing. He further contended that considering that injury suffered by the claimant and medical records, evidence of doctor, overall compensation awarded by the tribunal is on lower side. Heard the learned counsel for the parties. Feroz. It is the case that on 11/8/2016, at about 8:50 PM, the claimant was walking on his left side of the road near Avalahalli Lake, Yelanka Hobli. At the time, driver of BMTC bus bearing registration number KA57F0567 came in rash and negligent manner, dashed to the claimant. Due to impact, he fell down, suffered an injury. Immediately after that accident, the petitioner was shifted to hospital at Bangalore. Then he was shifted to SDM hospital at Dharwad. The exhibit P11 is the discharge summary of the Sagar Hospital. It was written that patient's attendant wants to shift him to that another hospital at Hubli due to financial difficulties and other reasons. Therefore, it goes to show that on the day of the accident and the next day, the family members of the claimant was busy in shifting him from Bangalore to Dharwad. Therefore, there is a delay in lodging the complaint in 2 days. On the basis of that complaint, the tribunal, on the basis of the complaint, the police has filed an FIR against the driver of the bus, and after detailed inquiry filed in a charge sheet. The tribunal, after considering that FIR, complaint, spot major, spot sketch, charge sheet, has rightly held that driver of the bus alone is negligent in causing that accident. In respect of quantum is concerned, due to that accident, claimant has suffered the following injury. He has examined the doctor as PW3. In his evidence, he has deposed that claimant has suffered 36% disability to lower limb, 18% to whole body. Considering that evidence of doctor and medical records, the overall compensation awarded by the tribunal is just and reasonable. There is no error in judgment and award passed by the tribunal. Accordingly, the appeal is dismissed. Amount in deposit is transferred to the tribunal. Delay is controlled.
Cell number 52, 53 adjourned. Cell number 54, K. Prasanna Shetty for appellant, Ravish Penny, Ravi Samprati.
Preparing for the appellant, my lords.
10,000 rupees ಕೊಟ್ಟಿದ್ದಾರೆ. Additional 40,000 rupees may be granted.
ಯಾಕೆ ಏನು minor injuries?
Simple injuries.
Doctor evidence ಏನು ಮಾಡಿಲ್ಲ. They have examined
ಯಾವುದು MUC?
721 of 6.
the page number 16 of the judgment.
721 of 2016. Learned counsel for
Page number 16 ನಲ್ಲಿ injury ಹೇಳ್ತಾರೆ. Dento alveolar fracture of mandible ಅಂತ 4,223 bills ಕೊಟ್ಟಿದ್ದಾರೆ. Total 10,000 ಕೊಡ್ತಾರೆ. Maybe enhanced by another 40,000 rupees and to be shared by respondent number 2 and 4 equal.
$720
721, my lord.
721.
Page number 16 of judgment, my lords.
Yes. So and so learned counsel appearing for claimant has contended that due to that accident, claimant has suffered grievous injury. He has spent 4,223 towards medical expenses. The overall compensation awarded by the tribunal, 10,220 is on lower side. hence sought for enhancement of compensation. Shri Ravi Learned Counsel appearing for insurance company has contended that.
Second,
Ibro,
now second respondent, you
Bini Learned Counsels appearing for the insurance companies has contended that the injuries suffered by the claimants are minor in nature. He has spent only 4,223 towards medical expenses. Considering that same, the overall compensation awarded by the tribunal 10,220 is just and reasonable. Sought for dismissal of the appeal. Heard the Learned Counsel for the parties. Feroz, judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 28/6/2015 due to rash and negligent driving of driver of car bearing registration number 20N7255 and bus bearing registration number KA20A7723. Due to that accident, claimant has suffered the following injury. He has spent 4,223 towards medical expenses. Considering that injury suffered by the claimant, I am of the opinion that the overall compensation awarded by the tribunal has to be enhanced to 50,000. 50,000 with interest. Delay is condoned.
Serial number 55, M. Venkatesh for appellant, connected matter, Narendra Gowda.
I'm for appellant, my lord. We have filed an application for substitute service, my lord. Andhra Prabha, daily newspaper.
IA 1 of 2024 is filed by that appellant, seeking permission to take out notice to the respondent number 3 by way of substituted service in newspaper. Which is that newspaper, madam?
Andhra Prabha.
Andhra Prabha, daily newspaper published in Anantapura, sir. For the reason stated in that accompanying affidavit, IA 1 of 2024 is allowed. Appellant is permitted to take out notice to respondent number 3 by way of paper publication in Andhra Prabha, daily newspaper published in Anantapura on or before
14th October,
hearing date
6th November.
Yes.
Serial number 56, Somashekara came for appellant, Mrs. Shivanya Gowda.
I pay for this. The correction of judgment regarding the liability is concerned, my lord, on that day we have not made submission. Therefore, the
Yes.
Quantum of compensation conclusion is correct, my lord. Only thing is, my lord, the vehicle, auto rickshaw, which was not having a permit to play on the road.
Now that what is the tribunal finding?
Owner liability ಮಾಡಿದ್ದಾರೆ violation ಅಂತ. Of that.
Now we have to do
pain recovery act.
Yes.
ಒಂದು 2 ಪ್ಯಾರಾದಲ್ಲಿ ಆಗ್ಬೇಕು. ಮೊದಲು contention ಮತ್ತು ಇಲ್ಲಿ ಪ್ಯಾರಾ ಫೈನಲಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಡೈರೆಕ್ಟ್ ಡೆಪಾಸಿಟ್ ಅಲ್ಲ, ಅದು ಓನರ್ ಅಷ್ಟು ಡೆಪಾಸಿಟ್ ಅಂತ ಬರ್ತದೆ.
ಅಲ್ಲ ಇಲ್ಲಿ since in respect of claim of the third parties is concerned, insurance company is directed to deposit, liberty to recover ಮಾಡಿದ್ರೆ ಆಗ ಈ ತರ ಮಾಡ್ಬೋದು.
ಮಧ್ಯದಲ್ಲಿ ಪ್ಯಾರಾ ಇದರಲ್ಲಿ 5 ಲಾಸ್ಟ್ ಪ್ಯಾರಾ 5 ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಅಲಾಂಗ್ ವಿತ್ 6% ಇಂಟ್ರೆಸ್ಟ್ ಡೈರೆಕ್ಟೆಡ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೈರೆಕ್ಟೆಡ್ ಟು ಓನರ್ ಆಫ್ ದಿ ವೆಹಿಕಲ್.
ಅಲ್ಲ ಅದರಲ್ಲಿ
ಅದ್ ಮಾಡಿ
ಪ್ಯಾರಾ ಡಿ ಇದೆಯಲ್ಲ, ನಮ್ದು ಇದ್ರಲ್ಲಿ ಪ್ಯಾರಾ ಡಿ ಅಲ್ಲಿ in respect of third party is concerned, the insurance company, since insurance company is directed to deposit the compensation amount along with that 6% interest. Date of filing till date of within 6 weeks with liberty to recover from that. ಅಷ್ಟು ಮಾಡಿದ್ರೆ
Owner of the vehicle.
ಒಳಗಡೆದೇನು it's not because tribunal has already, yes, heard the learned counsel for parties on IA. Learned counsel appearing for insurance company has submitted that. Since insured has violated the policy condition, the tribunal has passed on the liability on owner of the vehicle and exonerated that insurance company. Therefore, he sought for modification of the order with a liberty to insurance company to recover from owner of the offending vehicle. In view of the above, IA is allowed in order dated 7th August 2024 in order portion para D, since claimants are third party, has to be added. And the end of the para, the liberty is reserved to the insurance company to recover from owner of the offending vehicle. Yes.
Serial number 57, Chandrasekhar R for appellant, D Vijay Kumar.
I appear for appellant counsel, my lord. And 90 days delay in filing the appeal, my lord.
Yes, delay is condoned.
But in this case, my lord, death
On filing of objection to IA 1 of 20, ಅದು recalling ಇದಕ್ಕ
delay.
delay in filing.
Yes.
ಏನು dispute ಏನಿದೆಯಾ?
Dispute ಏನಿಲ್ಲ, only quantum, my lord, death case. Income and conventional aids, my lord.
Yes.
2017 accident.
Vijay Kumar. Yes.
My lord, 2017 accident, my lord. Death of husband. Claimants are wife.
ಅವ್ರದ್ದೇನಾರು appeal ಇದೆಯಾ?
ಇಲ್ಲ sir.
Yes.
Claimants are wife, minor daughters and mother. Tribunal is income is taken, my lord, only 8,000.
ನೀವೆಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಿ?
Claim, my lord, 17,000 per month.
2017 ಗೆ ಎಷ್ಟಿದೆ?
11,000, my lord.
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಕೊಟ್ಟಿದಾರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ, 25% ತಗೊಂಡಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದಾರಾ?
ಹೌದು.
ವಾಟ್ ಇಸ್ ಹಿಸ್ ಏಜ್?
ಏಜ್, my lord, 42 years, my lord.
ಇದೆಷ್ಟು?
Multiplier.
ಡಿಡಕ್ಷನ್ ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ?
Deduction 1/4, my lord. Wife to minor daughters and mother.
1/4 ಮಾಡಿದ್ದಾರೆ.
Yes, ma'am.
That is correct. Yes. Multiplier
14, my lord.
14. ಅಷ್ಟೇ ಮಾಡ್ತೀರಾ?
ಆಮೇಲೆ ಕನ್ವೆನ್ಷನಲ್ ಏಡ್ಸ್ ಅಲ್ಲಿ
2017 8,000, 17,000 ಕ್ಲೈಮ್, 11,000. ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಮಲ್ಟಿಪ್ಲೇಯರ್ ಅದೆಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ. Then who are the claimants?
Claimants, my lord, wife, minor daughters and mother.
Wife 40,000,
Minor
40, mother 40. All are entitled 40.
Please.
Interest ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
6% ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes. Disposed of. Please. Delay is condoned.
Please.
Serial number 58, Mohammed Sharif for appellant, Manjula and Tejasvi.
Appearing for the second respondent in this case, Your Lordship.
Yes.
It's a case for enhancement of the compensation, my lord.
Your Lordship, their appeal was dismissed for non-prosecution on
Why?
8/1. For not taking steps, you failed to take notice and steps to the respond number 1.
Underwent several adjournment needful when there was no representation appellant that directed to be listed today under the caption dismissed. Today also there is no representation on behalf of the appellant. The appellant is not interested in prosecuting the matter. Yes,
My lords,
madam, why it
filed
is
and-
dismissed?
It was dismissed for
Office objection has to be
non-prosecution.
complained.
It was dismissed, my lords, for a non-appearance.
Non-appearance, non-appearance, madam, it is dismissed.
Non-prosecution.
Other non-prosecution is for,
Yes.
on
Not
that day
taking
she was
steps.
not present.
Yes.
Not
Yes,
for
Your Lordship.
complaints of office objection.
Not.
Yes, 156 days delay in filing that recalling application. Yes, will allow that application by denying that interest. Yes, madam.
Yes, your lordship. Yes, your lordship.
Yes.
But to dispose of the matter, I need a 2 weeks time, your lordship, as I do not have the consent case papers of the entire file here.
Yes, yes. IA 1 of 2024 is filed for condonation of delay of 156 days in filing a recalling application. Peruse that affidavit for the reason stated in that accompanying affidavit. Delay of 156 days in filing recalling application is condoned. IA 1 of 2024 is allowed. Consequently, 2 of 2024 is allowed. Order dated 8/12/2023 is recalled subject to condition. In case appellant is succeed, he is not entitled for the interest for enhanced compensation amount for a period of 156 days. Yes.
ಕಾಪಿನೂ ನಾನು ಕೊಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ಹಾಗಾಗಿ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ನಂಗೆ ಅಂತ ಅವ್ರು ಮಾಡಿದ್ದಷ್ಟೇ.
You want copy?
ಅಲ್ಲ, ಈಗ ಪರವಾಗಿಲ್ಲ, ಆಗೋಯ್ತು.
TCR may kindly be called for.
Yes, office is directed to secure original records.
Obliged, ma'am.
Serial number 59, Naveen JN for petitioner, Madhukar Deshpande.
I filed the 3 applications.
Yes, Venkata Narayana.
Yes.
The respondent number 11.
LRs of R11 is served, represented by the council, and they have not filed any objection. For the reason stated in that accompanying affidavit, delay of so and so date in filing LR application is condoned. And IA 2 of 20 abatement is set aside. 4 of 2023 is allowed. LRs of deceased respondent number 11 is permitted to come on record. Learned counsel for the petitioner is permitted to amend the cost title.
Interim order.
Yes, interim order granted earlier, extended till next date of hearing.
Serial number 60, PV Chandrasekhar for petitioner, connected matter, PN Rajeshwara.
In the connected matter.
For the petitioner. Giant objections ready blood accelerate and file it.
Should we pass over your lordship?
ಇವ್ರು ಲಾಸ್ಟ್ ಅಲ್ಲ, ನಂದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅವರು 6 and 7 ಗೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಚಿದಾನಂದ ಅವರು ಅಪೇರ್ ಆಗ್ತಾರೆ. ನನ್ನ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಆಗ್ಬೇಕು ನನ್ನ ಕೇಸಲ್ಲಿ 60.1 ಅಲ್ಲಿ 6 and 7 ಗೆ ದ ಸೇಮ್ ಪಾರ್ಟೀಸ್ ಮೈ ಲಾರ್ಡ್ ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
Finally, your lordship, because I am in possession, there is an interim order granted by this honorable court. That's the reason. Madam,
ಅಲ್ಲ, ಕಾಪಿ ಅವ್ರು ನನಗೆ ನೋಟಿಸ್ ಆಗ್ಬೇಕು ಅವ್ರಿಗೆ. ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಹತ್ರ ಹಾಗೆ ಮಾಡಿದ್ದಾರೆ, ನಮ್ಮನ್ನು ಪಾರ್ಟಿ ಬಿಟ್ಬಿಟ್ಟು.
ನಿಮ್ದು ನೋಟಿಸ್ ತಗೊಂಡು ನಿಮ್ ಕೇಸಿಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ಗೂ ರೆಡಿ ಇದೀನಿ ಅಂತ ಅವ್ರು ಹೇಳ್ಬೇಕಾದ್ರೆ ವೈಆರ್
ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ
ಅಲ್ಲ he saying that they have to take notice, they are ready to take notice today and ready to argue.
My lord, kindly have it tomorrow. If my lords wanted to kindly have it tomorrow, my lord, serve the copy. That's why next week, my lord.
Yes. ಕೊಡಿ ಎರಡನೇ ಮ್ಯಾಟರ್. ಯಾರಿಗೆ ನೋಟಿಸ್ ಅವ್ರು ತಗೊಳ್ಬೇಕು?
6 and 7, my lord.
6 and 7 it is served.
Served, but in the connected matter they have appeared for the
that is for them to say, why do you worry, mister? It is served.
I'm sorry, my lord. If that is so.
If parties don't want to appear and ask that council to appear, why do you want to? Yes.
Please, my lord.
Yes.
Well, in this case,
yes, records has come, mister.
Secured, my lord.
Ready?
File ಮಾಡ್ತೇನೆ ಅವ್ರು.
Ready, madam?
it will be passed over your lordships.
Pass over.
Sure, ಬೇಡ.
Tomorrow.
Contempt se complaint.
Day after tomorrow.
Yes, your lordship.
Yes.
day after 13.
Day after tomorrow.
My lord, 18th.
Lord Mary.
18th.
No, that we are hearing his case only for application for vacating. In nim case ಅಲ್ಲಿ ಏನ್ ಹಾಕಿಲ್ಲ.
ಕೇಸಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
ನಮ್ಮನ್ನ ಪಾರ್ಟಿನೇ
There are parties to the absent commissioner without making them part.
ನಮ್ಮನ್ ಪಾರ್ಟಿ ಮಾಡಿದಿರಾ
When we will see at the time of hearing that application.
17th, your lordships.
17th.
17th
Yeah, 18th, not 17th, your lordships.
19th ಹಾಕೊಳ್ಳೇಗ.
The 18, 19 is, last time also my learned friend, it was told
Ayo,
finally, they are
well,
filing.
17th,
Don't give
yes, sir.
copy.
Yes, 17th.
ಇಂಟ್ರಿ ಮಾಡಬೇಕು ಕೈಲಿ ಬೇಕು.
Leave this matter on 17th. Interim order granted earlier is extended till next date of hearing. ಅದು ಯಾವತ್ತು ಹಾಕಿರೋದು? 18th. Yes, 17th.
Here ಆಗ್ಬೇಕಲ್ಲ.
Finally.
Final hearing matter, serial number 61, O Mahesh for appellant, Bhadravadi Siddeshwar.
I appear for respondent number 1 in this case.
Yes, Mr. Mahesh. Password.
Kindly.
Serial number 62, Parameshwaraya DC for appellant, Subramanya R.
Appear for appellant.
Yes.
Matter pertain to Millard. Case of death Millard. The appellants are the father and mother Millard.
Again, liability dispute ಇದೆಯಾ?
ಇಲ್ಲ.
It is an estate policy.
ಇದರಲ್ಲಿ
Estate policy declared wages ಏನ್ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ. ಬಟ್ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಅಂತ ನಾವು 1,29,263 ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ. ಬ್ಯಾಲೆನ್ಸ್ ಅಮೌಂಟ್ 42,560 ಡಿಪಾಸಿಟ್ ಮಾಡಬೇಕು ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಅದು ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಬಂದಿದ್ರೆ ಪ್ಲಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಪೋರ್ಷನ್ ನಾನು ಲಾಸ್ ಆಫ್ ಎಸ್ಟೇಟ್ ಪಾಲಿಸಿ ನಾನು ಕೊಡಕ್ ಬರೋದಿಲ್ಲ. ಅವ್ರ ವೇಜಸ್ ಏನ್ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅದ್ರ ಪ್ರಕಾರ ಕೊಟ್ಟಿದ್ದೀನಿ. ಓನ್ಲಿ 42,000 ಬ್ಯಾಲೆನ್ಸ್ ಇದೆ.
What is that? Let us see. Now there is no dispute regarding liability, only quantum.
Please,
yes.
regarding salary is concerned, my lord, the tribunal has considered, my lord.
What is the date of the accident?
Accident, my lord,
14/6/2006.
No, please. 14/6/2006, my lord. The tribunal, my lord, considered the average salary of rupees 1,517, my lord.
ನಿಮ್ದು ಎಷ್ಟು ಸ್ಯಾಲರಿ ಅಂತ ಹೇಳಿದ್ರು?
As per the, my lord, they have produced, my lord, I have disputed that document, my lord. Because of, my lord.
No, you have claimed what is that salary?
4,500.
4,500 you have claimed.
Please.
What is that salary considered by the tribunal?
Tribunal, my lord, 1,517. Sorry, please, my lord, 1,517.
Monthly wages of the deceased was 1,517.
Please.
Why?
Average, my lord, they have produced the salary slip, my lord. The tribunal taken the average, my lord. That was wrong, my lord.
What is that salary certificate they have produced? Records for it?
R1, my lord. ಅದ್ರಲ್ಲಾದ್ರೂ ಅವರು ಲಾಸ್ಟ್ ಮಂತ್ ಇಂದ ತಗೊಂಡಿಲ್ಲ, ಅವರೇಜ್ ತಗೊಂಡ್ ಮಾಡಿದಾರೆ. ದಟ್ ವಾಸ್ ರಾಂಗ್. ಅಂಡ್ ದೆನ್ my lord, as on that time minimum wage, my lord, R1.
No, what is your case? You are working where?
In the first respondent company, my lord.
Company.
Please.
Not a company, it is an estate, coffee estate, my lord.
This is to certify let so and so.
Copy Turing Works company.
That so and so. ಇದೇನಿದು ಏಪ್ರಿಲ್ ಅಲ್ಲಿ 732, ಮೇ ಅಲ್ಲಿ 2,325, ಜೂನ್ ಅಲ್ಲಿ
ಆ ತರ ಇದನ್ನ ಮಾಡಿದಾರೆ ಅವರು. We are disputed that document.
mention ಅಲ್ಲಿ thereunder during the service of the firm general work. ಅವ್ರ ಕೆಲಸಕ್ಕೆ ಹೋಗಿದ್ದ ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರ ವೇಜಸ್ ಅಲ್ಲಿ ನಮ್ಮ ಹತ್ರ ಪಾಲಿಸಿ ಅವ್ರಿಗೆ ಪ್ರೀಮಿಯಂ ಕಟ್ಟಿರ್ತಾರ ಸ್ವಾಮಿ, ಅದ್ರ ಪ್ರಕಾರ ನಾವು ಕೊಟ್ಟಿದೀವಿ, ನಾವು ಡಿಪಾಸಿಟ್ ಮಾಡ್ಬಿಟ್ಟಿದೀವಿ.
But what is that and 2006 for the minimum wages under the tax? 4,000 ಬರುತ್ತೆ. 4,000 has to take minimum. Yes. 2016 ಎಷ್ಟು ಇತ್ತು ಕೊಡಿ. 8,000 ಮಾಡಿದ್ದೆ ಯಾವಾಗ? 10 ಅಲ್ಲ?
10 ಅಲ್ಲಿ.
Then 4,000. Then what else? ಅದೊಂದೇನಾ?
Only one.
ಅದೊಂದೇ ಗೊಂಡ್ರು. Yes, ತಗೊಳ್ಳಿ.
ನನ್ನ ಲೈಬಿಲಿಟಿ ಏನಿದೆಯೋ ನಾನು ಡಿಪಾಸಿಟ್ ಮಾಡಿದೀವಿ. ನನ್ನ ಲೈಬಿಲಿಟಿ ಬಂದ್ಬಿಟ್ಟು ಟೋಟಲ್ 1,29,263 ನಾನು ಡಿಪಾಸಿಟ್ ಮಾಡಿದೀನಿ ಸರ್.
ಯಾಕೆ ಲಿಮಿಟೆಡ್ ಲೈಬಿಲಿಟಿ ಇದೆಯಾ?
ಹೌದು ಸರ್. ಎಸ್ಟೇಟ್ ಪಾಲಿಸಿಯಲ್ಲಿ ಅವ್ರು ವೇಜಸ್ ಡಿಕ್ಲೇರ್ ಮಾಡಿದ್ರೆ ಅದ್ರ ಮೇಲೆ ಪ್ರೀಮಿಯಂ ತಗೊಳ್ತೀವಿ. ನನ್ನ ಲೈಬಿಲಿಟಿ ಓನ್ಲಿ 1,71,822 rupees ನನ್ನ ಲೈಬಿಲಿಟಿ.
ಟ್ರಿಬ್ಯುನಲ್ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಅಮೌಂಟ್ ಕಟ್ಟಿದ್ದೀನಿ.
ಇಲ್ಲ kindly see the order portion of the tribunal, my lord. All responsibility shifted to insurance company only.
Petitioners are equally entitled to compensation of 42,000 with interest. 42,000 ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದ?
ಹೌದು sir.
Why?
ಅಲ್ಲ ಆಲ್ರೆಡಿ ಡಿಪಾಸಿಟ್ ಮಾಡಿದಿಲ್ಲ
ಅವರು
1,29,623 ಡಿಪಾಸಿಟ್
29,623 ಡೆಪಾಸಿಟ್ ಮಾಡಿರ್ತಾರೆ
ಹಾ.
But next para, my lord, kindly see the respondent number 2 is liable to pay the said compensation amount and he is directed to deposit compensation in this tribunal within 30 days. R2 under insurance company.
ಹೌದು, ನಾನು ಡಿಕ್ಲೇರ್ ಅಮೌಂಟ್ ಬ್ಯಾಲೆನ್ಸ್ ಅಮೌಂಟ್ ಕೊಡಿ ಅಂತ
Insurance
ಮಾಡಿದ್ದಾರೆ.
company which shows that as on the date of the accident, the employee of the respondent number 1 are covered under that policy. R1 deposed that is evidence that they have 1,28,000. The learned counsel for the petitioner filed a memo stating the petitioner released the deposit amount of 1,29,000. Hence that respondent now is liable to pay remaining compensation. 2 ಹೇಳಿದಲ್ಲ remaining.
Please, my lord.
Who is 2?
Respondent number 2 under insurance company.
ನಿಮಗೆ ಹೇಳಿದ್ದಾರೆ.
1,71,822 ಅವಾರ್ಡ್ ಅಮೌಂಟ್ ಸ್ವಾಮಿ. ಅದ್ರಲ್ಲಿ ನಾನು 1,29,263 ಕೊಟ್ಟಿದ್ದೀನಿ. ಬ್ಯಾಲೆನ್ಸ್ ಅಮೌಂಟ್ ನಾನು ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಐ ಆಮ್ ರೆಡಿ ಟು ಡಿಪಾಸಿಟ್ ದಟ್ ಅಮೌಂಟ್.
Why you are restricting only 1,72,000?
ಎಸ್ಟೇಟ್ ಪಾಲಿಸಿ ಅವರು ಸ್ಯಾಲರಿ ಡಿಕ್ಲೇರ್ ಮಾಡ್ತಾರೆ. ಆ ಸ್ಯಾಲರಿ ಡಿಕ್ಲೇರ್ ಮಾಡಿದಾಗ ಅದ್ರ ಮೇಲೆ ನಾವು ಪ್ರೀಮಿಯಂ ತಗೊಳ್ತೀವಿ.
ಎಲ್ಲಿ ಸ್ಯಾಲರಿ ಡಿಕ್ಲೇರ್ ಮಾಡಿದ್ದಾರೆ?
ಅವ್ರ ವೇಜಸ್ 1,500 ಅದೇ ಬೇಸಸ್ ಅವ್ರಿಗೆ ಎಕ್ಸಿಬಿಟ್ R1 ಅವ್ರು ಕೊಟ್ಟಿರೋ ಬೇಸಸ್ ಮೇಲೆ ಕೊಟ್ಟಿರೋ ಸ್ವಾಮಿ.
That is not that wages we are declaring.
ವೇಜಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಸರ್ ಅದನ್ನ.
Insurance policy li, if you have said this is that wages, then otherwise wages which is minimum, ಅದಕ್ಕೋಸ್ಕರ minimum fix ಮಾಡಿರೋ
ಎಸ್ಟೇಟ್ ಪಾಲಿಸಿಲಿ ಏನಾಗುತ್ತೆ ಸ್ವಾಮಿ, ಎಸ್ಟೇಟ್ ಪಾಲಿಸಿಲಿ ನಾವು ಲೇಬರ್ಸ್ ಎಷ್ಟು ಜನ ಲೇಬರ್ಸ್, ಸ್ಕಿಲ್ಡ್ ಲೇಬರ್, ಅನ್ಸ್ಕಿಲ್ಡ್ ಲೇಬರ್ಸ್ ಅಂತ ಇರ್ತಾರೆ. ಆ ಲೇಬರ್ಸ್ ಟೋಟಲ್ 100 ಸ್ಕಿಲ್ಡ್ ಲೇಬರ್ ಇದ್ರೆ ಟೋಟಲ್ ಪ್ರೀಮಿಯಂ ತಗೊಳ್ತಾರೆ. ಡಿವೈಡೆಡ್ ಬೈ ಅಷ್ಟು ಪ್ರೀಮಿಯಂ, ಒಂದು ತಿಂಗಳು ಸ್ಯಾಲರಿ ಅಂತ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅವರು ಪ್ರೀಮಿಯಂ ಕಟ್ತಾರೆ. ಆ ಅಮೌಂಟ್ ಮಾತ್ರ ಇಫ್ ಎನಿ ಇಂಜುರೀಸ್ ಆರ್ ಡೆತ್, ಆ ಅಮೌಂಟ್ ಮಾತ್ರ ನಾವು ಪೇ ಮಾಡ್ತೀವಿ. ರಿಮೈನಿಂಗ್ ಅಮೌಂಟ್ ದಿ ಓನರ್ ಹ್ಯಾಸ್ ಟು ಪೇ ಕಾಂಪನ್ಸೇಷನ್ ಅಲಾಂಗ್ ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್ ಎಕ್ಸಸ್ ಅಮೌಂಟ್ಗೆ. ನಾನು ಅದು ಬೇಕಾದ್ರೆ 2 days ಟೈಮ್ ಕೊಡಿ ಸರ್. ಮಂಡೇಗೆ ಟ್ಯೂಸ್ಡೇಗೆ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಡಾಕ್ಯುಮೆಂಟ್.
Yes. At the request of counsel for the respondent, leave this matter next week.
Date maybe. Date.
ಬರತ್ next week ಅಂತಂದ್ರೆ next Monday, Tuesday ಬರುತ್ತೆ. Yes. 17
Serial number 63, Nagaraja Hegde for appellant, P.B. Raju, B.C. Shivanegowda.
For appellant, my lord, case of injury, my lord.
ಯಾರು ಶಿವಣ್ಣಗೌಡ?
ಇವರು P.B. Raju ಅವರು.
ರಾಜು ಅವರ ಎಲ್ಲಿದ್ದಾರೆ? ಪಾಸ್ ಅವರು ಅವ್ರಿಗೆ ಹೇಳಿ ಮಧ್ಯಾಹ್ನ.
Serial number 64, Ravish Benny for appellant, connected matter, Shiva Prasad.
Yes, where is Ravish Bini? ಬೆಳಿಗ್ಗೆ ಎಲ್ಲ ಇದ್ರಲ್ಲ. What is this, Mr. Shivu?
It is called into question. Liability.
Liability.
Yes.
On what ground?
On the ground that, my lord, the persons who are injured, they were tractor, they were in trailer. It was not part of the insurance policy. And
Trailer is how that accident occurred.
ಗುಂಡಿಯಲ್ಲಿ ಬಿದ್ದು tilt ಆಗಿದೆ.
ಗುಂಡಿಯಲ್ಲಿ ಬಿದ್ದಾಗ. What is the finding of that tribunal? This thing.
Tribunal holds that, my lord, that they are entitled for compensation on the ground that for third party insurance, liability, there is no liability at all. Now the 4 persons who have been injured are all workers
with that.
ಕೆಲ್ಸಕ್ಕೆ ಹೋಗೋರು.
Yes.
So 4 ಜನಕ್ಕೆ ಇಂಜುರಿ ಆಗಿದೆ.
Where is Bini? Password.
Tomorrow may request for tomorrow.
Yes. None appear for appellant. Please this matter deft tomorrow.
Please.
Yes.
Serial number 65, M.E. Maheshwarappa for appellant, P. Prakash, Avadidar Negawa.
Case of death, your lords.
Next, kindly next week.
Why? ಕೊಡಿ. ಏನ್ liability owner ಮೇಲೆ ಇದೆಯಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ, dismiss the claim petition. There is no relation between the employee and employer. But he is working as a fully loader, unloader of the tractor. The tractor met with an accident. But there is no relation between the employee and employer ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ವಜಾ ಮಾಡಿದ್ದಾರೆ.
ಏನ್ ಹೇಳ್ತಾರೆ ಓನರ್?
ಓನರ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಮತ್ತೆ ನೀವು
But one, the co-worker not examined, your lordship. This person working with one shaker not examined. The observation, that is your lordship, the page number. No. One Satyappa is the eyewitness, lodge a complaint, your lordship. Our prakara is working as a tipper lorry, not your lordship. He is working as a tipper lorry. Is the goods vehicle. Exhibit 16. ವಿಷಯ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ದಿನಾಂಕ 19/2/2010 ಮಧ್ಯಾಹ್ನ ಸುಮಾರು 3 ಗಂಟೆಯಲ್ಲಿ ನಾನು ನನ್ನ ಗದ್ದೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದ ಸಿರಿಗೆರೆ ಕಡೆಯಿಂದ MHHF 5203 ಟಿಪ್ಪರ್ ಲಾರಿ ಚಾಲಕನು ಟಿಪ್ಪರ್ನಲ್ಲಿ ಜಲ್ಲಿ ಕಲ್ಲನ್ನು ತುಂಬಿಕೊಂಡು ಮಲೇಶಂಕರ ಗ್ರಾಮದ ಕಡೆಗೆ ಅತಿ ವೇಗ ಮತ್ತು ಅಜಾಗರೂಕತೆಯಿಂದ ಚಲಾಯಿಸಿಕೊಂಡು ಬಂದು ಪರಿಣಾಮ ಆರಿನ ಕೆರೆ ಏರಿಯ ಮೇಲೆ ರಸ್ತೆಯ ಎಡಬದಿಗೆ ಟಿಪ್ಪರ್ ಪಲ್ಟಿಯಾಗಿ ಬಿದ್ದಿದ್ದು ಟಿಪ್ಪರ್ನಲ್ಲಿ ಇದ್ದ ರಮೇಶ್ ಎಂಬುವರು ಲಾರಿಯ ಅಡಿಯಲ್ಲಿ ಸಿಕ್ಕಿಕೊಂಡು ಆತನಿಗೆ ಮೈಕೈ ತುಂಬಿ ಹೊಡೆತ ಬಿದ್ದಿರುವ ಸ್ಥಳದಲ್ಲಿಯೇ ಸತ್ತು ಹೋಗಿರುತ್ತಾನೆ. ಡ್ಯೂರಿಂಗ್ ದ ಕೋರ್ಸ್ ಆಫ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ವೆನ್ he was working as a loader while he was discharging his duty, he died in the accident, your lordship.
Now, what is that version of the owner?
Owner that is admitted, that is our, that is in the
Our WS statement of objection for respondent number 1.
One Miss Jai Krishna examined, your lordship.
Various amendment of petitioners, PC Vijay Kumar was died.
PW2 Satyappa, that is. Allah.
Also depending upon the income, that is Vijay Kumar.
Insurance company has got examined, that is learned counsel, that is para number 22, your lordship. Ink page number. The learned counsel respond to even subject to RW1 is cross examination. RW1 in his cross examination has categorically stated that he purchased the lorry on 9/2/2009 and on the same day he transferred to the side lorry to his mother, respond number 4. Subsequently, his mother sold the side lorry to respond number 1 on 23/5/2009. RW1 stated that he is not aware whether his mother had taken insurance policy from the respondent number 2 or a period of 2/5/2009 to 1/5/2009. Likewise, he has stated that he is not aware whether his mother has taken a permit to the lorry. However, he is categorically suggesting that at the time of accident, it was his mother who was absolute owner of the said lorry in her name, RC insurance policy. The respondent have examined official working in the
Mr.
RTO.
Lingraj, you are not there in this case.
No, next case is Lingraj.
ಇದ್ರಲ್ಲಿ ಯಾರಿದ್ದಾರೆ?
65.
Or Murlidhar.
Murlidhar, Nagwara Murlidhar.
Where is he?
ಬಂದಿಲ್ಲ ಅವರು.
Next week.
ಗಾಯಾಳಿಗೆ ಚಿಕಿತ್ಸೆ ವಕೀಲರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ?
That is cross examination.
ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆ ವೈದ್ಯಕರು ಡಾಕ್ಟರ್ದಲ್ರಿ ಓನರ್. Is owner is examined as RW?
Srinivas, Manjunath, no, your lordship. Not examined.
ಮತ್ ನೀವ್ ಯಾರು ಓದಿದ್ದೀಗ?
That is insurance company.
ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ಯಾಕ್ರಿ? ಓನರ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ?
Owner examine ಮಾಡೇ ಇಲ್ಲ ಸ್ವಾಮಿ. Only for RW1, Srinivasa, the Santosh Kumar manager.
What is your stand, madam? Is he your employee?
He is the owner, ಅವರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ.
ಅವ್ರು ಏನ್ ಹೇಳಿದ್ದಾರೆ? ಅವ್ರದ್ದು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ನೋಡಿ. Respondent. Owner is respondent number 1.
ಹೌದು.
ಹೇಮರಾಜ್.
ಹೇಮರಾಜ್.
ಡ್ರೈವರ್ ರೀ ಹೇಮರಾಜ್.
That is
ಏನ್ ಫೈಲ್ ನೋಡಲ್ಲ.
Jai Krishna HS branch manager.
Owner of the tractor and trailer.
256. That is year 5670, your lordship.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲನ್ರಿ ನೀವು? ವಾಟ್ ಇಸ್ ಯುವರ್ ಸ್ಟ್ಯಾಂಡ್ ಮೇಡಮ್?
ಕಲ್ಲಿಗ್ ಪರ್ಸನಲ್ ಮ್ಯಾಟರ್ ಕಲ್ಲಿಗ್ ಪರ್ಸನಲ್ ಮ್ಯಾಟರ್ ಅವರೇ ಮಾಡ್ತಾರೆ.
Yes, she is not ready, Mr.
ಏನಿದೆ?
Yes, at the request of counsel for Respondent number 1 and 2, please this matter next week.
Next case is Lingaraj.
Serial number 66, M.A. Maheshwarappa, H.S. Lingaraj.
Here is the tipper lorry. One sir. Huh? Oh, either reject I.
Dismissed.
Dismissed. The R1 is the Vijay Jai Krishna is the owner. Earlier Dakshayani is the owner. A transfer to Jai Krishna. Insurance is valid, your lordship.
Why it is dismissed?
Now your lordship, the relation same. The relationship is not admitted, your lordship.
Where is the finding?
That is. Respond, para number 18, your lordship.
Read.
Respondent number 3 has got examined himself as RW1. He has filed the chief examination affidavit wherein he has categorically deposed that the petition is not maintainable and this petition is false one, only with an intention to claim compensation on baseless and imaginary ground. RW1 deposed that the tipper lorry was purchased on 9/3/2009 and subsequently the same day the transport to vehicle on 4th respondent, he has deposited the RTO. Next, learned counsel for the respondent number 2, that is the insurance company, your lords. Respondents have examined the official working in the RTO. That is.
You continue that reading.
Yes.
Why you have jumped there?
Yes. Para number 19. Learned counsel for the respondent number 2, even subject to RW1 for cross-examination. RW1 in his cross-examination has categorically stated that he purchased the lorry 9/2/2009 and
RW1 yaro?
RW1 is that is one of the first respondent. Lorry, and the same day he transferred the said lorry to his mother, respondent number 4, and subsequently his mother sold the said lorry to respondent number 1 on 23/5/2009. RW1 has stated that
accident agide yavattu?
That is date of accident is 19/2/2010.
Yes. Yes.
RW1 has stated that he is not aware as to whether his mother had taken insurance from the respondent number 2 for a period of 2/5/2009 to 1/5/2009. Likewise, he has stated that he is not aware as to whether his mother had taken the permit to the lorry. However, he has categorically denied the suggestion that at the time of accident and it was his mother was absolute owner of the said lorry and her name RC in the insurance policy was standing and she is liable to pay compensation on her own. The respondents have examined an official working in the RTO office, Shivamogga RW3. RW3 Manjunath FDA has categorically deposed that as for the summons received by him before the court and he has produced before the court the authorization letter given to him by RTO, authorizing him to give evidence before this court, and based on that authorization, he is deposing before the court and marked authorization letter Exhibit P2. He has produced B extract of the tipper lorry bearing registration number MH11F5203, marked Exhibit R3. He has produced the application filed by the respondent number 4 to transfer the lorry to the name of the respondent number 1, and he has produced the copy of the application marked Exhibit R4. He has produced the document for having transferred the vehicle to the name of respondent number 1 based on application filed by the respondent number 4, and the said documents consist the 4 pages marked Exhibit R5. He has produced the endorsement given by his office to the respondent number 4 marked R6. He has deposed that subsequently the respondent number 1 also filed an application before the office to transfer the vehicle in the name of one Kavya Sri, and he has produced the copy of the application marked Exhibit R7. He has produced the RC transfer document and the said lorry was transferred to the name of Kavya Sri based on Exhibit P7, application marked Exhibit P8. However, RW3 in the cross-examination has categorically admitted that between the period of 5/5/2009 to 10/9, and the vehicle bearing registration number MH11F520 was standing in the name of respondent number 1, and he is owner of the said vehicle. RW1 has stated till 5/5/2009, the respondent number 4 was the owner of the vehicle, and subsequently based on an application filed by the respondent number 4, his RTO office has transferred to RC in the name of respondent number 1, and at the time of accident, the RC of the lorry was standing in the name of respondent number 1. Even the respondent number one in his objection and also the cross-examination PW1 has denied the fact that as on the date of he was the RC owner of tipper lorry, but however, he has categorically denied the fact that he had employed the deceased Ramesha to work under him as a cleaner tipper lorry. During the course of such employment, the accident took place. The respondent number two insurance company has got.
Why it is dismissed?
That is observation, the para. That is. Respondent number insurance has got examined its manager RW2. RW2 has filed his chief examination affidavit wherein he has deposited that tipper lorry bearing registration number MH11F5203 was insured with his insurance company, and they have issued an insurance policy on 2/5/2009 which was valid up to 1/5/2010, and their liability is subject to the terms and condition of the policy, insurance policy, and the said policy issued was a package policy to the way, and the policy was standing.
Para 22 ode.
Even though the learned counsel for the petitioner subject to RW1 cross-examination, however, nothing was elicited from the mouth of RW2 to prove the relationship between the deceased Ramesha and the respondent number one. However, RW2 has denied the suggestion that their insurance company has issued a package policy. His company is liable to pay compensation to the deceased Ramesh, who was said to be a cleaner of the lorry. Except making some suggestion, RW2, nothing was placed before this court to prove the deceased Ramesha working as a cleaner under the respondent to work in his tipper lorry. During the course of such employment, the deceased Ramesha met with an accident and sustained the march injuries and died at the spot. On the contrary, admittedly, the initial burden was on the petitioner to prove the existence, the relationship of employee and employer between the deceased and the respondent number one, and to prove that while he was charging his duty during the course of such employment under respondent number one, he met with an accident due to the negligence of driver of the
Respondent number one has been examined as
RW2, that is.
RW2.
Oh.
Even
Our
though
owner,
counsel for the petitioner subject to RW2 for corruption, however, nothing elicited from through that relationship between the deceased. No, that RW2 has denied your relationship.
What the owner himself denies that.
Who owner? Eli RW2 evidence padi.
RW2 Santosh Kumar, that is, yes.
Manager RW2 is the manager, right?
Manager.
ನೀವು ಯಾರು
RW2.
Who is that owner, mister?
Owner is first respondent, Jaikirti, that is.
ಆಯ್ತ್ರಿ ಅವ್ರು he has been examined as what?
Examine ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅದು.
Owner examine ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ.
ಮತ್ತೆ?
Notice served.
Then how you have proved that ownership, mister?
He is admitted, that is insurance company, that is.
ಎಲ್ಲ admitted ರೀ. RW2 ಯಾರ್ರಿ? ಕೊಡ್ರಿ.
RW2 ಸಂತೋಷ್ ಕುಮಾರ್, ಮ್ಯಾನೇಜರ್, ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ.
ಅವ್ರಿಗೇನ್ ಗೊತ್ತಿರತ್ರಿ ರಿಲೇಶನ್ಶಿಪ್?
RW1 ಬಂದು
ಶ್ರೀನಿವಾಸ, that is one.
You just see that. Yes.
ಅಲ್ಲ ಅದು ಬೇರೆ.
Pass out. 230 will continue. Yes.
On submission, my lordship, serial number 68, kindly out and speak, my lord.
68
years delay, my lord, is initiating the proceedings. SC/ST matter.
Yes, ma'am.
The sale was, my lord, in 56, sir. 1179 Act came into force. 2008, my lord, application is filed. On the ground of delay, my lord, the order of assistant commissioner and deputy commissioner is liable to be set aside.
No, that you are for an
For the purchaser.
Purchaser. No, DC and DSC is passed in his favor.
In his favor. But, my lord, 29 years delay, my lord, in invoking the jurisdiction.
But now that matter is pending before the court for consideration of validity.
Division bench, the validity has nothing to do. Division bench has said, my lord, the section will not be beneficial, my lord. The old provision continues.
No, even then, validity has been challenged in thousands of cases. It has been heard.
Without, my lord, deciding the question of validity, I am entitled to, my lord.
No, in all cases where there is a delay,
yes,
counsel says challenged and pending before the court. Should
it
he
is
not wait
unnecessary,
for
my lord, in view of the division bench ruling of Justice Krishna Dikshit and another judge.
True. See, that is different.
ಅದರಲ್ಲಿ ವ್ಯಾಲಿಡಿಟಿ ಚಾಲೆಂಜ್ ಮಾಡಿ
ವ್ಯಾಲಿಡಿಟಿ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. ಇದ್ರಲ್ಲಿ
ಮಾಡಿಲ್ಲ.
ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ವ್ಯಾಲಿಡಿಟಿ
But I have not challenged the validity. I have said, my lord, under the old provisions,
That is true. Constitutional validity has been challenged where that grant is taking in a defense. That is before the court matter was heard, then AG has to replay. Do not wait for that, mister. Otherwise, suppose constitutional validity in the court it said that constitutional validity is upheld. Then two contrary views.
no, my lord, your lordships are mistaken.
That, see,
That the-
no, I understood.
What the division bench has held is,
I
now
read
the,
it, Mr.
the
Shastri
wording of
said-
the wording of the section is such it will not nullify the previous judgments of this courts and that of the Supreme Court. That is what, my lord,
That has to be held in that when it is constitutional validity has been challenged. There the court has to say, see, by making an amendment, nothing has been changed. This amendment is not taking over the decision of the Supreme Court. Therefore, amendment has to be quashed. That has to be said by that bench which has been hearing that matter.
all right, my lord,
Can't wait,
let us-
we can wait for it. Even, I think, division bench,
In
first court.
principal
also, I
bench
think
also
they have
waiting
kept
for
the
that.
matter has been pending.
please.
We'll wait for that. Anyhow, that, see, all, some senior counsels has argued. Now AG has to give a reply. We'll wait that. Then we'll decide if division bench as well as that constitutional validity.
What happens
court
is-
has said,
No, my
then
lord.
it is easy for us to
Now,
dispose.
now the division bench upholds its validity. Let
Without-
us say that.
No,
The
without,
effect is the same, my lord.
Eh?
The effect is the same. It will not take away the validity of the
I
previous
think,
judgments.
Lord, I
The
think,
division, the single judge upholds its validity, let us say. It is valid, it is competent because the SC/ST Act is there. The state legislature is competent to enact legislation. They have done it. But even then, my lord,
after that, it is easy for us to follow that single judge as division bench and dispose of the matter.
well,
If single judge validity challenge said something else, no, they can file an application at any time.
well,
Right? You
well,
see,
well.
matter has already argued sometime.
Well,
We
well.
can wait for some.
Well,
Yes.
well.
Otherwise, this problem will arise us.
Again, there will be conflicting that confusion that.
See, I think I am told that even first court, they have not taken that.
ಯಾರು ಹಿಯರ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸರ್. ಡಿವಿಷನ್ ಬೆಂಚ್ ಆಲ್ಸೋ ವೇಟಿಂಗ್ ಫಾರ್ ದ ಡಿಸಿಷನ್.
All right, all right,
Sending the matter.
all right.
Yes.
Serial number 40 minutes next week.
Lord, serial number 68 next week. Lord.
Serial number
68.
40. Yes, at the request of parties, leave this matter next week. Yes,
Serial number 68, my lord.
next, ಯಾವತ್ತಿದ್ದಾರೆ ಅದು?
ಲಾರ್ಡ್ ಈಗ 12th ಇದೆ ಸ್ವಾಮಿ, ನಾಳೆನೇ ಇದೆ.
Yes,
ಬಟ್
we'll have it
21st ಹಿಯರಿಂಗ್ ಫೈನಲಿ ಕಂಪ್ಲೀಟ್ ಆಗತ್ತೆ ಅನ್ಸುತ್ತೆ.
21st.
ಅಬ್ಲೈಜ್
I list this
2
matter
weeks.
after 2 weeks.
First.
ವೈಟ್ ಶೀಟ್ ಕೊಡು.
ಇದರಲ್ಲಿ ಒನ್ ಟೈಮ್
TCR ನಮ್ದ ಸರ್? ಯಾವ್ದು TCR?
ಎನ್ಸಿಆರ್ ಏನು ಎವಿಡೆನ್ಸ್ ಏನ್ ಮಾಡ್ಯಾರ ಇವರು ಹಳೆ ಕೇಸು ಅದೇ ಓದಿದ್ರು ಅದಕ್ಕೆ
Madam, sir. Sir, what officer, sir?
ಆಗಿದೆ ಸರ್ ನಿಮ್ದು ಅರ್ಜೆಂಟ್
Serial number 68, sir.
ಆಗಿದೆ ಸರ್ ಆಗಿದೆ.
Sir,
ಆಗಿದೆ ಸರ್ ಆಗಿದೆ.
2 weeks,
ಹಾ ಅವ್ರಿಗೆ ಡಬಲ್ ಕನ್ಫರ್ಮ್. Citation. Madam, citation ಆಮೇಲೆ ಅಷ್ಟೇ ಮಾತ್ರ ಬಂದದ್ದು ಕರೆಕ್ಟ್ ಆಗುತ್ತೆ ಮಾತ್ರ ಬಂದದ್ದು ಕರೆಕ್ಟ್ ಆಗುತ್ತೆ ಯಾಕೆ ಇದೆಲ್ಲ ಕಿತ್ತಾಕಿದ್ದೀನಿ
ಏನ್ ಮಾಡ್ಲಿ ಡಿಸ್ಪೋಸ್ ಇದಿದ್ರೆ ರೀಕಾಲ್ ಅನ್ನ ವರ್ಡ್ ಮಾಡಿ ಮಾಡಿಫೈ ಅಂತ ಹಾಕ್ತೀನಿ.
ಅಷ್ಟೇ ಮಾಡ್ಬೇಕಾಗ್ತದೆ
ಅವತ್ ಬಂದ್ರು ಚೇಂಬರ್ ನಾನೇ ಹೇಳಿದ್ನಲ್ಲ ಅವತ್ ಬಂದ್ರು ಸಾಹೇಬ್ರ ಹತ್ರನೂ ಮಾತಾಡಿದ್ರು ಯಾಕೆ ಮುಡಿ ಒಂದು
ಅದೇ ಅಯ್ಯ ಸರಿಯಾಗಿ
ಅವ್ರಿಗೆ ಕಂಟೆನ್ಷನ್ ಬಂದಿದ್ರು ಕಂಟೆನ್ಷನ್ ತೋರಿಸಿ
ಇವಾಗ್ಲೂ ಹೇಳಿದ್ರು ಅವರು 2-3 ದಿನ ಬರ್ಬೇಕು ಸಾಹೇಬ್ರು ಬೇಡ
ಕಂಟೆನ್ಷನ್ ಏನಕ್ಕೆ
Court officer? Court officer? Court officer? Court officer? ಎಲ್ಲಿದ್ದೀರ? ಗಣೇಶ್ ಗಣೇಶ್ ಹಾ ಆಯ್ತಣ್ಣ ನಾನೇ ಅಲ್ಲಿಗೆ ಬರ್ಲಾ? ಇದು ನೀವು ಊಟಕ್ಕೆ ಹೋಗಲ್ವಾಡ? ಆಯ್ತಣ್ಣ ತೊಗೊಳ್ರಿ. ಅದಾದ ನಂತರ ನನ್ಗೆ ಮೆಸೇಜ್ ಫೋನ್ ಮಾಡಿ ಅಣ್ಣ. ಅದು ಡಾಕ್ಯುಮೆಂಟ್ ನೀವು ಕೇಳಿದ್ರಲ್ಲ ಬೆಳಿಗ್ಗೆ ತಂದ್ಕೊಡ್ತೀನಿ ಅಣ್ಣ. ನನ್ನ ತಗೊಬಂದಿದ್ದೀನಿ, ನೀವು ಮುಗಿದ್ಮೇಲೆ ಒಂದು ಫೋನ್ ಹಾಕಿ ಅಣ್ಣ. ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಸರ್ ಇದೊಂದು ಅಪ್ಡೇಟ್ ಆಗಿಲ್ಲ ಅಂತ ಈಗ ವಾಪಸ್ ಕಳಿಸ್ತಾ ಇಲ್ಲ. ಚೇತನಣ್ಣ ಇಲ್ಲಿ ಇದ್ದಾರೆ.
ಸೇವ್ ಮಾಡುವಾಗ ಗೇಟ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಈಗ ಒಂದು ಎರಡು ಆದ್ರೂ ನಾನು ಇವತ್ತು ಬೆಳಗ್ಗೆಯಿಂದ ಗಲಾಟೆ. ನಾನು ಹೇಳಿದೆ ಹೌದು. ಬೋಟೆ ತೊಂದ್ರೆ ಬೆಳಿಗ್ಗೆ ನಿಮ್ ಬಂದು ಡಿಸ್ಪೋಸ್ ರಿಪೀಟ್ ಆದಾಗ ಹಂಗೆ ಸರಿ ಊಟ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ.
Sir, serial number 62.
ನಮ್ದು 64 ಪಾಸ್ ಓವರ್ ಆಯ್ತು ಇನ್ನು ಅಲ್ಲಿ ಡಿವಿಷನ್ ಬೆಂಚಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ. ಇನ್ನೇನು ಕರೀತೀರ ಅನ್ನೋದ್ರಾಗ ಅಲ್ಲೇ ಟೈಮ್ ಆಗುತ್ತೆ. ಅದು ಬಿಟ್ಟು ಬಂದ್ರೆ ಇನ್ನು ಕರೀತಾರೆ ಅನ್ನೋದಾಗ ರೀಚ್ ಆಗುತ್ತೆ, ಮತ್ತೆ ಅಲ್ಲೇ ಸ್ಟಕ್ ಆಗುತ್ತೆ. ಸೀರೀಸ್ ಮೇಟ್ ರೆಡಿ ಇದೀನಿ.
ಇಲ್ಲ ಅದು ಅರ್ಜೆಂಟ್ ಆಗೋಯ್ತು ಸೀರೀಸ್ ಅರ್ಜೆಂಟ್. ಇಲ್ಲ ಸರ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಆರ್ಗ್ಯುಮೆಂಟ್.
64 ಸೀರೀಸ್
42ಗೆ ನೀವೇನೋ ಚೀಟಿ ಕೊಟ್ಟಿದ್ರೆ ಅದು ಕನೆಕ್ಟ್ ಮಾಡ್ತೀವಿ. ಮುಗೀತಾ? ಅದಾದ್ಮೇಲೆ 54 ಡಿಸ್ಪೋಸ್ ಆಯ್ತು. ಅವ್ರಿದ್ರು ರವಿ ಸಂಪ್ರದಾಯ ನೀವು ಇದ್ರ ಅದಾಯ್ತು. ಅದಾದ್ಮೇಲೆ ಇನ್ನು 64 13/9 ಏನಪ್ಪ ಮುಗಿಬೇಕಲ್ಲ. ಏನ್ ಲಿಸ್ಟ್ ಹಾಕಿ ಯಾವ್ದು ಇಲ್ಲ ಇನ್ನು ಎರಡಿದೆ. ಇದು ಲೇಟ್ ಆಗ್ಬಿಡಿ ಸರ್. ಏನೋ ಕಟ್ ಅಂತಂದ್ರೆ ಅಷ್ಟೇ ಹಂಗೆ ನಿಂತೋಗಿದೆ. ಚೇಂಜ್ ಮಾಡ್ಬಿಡಿ ಸರ್. ಇಲ್ಲ ಇವತ್ತು ಎರಡ್ ಮೂರ್ ಸತಿ ಕರೆಂಟ್ ಹೋಗ್ಬಂತಲ್ಲ ಇವತ್ತಿನ ಪ್ರಾಬ್ಲಮ್ ಫುಲ್ ಡೇ ಏನು ಇಲ್ವೇ ಇಲ್ಲ ನೋಡಿ ಇವಾಗ ಅವ್ರಿಗೆ ಗೊತ್ತಾಯ್ತಲ್ಲ ಪ್ರಾಬ್ಲಮ್. ಆರ್ಗ್ಯುಮೆಂಟ್ ಅರ್ಧಕ್ಕೆ ನಿಂತೋಗಿ. ಅರವತ್ತೆರಡೇನಪ್ಪ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Continue.
Passport matter later, sir.
ಅರ್ಧಂಬರ್ಧ ಹಾಕಿದ್ದಾರೆ. ಸ್ವಲ್ಪ ಸ್ಟ್ಯಾಪ್ಲರ್ ಅಂತ ಕೊಡು. Bill number 66, M. A. Maheshwarappa for appellant, H. S. Lingaraj.
Yes. See, who is the owner?
Jai Krishna.
Jai Krishna.
Jai
Jai Krishna
first
is respondent number?
Respondent number 1.
Earlier,
Earlier, R4 is the owner. He is sold to the transfer. The vehicle is first respondent.
now that as on the date of the accident, RC, who is the RC owner?
Jai Krishna, that is.
Jai Krishna.
Jai Krishna.
Jai Krishna ಅವರು objection ಹಾಕಿದಾರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, not yielded the evidence, not filed objection.
What about R4?
R4 is that is J Dakshin, earlier owner.
ಅವನು ಹಾಕಿದಾನ
ಅವರು ಇಲ್ಲ.
ಫಸ್ಟ್ ಕಮಿಷನರ್ ಮುಂದೆ ಹೋಗಿ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿದೆ, ಆಮೇಲೆ ಅದೇನಾಗಿದೆ MLC ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ, ಅಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಆಗಿಲ್ಲ. ನಮ್ಮವರು ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆರ್ಬನ್ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ, ಅಡ್ವೊಕೇಟ್ ಸೈನ್ ಮಾಡಿಲ್ಲ, ಅದೆಲ್ಲ ಇವರು ಎವಿಡೆನ್ಸ್ ಮಾಡ್ತಾರೆ. ಮ್ಯಾಟರ್ ಕ್ಯಾನ್ ಬಿ ಡಿಮಾಂಡೆಡ್ ಫಾರ್ because it's a case of death. I would not have.
Yes.
Case of death.
Death. ಅದೇನಾಗಿದೆ ಪೆಂಡೆನ್ಸಿಯಲ್ಲಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಯ್ತಾರೆ, ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ತದೆ, ಅವಾಗ ರೆಕಾರ್ಡ್ಸ್ ಇದಾಗಿದೆ.
See, on the ground that opportunity to examine that co-employee and also
further evidence.
Co-employee and
open all
owner, liberty, yes.
ಈಗ ಮತ್ತೆ ಅವ್ರಿಗೂ ಪಾಪ ಅನ್ಯಾಯ.
Yes. Substantial question of law frame ಮಾಡಿಲ್ಲ.
ಮಾಡಿದೆ.
ಅಲ್ಲ, when it is
admission
following the substantial ಹೌದು, that is admission ಬಂದಿದೆ.
ಅಡ್ಮಿಷನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. Yes. Substantial question of law arises for consideration. whether Commissioner justified held that the claimant has failed to prove that employer and employee's relationship so and so learned counsel appearing for claimant contended that deceased Ramesh was working as a cleaner in the tipper lorry belongs to respondent number 1. On instruction of his employer, respondent number 1, he was traveling in the tipper lorry after loaded with jelly stones. From Sirigere to Arkankere at the time on 19 to 2010. Due to rash and negligent driving of driver of the tipper lorry, the lorry met with an accident and the cleaner Ramesh died in that accident. The claimant has examined as RW1 has categorically stated that Ramesh was working under first respondent. That has not been denied by the first respondent.
ಎಲ್ಲಾರು ಮೂರ್ ಜನ ಓನರ್ಸ್ ಮಾಡಿದೆ, 3 ಜನನು ಡಿನೈ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಇವರು.
ಇಲ್ಲ ಇಲ್ಲ,
That is the objection,
not
examined,
ಅವ್ರು ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ. LCR ಪೇಜ್ ನಂಬರ್ 33
ಓ ಎಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಾರ.
objection ಹಾಕಿದ್ದಾರೆ,
ಎಲ್ಲರೂ they have denied.
ಎಲ್ಲರೂ ಡಿನೈ ಮಾಡ್ಬಿಟ್ಟು
not lead the evidence.
ಅದು MEC ಬಂದ್ಮೇಲೆ ಕೆಲವರು ಇಂಪ್ಲೀಟ್ ಮಾಡಿ
ಹಾಕಿದ್ದಾರೆ.
ಹಂಗಾಗಿ ಅದು ಕನ್ಫ್ಯೂಷನ್.
Yes, the respondent number 1.
Page number 12 ನಲ್ಲಿ
Under
ಹಾಕಿದ್ದಾರೆ.
respondent number 1 as in
ಎಲ್ಲ
to
ಟೋಟಲ್
prove that he has examined. First claimant has PW1 has categorically stated that Ramesh was working under first respondent as a cleaner in his lorry, except that petitioner claimant has not produced any documents to prove that the relationship of employer and employee. They have not examined that co-owner, the co-employee, or any other witness to prove their case. Therefore, tribunal has dismissed the claim petition. On the ground that they failed to prove employer and employee's relationship. Learned counsel for claimant appellant has submitted that if this court grant one more opportunity, they will examine that co-workers and other witnesses to prove their case. In the interest of justice, to give one more opportunity, the matter requires to be remitted back to the tribunal for fresh consideration. Accordingly,
I oppose on.
the learned counsel appearing for insurance company has contended that the claimant has failed to prove that master and servant relationship.
In spite of opportunity to give one.
They have not produced any document to prove the relationship of employer and employee. Therefore, tribunal has rightly rejected the claim petition. To give one more opportunity and in the interest of justice, I am of the opinion that the matter requires to be remitted back to the tribunal for fresh consideration. Accordingly, the appeal is allowed. Order dated so and so is set aside. Matter is remitted back to the tribunal for fresh consideration in accordance with law. After giving an opportunity to both the parties to adduce additional evidence and produce additional documents. All the points are kept open. Yes.
And stipulated.
All the contentions of the parties are kept open. Yes.
Maybe time may be fixed that dispose the matter.
ಅವರಿಗೆ ಓನರ್ಸಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ because they have not appeared here. Yes.
Serial number 67, Pradyumna L. Narasimha for petitioner, Narayanappa M.
Lord, in this matter, I beg your pardon, 1 week time may be granted, my lord. ಇದ್ರಲ್ಲಿ ಎಲ್ಲಾರು ಸಿದಾರಿಲ್ಲ ಅಂತ ಒಂದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತೋಡಿ ಅಂತ ಹೇಳಿದ್ರಿ. ಆರಿಗೆ ಹೇಳಿದಾರಂತೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. 1 week ಆದರೆ I will produce a report.
I appeal for the petitioner, my lords. It's been 3 dates, my lords. They've been given.
No,
Lord, I
they are
agree.
trying.
Yes,
but
my lords.
Otherwise, it is your duty to get
My lords,
there is no law which says
my lords,
government has to get an instruction, find out that who is the LRs.
yes, my lords, if I can
You know,
just give
this
some.
court order is there, they are doing that.
Yes, my lords.
We'll see 1 more week.
Indeed, my lords, just to give some background. So effectively, my lords, we had made those efforts initially, and then my lords, once we were unsuccessful, we had sort of written to the government to make sure that if that can be brought on record, then my lords, if they are making those efforts, then maybe adjourn.
No, show me under which law.
No, my lords, I agree that they're making those efforts, my
Yes,
lords.
yes,
It's
let
just
him,
that
yes,
there is
for
so
the
much-
interest of the parties only court has there.
Indeed, my
Yes, at the request of counsel for government advocate, leave this matter next week.
Obliged.
You can.
No, I
Village
called him,
accountant
I called him telephonically. He said that they are not available in that place. So they want to inquire
find
into
out.
that.
Yes.
Serial number 68, 69 adjourned. Serial number 70, Chetan V for petitioner, PM Siddhamalappa.
Yes.
13 years
Hearing for
delay.
petitioners, my lords.
Grantee.
Request short accommodation.
What is the date of the grant?
Lord, 72, my lord.
72.
ಹೌದು ಸ್ವಾಮಿ.
Sale?
ಸೇಲ್ ಬಂದ್ಬಿಟ್ಟು 2005 ಅಲ್ಲಿ 81 ಅಲ್ಲಿ ಫಸ್ಟ್ ಸೇಲು, ಅದಾದ್ಮೇಲೆ 2005 ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ 2018 ಮೇಲೆ ಲಾರ್ಡ್.
81 ಅಲ್ಲಿ ಫಸ್ಟ್ ಸೇಲ್.
ಹೌದು.
81 ಅಲ್ಲಿ ಆದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು
ಅಪ್ಲಿಕೇಶನ್ 2018 ಮೇಲೆ ಲಾರ್ಡ್.
There is a delay. Yes. We'll have it after 2 weeks.
Obliged.
Yes. At the request of parties, leave this matter of 2 weeks.
Fast over matter, serial number 1, Jaiprakash Reddy M for petitioner, Veena
Appeal for
Kumari.
the petitioner, my lord,
RCG.
we have filed amended application.
When
Yesterday, my lord, in the counter, we have filed
amended,
yeah.
have served the copy to other side.
Service, I'll serve it.
Yes. They have filed it. Let us see that application may be put up. Learned counsel for petitioner submits that as per that order dated 26/7/2024, 19/7/2024, they have filed an application for amendment of writ petition. Office to verify and put up the same. Yes.
R3 copy is, sir.
R3, yes, copy is. That is the formal. What is that objection you have that?
The only objection is it anyway does not come under.
Yeah, you can also file because here by challenging that amendment, they will not get any further relief. Yes, you have this thing because there is no limitation, delay in this case.
There is no.
Yes, let us see.
Oral objections may be taken on record and.
Application is not put up. They have filed it in that office. Yes.
Bill number 11, Sridhara Rao NG for petitioner. Serial number 11, Sridhara Rao NG.
ಏನ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಏನಾಗಿದೆ?
Pending ಇದೆ.
26 September. When the matter is called in the morning session, none appear. Even in that afternoon session, none appear for the petitioner. Is this matter? Nale agalva? Day after tomorrow, at the top of the list, under up for orders.
Serial number 22, Nagaraj AC for appellant, B. Purandara. Serial number 22.
ಏನಿದೆ ಮಿಷನ್ Purandara has password letters in managing director.
Serial number 24, Chetan Desai for appellant, B. Pradeep, HS Lingaraj.
Appeal for enhancement of compensation, Lordship.
Hmm.
The victim is the minor girl. The Honorable Tribunal has awarded a global compensation of 3 lakh rupees.
Hmm.
The victim has lost one kidney in the accident.
Hmm.
And
What is that age of?
2.5 years.
Hmm.
The trial court has awarded global compensation, not awarded in according to the heads, various heads of the given in the schedule.
Hmm.
I kindly rely upon the judgment of the Honorable Supreme Court and also passed by the coordinate bench of this Honorable Court,
Hmm.
wherein a minor child is being injured. Future loss of income has to be also to.
What is the age?
2.5 years.
No,
In that also, Your Lordship, the minor, she was also minor.
No, minor age.
4 years. She has also lost a kidney.
What is that? Give that to me.
In the last 2 judgments of Karnataka High Court, Your Lordship, in the first judgment, in the second judgment, Your Lordship, where I refer MFA number
3455.
3455.
Hmm.
Similarly, she was also minor, age of 2.5 years.
Hmm.
And Honorable Trial Court, High Court has awarded compensation of rupees 10 lakh.
The master Maligar.
Therein also, there was a failure of functioning of one kidney. Page number 20 may be perused, para number 3.
ಅಲ್ಲಿ 6 ಇಂದ 10 lakhs ಮಾಡಿದ್ದಾರೆ.
Enhance ಮಾಡಿದ್ರು.
ಇಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
In the next judgment, ಇಲ್ಲಿ only 3 lakhs global compensation. In the next judgment, Your Lordship may kindly peruse. Page number 32, page number 33, wherein here also same, page number 33, para number 1, Your Lordship. The fact that claimant was 4 years on the date of accident, lost one of her kidney as a result of accident is also not in dispute.
ಅದು ಕಾಜಲ್ ಕೇಸ್ ಕೊಡಿ.
Therein, after, ಅಲ್ಲ ಒಂದು ನಿಮಿಷ, I will, sir, ಒಂದು ನಿಮಿಷ. In the next page, at para number 3, the tribunal relying upon the judgment of the Honorable High Court, Kajal versus Jagdish Chand and others, 2020, I have produced this judgment here, reported in here as the first judgment of this. Relying upon this judgment, wherein the Honorable Supreme Court has held that even future loss of income has to be calculated and to be awarded.
What is that age?
Age in 4 years. ಈ ಕೇಸಲ್ಲಿ 4 years, ಫಸ್ಟ್ ಕೇಸಲ್ಲಿ 2.5 years, ಈ ಕೇಸಲ್ಲಿ 4
ಸುಪ್ರೀಂ
years.
ಕೋರ್ಟ್ ಕೇಸ್ ಇದರಲ್ಲಿ
ಅಲ್ಲ, ರಿಲೈಂಗ್ ಅಪ್, ಸೊ ಅದ್ರಲ್ಲಿ 10 years.
ಕಾಜಲ್.
That was regarding the minor, also regarding the minor, wherein the.
Yes, mister, all that same 4 years and all.
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಕಿಡ್ನಿ ಆಗಿರೋದು. No doubt ಈಗ MSCT has erred in not granting compensation. The loss of future earnings ಬರೋದ್ರ ಬದಲು ಲೋಕಲ್ ತಾವು ಒಂದು ಅಮೌಂಟ್ ಅರೈವ್ ಮಾಡ್ಬಿಟ್ಟು because
ಅಲ್ಲ ಸಿಮಿಲರ್ ಕೇಸ್ ಅಲ್ಲಿ 10 lakhs ಮಾಡಿದಾರಲ್ಲ 6 to 10 lakhs, it is also loss of kidney.
Loss of kidney, same matter.
ಅದನ್ನೇ
Both of the judgment, same kidney, failure of kidney.
ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ಅರ್ನಿಂಗ್ಸ್ ಅಂತ ಅದ್ರ ಬಗ್ಗೆ ಏನು
ಅಲ್ಲ, in view of that similar matter, this court has taken for on that 10 lakhs, same will be awarded in this case also. Instead of going to that all that this thing.
ಅದಕ್ಕೆ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ. ಬ್ರೇಕಪ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಪೇರೆಂಟ್ಸ್ ಸಫರಿಂಗ್ 3 ಲಕ್ಷ ಅಮ್ಯುನಿಟೀಸ್ ಆತರ ಮಾಡಿ.
ಅಲ್ಲ ಅವ್ರದ್ದು ಇವ್ರದ್ರಲ್ಲಿ 6 to 10 lakhs ಮಾಡಿದ್ದಾರೆ. We'll make it 3 to 10 lakhs in view of that judgment.
Kindly.
So and so learned counsel appearing for the claimant has contended that at the time of the accident, she was aged about 3 years.
2 years.
2 years. Due to that accident, she has lost 1 kidney.
Lordship, sorry. ಅಲ್ಲಿ ಇದು ಕಾಸ್ಟ್ ಇಟ್ಲಿ ಅವ್ರು 3 years ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ 3 years.
Yes, 3 years. Doctor has been examined.
PW2.
PW2. In his evidence, he has deposed that. ಏನ್ ಹೇಳಿದಾರ ಅವರು?
Lordship, failure of
ಏನಾರು ಹೇಳಿದಾರ?
ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Even doctor has also deposed that right kidney of the petitioner required to be transplanted.
Your Lordship, such a complete loss of kidney function.
As deposed that petitioner has lost left kidney, complete
loss of
loss of left kidney.
Lost 1 kidney. She has to live further life with only 1 functioning kidney.
Yes. ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
Evidence.
Which?
Even second paragraph.
Completely loss of kidney functions.
Further related.
Prophetic opinions, slab applied to kept so and so.
Last 3 lines. A child has lost 1 kidney. She has to live further
He
life.
has to live further life with
only one
one
function.
functional kidney. Therefore, compensation awarded by the tribunal is on lower side. He has relied on judgment of this court in similar circumstances has awarded a compensation of rupees 10 lakhs with 6% interest. Sought for enhancement of compensation. Has awarded 6 lakhs rupees for he has relied on the judgment of so and so in that in similar circumstance, this court has awarded 6 lakhs rupees for
ಅಲ್ಲ 6.5
4 ಲಕ್ಷ ಮೆಡಿಕಲ್ ಕೊಟ್ಟು ಇಂಟ್ರೆಸ್ಟ್ ಅವಾಯ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಅದಕ್ಕೋಸ್ಕರ ಐ ವಿಲ್ ಸ್ಪಿಟ್ ಅಪ್ ಇಟ್ ಅಂಡ್ ಎಸ್ ಎಲ್ಲ ಆಯ್ತದೆ ಇದೆ ಇಲ್ಲೆಲ್ಲ ಕೊಟ್ಟರು ಎಸ್ granted 6 lakhs rupees for loss of amenities and conveyances pain and suffering and 4 lakhs rupees for medical expenses which will not carry any interest. 6 lakhs rupees with 6% interest. 4 lakhs rupees for medical expenses will not carry any interest. Oh, ಇಲ್ಲ ಎಲ್ಲ ಸೇರ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಮೆಡಿಕಲ್ ಅಂತ ಕೊಟ್ಟಿಲ್ಲ. ಆಸ್ ಎನ್ಹಾನ್ಸ್ಡ್ ಕೊಟ್ಟೆ ಹಾಕ್ಬಿಟ್ಟು. Similar with enhanced from 6 lakhs, as granted a 10 lakhs rupees with 6% interest. Hence he sought for enhancement of compensation. Per contra, so and so learned counsel appearing for the claimant, insurance company has contended that at the time of the accident, claimant was minor, non-earning member of the family. In such circumstances, apex court in case of Master Mallikarjun has held that in case of disability less than 30%, less than 30%, the compensation has to be awarded for 3 lakhs. Considering the same, tribunal has awarded a compensation. Hence he sought for dismissal of the appeal.
Lordship, that Supreme Court judgment that has also considered Master Mallikarjun judgment.
ಅಲ್ಲಿ 10 years ಇದೆ.
ಹೌದು.
10 years only they are expected that she may support to the family and earning and all. 10 years ಇಂದ ನಾನು ಅದೇ ಹಿಂದಿನ 4-5 years ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವ್ರು ಯಾವ್ದಾರ ಕೇಸಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರಾ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು I asked some other advocates also find out and assist the court. Anyhow, that our High Court judgment is for some extent we can, that also in similar circumstances.
Yes, sir.
Up to 60%. 10% disability above 10% and up to 30%. Whole body rupees 3 lakhs. ಅದನ್ನೇ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ?
10 to 40%, 3 lakhs.
90% 5 lakhs. Above 90%, yes. Up to 30%. Whole body disability is 3 lakhs. Accordingly, tribunal has awarded a compensation. Hence he sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 13/9/2016 due to rash and negligent driving of driver of Tata Ace vehicle bearing registration number KA 13B8044. At the time of the accident, claimant was aged about 3 years. She was a minor, non-earning member of the family. Due to that accident, she has suffered the following injury. Doctor has been examined as PW2. In his evidence, he has deposed that due to that accidental injury, the claimant has suffered a loss of kidney function and she lost one kidney. She has to live further life with only one functional kidney. In similar circumstances, this court in MFA 3455 of 2013 and connected matter disposed of on 4th February 2020 has granted a compensation of rupees 10 lakhs in the case where the minor aged about 4 years has lost one kidney.
2.5. In that case, 2.5 years.
2.5 years has lost one kidney. In view of the above, I am of the opinion that in this case, the claimant is also entitled for compensation of rupees 10 lakhs. The compensation awarded by the tribunal 3 lakhs has to be enhanced to 10 lakhs with 6% interest. The insurance company is directed to deposit compensation amount with interest within 6 weeks from date of receipt. Evidence.
Lordship, how it has to be
Deposited by minor.
minor.
Other same, whatever that tribunal has said, that will be followed.
Tribunal,
Proportionately, that will go.
your tribunal has said, your lordship, 50,000 has given to the father guardian. 2 lakhs is to be deposited. Another 50,000 is also to be deposited. Entirely 90% of the amount is been deposited. Treatment deposit ಮಾಡಿ ಇದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ proportionate.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಆತರ ಹೇಳಿಲ್ವಾ?
ಅದ್ರಲ್ಲಿ
Percentage ಹೇಳಿಲ್ವಾ?
ಅವರು 2 ಲಕ್ಷ ಹೇಳಿದ್ದಾರೆ.
They have made it split this thing. We'll say that 75% of that amount will be deposited in that fixed deposit in the name of the claimant. 25% ಬೇಕಾಗುತ್ತೆ. Day to day.
Up to 10 years or?
No, still she become major, attain major.
The trial court has said, your lordship, from the interest obtained from the deposit,
That
she has to, she has to get a mediclaim policy ಮಾಡಬೇಕು ಅಂತ ಮಾಡಿದ್ದಾರೆ.
That will be continued. See,
interest if they are not,
it is further ordered at degree after making a deposit of the compensation, it is ordered to keep 50,000 FT in the name of the minor petitioner in any of the nationalized bank until she attain majority. Also keep FD of amount 2 lakhs in the name of the minor petitioner for 10 years. In the interest accrued if annually shall be paid as a premium towards the medical claim policy of the minor petitioner in that eventuality of the kidney transplantation to the minor petitioner. ಇದ್ರನ್ನ
ಆ ಅಮೌಂಟ್ ನ ಮೆಡಿಕ್ಲೇಮ್ ಪಾಲಿಸಿ ಮಾಡಿಸಿ ಅಂತ
ಅಲ್ಲ eventuality kidney transplantation, we don't know when the kidney necessary of a kidney transplant would come.
Eventuality of the right kidney transplantation minor petitioner and
eventuality
ಬಂದ್ರೆ see ಅಲ್ಲಿ deposit
ಇಲ್ಲ ತಗೊಂಡು ಅಮೌಂಟ್
in order to keep 50% FT in the name of the minor in any nationalized bank ಇದೆಯಲ್ಲ ಅದನ್ನ 1.5 lakh ಮಾಡೋಣ. Directed to deposit within so and so date. It is further ordered that agreed that after making a deposit of the compensation amount, it is ordered to keep 1.5 lakhs rupees FT in the name of the minor petitioner, any of the nationalized bank until she attain majority. Also keep 2 lakhs ideally, you will make it 4 lakhs or 5 lakhs madam. Yes. Also keep 5 lakhs in the name of the minor petitioner for a period of 12 years. 12 years. The interest accrued on if annually shall be paid as a premium towards the medical claim.
Your lordship,
Policy of the minor of the petitioner.
Medical claim policy ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಇದು ಅಮೌಂಟ್ ಬರೋದು ಅಲ್ಲಿ ಎಷ್ಟಾಗುತ್ತೆ ಪಾಲಿಸಿ ಅಮೌಂಟ್
ಜಾಸ್ತಿನೇ ಬರುತ್ತೆ ಅದು ಉಳಿಯುತ್ತೆ ಅದು ಯಾಕೆ ಅಂತ ಅಂದ್ರೆ ಇಟ್ ಇಸ್ 5 lakhs ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಮೆಡಿಕಲ್ ಕ್ಲೈಮ್ ಅಷ್ಟಿರಲ್ಲ.
ಅದರಿಂದ ಅದೊಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್. ಮೆಡಿಕಲ್ ಉಳಿದಿದ್ದ ದುಡ್ಡು ಅವ್ರಿಗೆ ವಾಟ್ ಎವರ್ ದಿ ಅಮೌಂಟ್ ಲೆಫ್ಟ್ ಆಫ್ಟರ್ ಮೆಡಿಕಲ್ ಕ್ಲೈಮ್
interest in that interest accrued
and
on if annually shall be paid as a premium ಅಷ್ಟೇ ರೀ. paid ಬಾಕಿ ನಿಮಗೆ ಅದು ಹೋಗುತ್ತೆ.
ಬ್ಯಾಲೆನ್ಸ್ ಅಲ್ಲ ನಮಗೆ ಕೊಡ್ಲಿಲ್ಲ ಅಕೌಂಟ್ಗೆ ಇಡ್ಲಿ ನಮಗೆ
ಅಲ್ಲ ಬ್ಯಾಲೆನ್ಸ್ ನಿಮಗೆ ಬರುತ್ತೆ. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ನೀವು ಇನ್ಸೂರೆನ್ಸ್ ಪೇಯ್ಡ್ ಆದ್ಮೇಲೆ ಏನ್ ವಾಪಸ್ ತಗೊಂಡೋಗಿ ಕೊಡ್ತೀರಾ ಮತ್ತೆ ಯು ವಿಲ್ ಬಿ ಕೀಪ್ ಇಟ್ ಇನ್ ಯುವರ್ ಸೆಲ್ಫ್. ದಟ್ಸ್ ವೈ ದಟ್ ಸೆಡ್ ಯು ಹ್ಯಾವ್ ಟು ಪೇ ದಟ್ ಇನ್ಸೂರೆನ್ಸ್ ಫ್ರಮ್ ದಟ್ ಅಮೌಂಟ್ ಅಂತ.
ಅದು ಅಮೌಂಟ್ ಎಷ್ಟಾಗುತ್ತೆ ಅಂತ ಗೊತ್ತಾಗಲ್ಲ. ಬ್ಯಾಲೆನ್ಸ್ ಈಗ ಇಂಟ್ರೆಸ್ಟ್ ಜಾಸ್ತಿ ಬಂದು ಇನ್ಶೂರೆನ್ಸ್ ಅಮೌಂಟ್ ಕಡಿಮೆ ಇತ್ತು ಅಂದಾಗ
ಎಸ್ ದೇ ಹ್ಯಾವ್ ಟು ಪೇ ದಟ್ ಪ್ರೀಮಿಯಂ ಟುವರ್ಡ್ಸ್ ದ ಮೆಡಿಕಲ್ ಕ್ಲೈಮ್ policy of the minor petitioner. Remaining amount can be used for the welfare of the petitioner. In the eventuality of the right kidney transplantation to that minor petitioner and disperse 50,000 towards the minor guardian of the minor.
3.5 lakh.
ಅದ್ ಬೇಡ ಬಿಡಿ ಅಷ್ಟೇ ಸಾಕು.
ಅಲ್ಲ ಅದು ಉಳಿದಿತ್ತು 3.5 lakh ಉಳಿತೀವಿ. 5 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ. 5 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ. ಇನ್ನು 1.5 ಲಕ್ಷ FD up to 18 ಮಾಡ್ತೀವಿ. 6.5 lakh. In 3.5 lakh may be given to the
Yes, that will go to that mother, at least whatever they have spent it. Remaining amount is directed to be released in favor of your father idara,
Father, guy is the guardian.
mother ilva?
ಅವರು ಫಾದರ್ ಅಂತ ಅಷ್ಟೇ ತೋರಿಸಿದ್ದಾರೆ ಮದರ್.
Yes, may be released in the name of, for the father to take care of welfare of the child.
Applies it.
Bill number 25, Chandrasekhar R for petition appellant, SV Agde Mulkon.
Yes, yaar Chandrasekhar R. Where is that Hegde? He has not come. Yes, none appears. Leave this matter after 2 weeks.
Serial number 28, Deepak DC for petitioner.
My lords,
Yes, you have complained.
I am the petitioner, my lords. I have complained.
Yes.
Complained. My lords, I am the grantee.
Yes,
The grant is of the year 1981.
1981.
1981.
Hmm.
Sale deed take place in the year 2007, my lords. Both in serial number 28 and 29, my
First
lords.
sale is 2017.
First sale is 2017.
7.
What? 2007, my lords.
Yes,
The challenge happens in the year 2014 before the assistant commissioner,
after 7 years.
after 7 years.
Hmm.
My lords, the reason assigned here is
Hmm.
by the assistant commissioner saying that
Yes.
the land, the sale permission has been obtained
Hmm.
and the land has been conveyed.
Where is that? Has it, have you obtained that sale
No.
permission?
No such permission has been granted.
Sir,
My lords,
Government
annexure
advocate-
H may kindly be seen.
in some of the cases, we are noticing that assistant commissioner is simply writing, there is a permission.
My lords, annexure H, my lords.
Continue, it is for a different land. He has used.
No, but you have to verify.
I have to verify.
Then in the other case, you said that no, DC has, after verifying that it is not related to that property.
That endorsement has been given by the very same people, my lords, the deputy commissioner.
Hmm.
Annexure H we have produced,
Hmm.
page 48, my lords.
You have not taken any permission for alienation.
No. The endorsement has been issued by the officer.
Where is that?
Annexure H, my lords, page 48. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಿಮ್ರಾಯಪ್ಪ ಬಿನ್ ಮುನ್ಸಾಮಪ್ಪ ದೊಡ್ಡಗಲ್ಲಿ ಗ್ರಾಮದ ಸೋ ಅಂಡ್ ಸೋ ಸರ್ವೆ
Yes.
ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಪ್ರಕರಣದಲ್ಲಿ
Hmm.
ಅದರಂತೆ ನಾವು ಕೋರಿರುವ ಮಾಹಿತಿ ಅಭಿಲೇಖನ ಕೆಟಲಾಗ್ ಇಂಡೆಕ್ಸ್ ಆಗಿರುವ ಕಡತದ ಪರಿಶೀಲನೆ ತಾವು ಕೋರಿರುವ ಮಾಹಿತಿ ಈ ಕಚೇರಿಯಲ್ಲಿ ವಹಿವಾಟು ನಡೆದಿರುವುದಿಲ್ಲ. There is no such permission which has been mentioned has been obtained.
Yes. No, this has been, have you placed this before the DC?
At that instance, I did not place, my lords.
Where is that? DC has also held same.
No, DC bypasses, he doesn't go on there not being sale permission.
Hmm.
He goes on saying that there is no such register, so there is no grant certificate found, hence we can't intervene.
Yes, you take notice. Government advocate is directed to take notice for respondent number 1, 2. Why the special land acquisition officer?
My
Is it
lords,
acquired?
the lands have been notified, my lords. By
No,
the,
This is happening in that only in land where it has been
Yes.
acquired.
This
In
is
all
happening.
cases, same thing is happening.
this is happening in only,
ಬೆಳಗ್ಗೆನೇ ಯಾವ್ದೋ ಎರಡು case ಅಲ್ಲಿ. Where it is acquired by the KADB, your officers will see that in one
KADB,
case,
my
will ask them to appear even DCAC also, if that is the case. You also intimate that secretary, this is what happening. Yes,
not to draw the compensation is the interim order.
yes. Directed to take notice for 1 to 3. Counsel for petitioner is directed to serve 3 set of copies on government advocate. PV Chandrasekhar is directed to take notice for R4. Counsel for the petitioner is directed to serve 1 set of copies. Issue emergent notice to 6, 7. The respondent number 4 is directed not to release that compensation amount in favor of
5, 6 and 7. 5,
respondent
6.
number 5, 6 till next date of hearing.
Stay of annexure A and B, my lords.
You are seeking
Order of
for
the
stay.
assistant commissioner and the deputy commissioner.
Then why do you want that not to release? If that order is stayed, then he can't release it.
It's all one and the same. My lord.
Yes. Stay of annexure, other badly it but stay of annexure A and B till next date of hearing. Yes.
My lords, if that order has not been narrated, my lords, they may once again say that
No, that, why do you want to stay that? That not
not
to
to
release that
release,
amount?
my lords, not
Yes.
to release is the only
Yes.
question, my lords. That is
Not
why
to release that compensation in favor of respondent number 5 and 6 in respect of petition scheduled property.
20,
Counsel for the petitioner submits that office objection is complied, office to verify.
29 also same, my lords. The grant is different, my lords. The purchaser is same. And the order is passed by the very
Same,
same officers and very same grounds. Verbatim, my lord.
Yes, government advocate is directed to take notice for 1 to 3, directed to serve copy. P.V. Chandrasekhar for R4, 5 and 6. R4 is directed not to disperse that compensation amount in favor of 5 and 6 in respect of petition scheduled property till next date of hearing.
Grateful.
Yes.
Serial number 48, Varun Jaykumar Patil for petitioner, government advocate.
I'm the petitioner, my lord.
Yes.
My lord, they have not served vacating application on me, my
I
lord.
have not served, I have not filed any.
They have not
application.
filed any vacating.
Lord, my
They
submission.
are
Lord,
opposing for extension.
Yes, Lord. Lord, kindly see, writ petition is filed 5 years after the order, Lord. Kindly
Yes.
see the order, Lord, that is impugned. It is of 2019.
Yes.
Lord, annexure A is the order which they have impugned. This order is dated 2/4/2019.
Yes.
Writ
Who
is
are
filed-
you? You are the purchaser.
I am the purchaser, Lord. I purchased in 1995. The first sale, Lord, is in 1943.
Yes.
I'm not 5 years, Lord, they don't do anything. They file a writ petition after that. I'm they get an order of status quo.
Yes.
Not kindly seem not, in fact, not their only
No, how
contention.
it will affect your rights now?
Not status quo, Lord, that has been granted.
No, will confine status quo in respect of position. If you
But
are,
I am already in possession.
you continue that. That's all.
But
Only
why-
thing is not to create third party interest.
No, Lord, even there, Lord, just not only ground on which not the interim order probably not have granted this because of the amendment.
Yes.
But I'll just place on record the judgment, Lord, of the division bench of the Honorable Court.
As-
Not, sir, aware. But they, and second thing is not land is converted. Not kindly see 68 years.
See, that is true. Now that in all matter, we are not taking any decision. Even in the first court also, they are adjourning the matter is pending before single judge in respect of validity. We are waiting for that. Therefore, on all matters which it is posted before this court, we are adjourning because of that. Let there be a decision when there is a constitutional validity, matter has been argued.
But I will point out, I'll answer that also, Lord. Kindly see, Lord, what is challenged. The validity of the
No,
amendment has been challenged. Now, Lord, the amendment is challenged. It is challenged, Lord, by the purchaser, Lord, not by the grantee. Therefore, Lord, the law as on date.
No. The only thing is that now they are arguing in some cases by in view of that amendment, there is a liberty to file an application for any time. That has to be considered by that case which is pending. Therefore, see, if suppose something has been held by that other bench, we cannot be go contrary.
Lord,
That's
then,
all.
Lord, I'll point out another thing. Lord, one is 68 days delay. The other thing is not land is converted. The land is converted, Lord, the full bench is held, Lord, land is out of the purview, Lord, of the act.
Land is converted prior to sale or after the sale, that has
But
to
it's
be
prior to
decided.
sale.
Prior to sale, it is converted.
But the first sale is 1943.
Hmm.
Lord, the conversion order,
1943.
how, Lord? First sale in 1943.
No, 43 itself it is converted.
No, 43 is a sale. Conversion. The first sale, the conversion, Lord, is on 17/1/1994.
Then after that,
After which there's a sale in 1995.
no, first sale itself is void.
But first sale, Lord, is even before the act came into force.
No, that is what that.
Therefore, Lord, if the act came into force in 1978,
I
therefore-
said any grant which is made.
Lord, act, Lord, comes into picture, Lord, when there is a sale, Lord, after the act came into force. Now, Lord,
No. You read that act. But I have read it. But now.
The act said all transaction which is made in contravention of that has to be resumed. After the act, any sale, it should be permission.
True, Lord. Insofar as sale which has taken place prior to that coming into force, even if that date is taken, Lord, 1943 is the first sale.
Yes.
That came into force in 1978. Then even then 30 years have expired, Lord, from that date.
No, that is also explained in the division bench and all. 30 years, they said, before 43, you were the sale,
1943 is the first sale.
first sale.
True.
For 1978, how many years?
1978, Lord, is 32 years.
32 years.
35 years.
Then I think.
Lord, may I request, Lord?
Adverse position.
Lord, Supreme
Lord,
Court
that
has
is what
held
I'm
that
saying.
the government should know that he is in a position.
No,
That he
see,
should satisfy that.
Division bench has held.
Obliged, Lord.
If before act came in the force, if sale has taken place 30 years, that has been saved on but one judgment is there.
ಹೌದಿದೆ ಅಂತ ಕೊಡ್ತೀನಿ ಅದು ಇದೆ ನೋ ಬ್ಲಡ್
Now, if they are taking a contention that adverse possession, then
civil court of the adverse possession, knowledge of this court said, see, if it is before act came into the force, if sale has been taken for.
no,
30
even
years,
Supreme Court is held that it has to be knowledge to the government because the property belongs to the government.
you see that on the SAST Act itself, there is a judgment.
yes Lord, I'll place that judgment
Yes,
also.
where is your senior? Mr.
He is held up in court of 11.
When do you want? When do you want?
Any date in next week, my lord.
Next week we'll hear that.
Lord may not extend the interim order, Lord. What has happened is, Lord,
Now, what is that difficulties for interim order now you are saying?
Lord, after I purchased 1995, Lord, on 18/4/2024, Lord, I have again sold the property to respondent number 11. Now, Lord, now the order of status quo, Lord, is affecting me because I cannot do anything in the property.
No, you do it. That will not say. You can develop that property. I will modify it to say that not to create any third party interest. You develop it. It is, if you are, he can't tomorrow, lose the case, but that loss it is cost to you. But if he succeed, he will get that developed property. You develop it.
Lord, kindly see the situation. 2019 order, 2024 al writ hakidare.
You will hear that on merit. Now, what is your difficulty? If you want to develop, we'll make it clear. You can develop the property.
Otherwise, Lord said the first instance suggested status quo with regard to possession is what Lords have said. Status quo, Lord, I am already in possession.
That's what that we said. We have said status quo in possession.
The order, Lord, Lord have just said, Lord, status quo.
Parties are directed to maintain status quo in respect of that petition scheduled property.
True. That means status quo, Lord, becomes wider.
You will say that parties are maintain status quo in respect of possession. Yes.
Lord, I will anyway file my vacating stay, Lord, thereafter. As of now, Lord, kindly at least to that extent, Lords may clarify.
Yes. Interim order granted on 9/8/2024 is modified. That parties are directed to maintain status quo in respect of petition scheduled property. Maintain status quo in respect of the possession of petition scheduled property. Till next date of
Please.
it.
Great.
Yes.
Let's give me a date next week, Lord. By then I'll file the application also.
You file it and move it anytime. We'll see that. Yeah.
Great.
Cell number 61, O Mahesh for appellant, Bhadravadi Siddheshwara. Serial number 61, O Mahesh.
Yes, Mahesh. ಯಾರಿದು? ಭದ್ರಾವತಿ ಸಿದ್ದೇಶ್ವರ.
61. Sir Mahesh.
My lord, I appear for the respondent number 1 in this case, my lord. 61, in 61, my lord.
What is this, mister?
My lord, this is a MVC petition, my lord.
You are the claimant.
Yes, my lord, I am the claimant, my lord. I have not challenged the petition, my lord. It has been challenged by insurance company.
On what ground they are challenging?
My lord, they have not served a petition copy, my lord. I have only the
No,
judgment.
is it a case of injury?
Injury, my lord. It's a case of injury, my lord.
Yes, they have challenged on the ground of negligence. Wound certificate, so and so.
their contention before the trial court is on
Involvement
twofold,
of
my
the
lord.
Insurance MC is alleged to accident suffer from any infirmity. The illegality has failed to notice borne by the records place of difference. Now complaint is for unknown vehicle.
My lord, unknown, my lord,
Yes.
complaint is 12 days delay. It's actually he was not conscious, my lord, hence.
Yes.
Petitioner, while the accident, he was not in conscious, my lord,
No,
at the time of accident.
you read that issue number 1.
Whether the petitioner proves that he sustained grievous injury on 21/1/2016 at 9 p.m.
Now para
near
9. Para 9.
Learned counsel for the petitioner argues that as per the evidence of PW 1-2 and exhibits P1 P9, petitioner proves his case. The learned counsel for the respondent argues that the petitioner failed to prove the accident occurred due to rational negligent riding by the rider of the bike, and respondent number 1 has violated the condition of the policy. On careful perusal of the material placed before the court, PW1 has filed an affidavit in lieu of his chief examination and reiterated the contents of the petition. PW1 states that on 21/1/2016 at 9 p.m. he was proceeding by motorcycle bearing register number so and so along with his father, who is a pillion rider, near Kalasapura Lakkaya Road. At that time, the rider of the bike bearing number KA13X52 drove the same in rash and negligent manner and dashed against his bike. As a result of which he fell down and sustained the grievous injury on the all over the body. PW1 further submits that immediately he was shifted to government hospital Chikmagalur and later he was referred to government hospital Assam, where he was undergone surgery and took a treatment as inpatient for a period of 1 week. He has spent around 20,000 towards the medical expenses. PW1 further states that earlier to the accident, he was hale and healthy man getting income of 9,000 per month by doing agriculture cultivation and animal husbandry, and he is suffering from pain, mental agony, and he is become permanently disabled. PW1 further states that respondent number 1 is the owner of the vehicle and it is insured to respondent number 2, and the policy is enforced on the date of the accident. Therefore, both the respondent are liable for paying the compensation. In cross-examination, PW1 denies the accident has not occurred due to the rash and negligent driving of the rider of the bike. He has also denied that he fell down and sustained injury, same is stated before the medical officer. Nothing is elicited in the cross-examination except denial. PW2 in his cross-examination stated that MLC vehicle number has not mentioned. On the basis of the affidavit filed by the petitioner on 1/2/2016, it is treated as RTI and mentioned in MLC. There is no instructions from the police station to register as RTI. Further admitted that the MLC mentioned as self-fallen. The learned counsel for the petitioner argues that
MLC it is mentioned self-fall.
My lord, actually MLC, my lord, he has not given MLC. His father has given, my lord. Learned counsel for the petitioner argues that petitioner was unconscious. Unknown person informed the daughter without personal knowledge, my lord. He was not conscious, my lord. MLC was not recorded by the petitioner.
Who is the complainant?
Complainant is
You yourself has given a complaint.
yes, my lord. Complaint is delayed complaint, my lord. 21 days delay.
Why delay? Have you explained that?
My lord, he after accident, my lord, he has went to hospital. After recovery, my lord, he has given a complaint, my lord. Police have not visited the hospital, my lord. He was admitted in the hospital, my lord, for a surgery.
Karatandavara Hesaru is attendant. Has been admitted to the IMSC so and so. Self-fall from the bike moving 9 pair. It is CNC that. From by that other on so and so. Treated that so and so.
Further, my lord, in the same para, my lord, where learned judge had observed that denial of accident can't be accepted, can be sustained, as it has been evidence led by RW1, my lord.
You are examine, they have examined that RW1. Who is RW1?
RW1 is insurance companies, my lord.
Driver has
Representative
not
of
been
insurance
examined.
company. My lord?
Driver has not been examined.
No, not examined, my lord. He was, my lord, in that same para, my lord, subsequently it has been revealed why I gave a delayed complaint, my lord. After reveals immediately after the accident, lodge complaint also took treatment. As an accident has occurred at 9 p.m. night hours of an offending vehicle could not be tracked. During investigation, police officer seized the said vehicle, so the contention of respondent can't be accepted. Trial judge had went to.
Where is Mahesh? Next week.
My lord, he is online, I think.
No, he is not there. He's only put his photos and went up.
Yes, my lord.
Yes. As the deposited amount.
My lord, they have deposited the amount, my lord. Basically, my lord, trial court had awarded only 2,02,000, my lord, with an interest of 6%.
Yes,
My lord,
Mr.
Mahesh
Mahesh.
sir had appealed.
Sir, 61 ನಿಮ್ದೆ ಮಹೇಶ್ sir.
Mahesh, ready ಇದೀರಾ?
Yes. Well, if the records have come.
Yes, yes, records are there.
Yes. Lord, it is an appeal by the insurance company.
Yes.
Where, my lord, the complaint was given by. Lord, I invite your lordship attention to ground number, my lord, in page 5.
Yes.
In page 6, my lord, A2.
Yes.
Q. Lord, the complaint exhibit P1, my lord, is by father of the injured.
Yes.
And pillion rider of the motorcycle. And it was on 22/1/2016 to Chikmagalur Rural Police, my lord, at about 5:45 p.m. Case, my lord, is that hit by an unknown vehicle which went away without stopping. Now, my lord, I invite your lordship attention to, my lord, exhibit P1, my lord.
Yes.
Yes. Then, my lord, on the third page.
Yes.
ದಿನಾಂಕ 22/1/2016 ಬೆಳಗ್ಗೆ 5 ಗಂಟೆಯಿಂದ 5:30 ಗಂಟೆಯವರೆಗೂ ಗಾಯಾಳು ಫಿರ್ಯಾದಿ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದುಕೊಂಡು ಸಾರಾಂಶವೇನೆಂದರೆ ದಿನಾಂಕ 21/1/2016 ರಾತ್ರಿ 9 ಗಂಟೆಗೆ ಫಿರ್ಯಾದಿದಾರರು ತನ್ನ ಮಗ ಮೋಹನ್ ಕುಮಾರ್ ಇವರ ಅಣ್ಣನ ಬಾಪ್ತು ಮೋಟರ್ಸೈಕಲ್ K18 EB 7729 ಅಲ್ಲಿ ಕಳಸಾಪುರದಿಂದ ಹೊರಟು ಫಿರ್ಯಾದಿದಾರರು ಬೈಕಿನ ಹಿಂದೆ ಕುಳಿತಿದ್ದು ಇವರ ಮಗ ಮೋಹನ್ ಕುಮಾರ್ ಬೈಕ್ ಓಡಿಸುತ್ತಿದ್ದು ರಾತ್ರಿ ಸುಮಾರು 9:30 ಗಂಟೆಗೆ ಗಾಣದಾಳು ಮತ್ತು ಹೊಸಲಕ್ಯ ಮಧ್ಯೆ ರಸ್ತೆಯಲ್ಲಿ ಕೋಳಿ ಫಾರಂ ಮುಂಭಾಗ ಬರುತ್ತಿದ್ದಾಗ ಎದುರುಗಡೆಯಿಂದ ಯಾವುದೋ ವಾಹನ ನಮ್ಮ ಮೋಟರ್ ಸೈಕಲ್ಗೆ ಡಿಕ್ಕಿ ಹೊಡೆದು ನಿಲ್ಲಿಸದೆ ಹೋಗಿದ್ದು ವಾಹನ ಕತ್ತಲಲ್ಲಿ ಗೊತ್ತಾಗಿರುವುದಿಲ್ಲ. This is the, my lord, the FIR by the pillion rider's father.
Yes.
Then exhibit P2, my lord, may kindly be looked into, my lord. Wound certificate of Hassan General Hospital.
Self-fall.
There you can see self-fall. Then, my lord, the Mahazar is, my lord, on exhibit P3.
Yes.
Is on 28/1/2016. Sorry, madam. P3 is the Caesar Mahazar, my lord. Caesar
Yes.
Mahazar. Yes. Then, my lord, P4 is the spot sketch, spot Mahazar, my lord. said to be in the presence of witness Nandish. He has not been examined.
Yes.
Then the my lord sketch does not have any signature, my lord, which is appended to the my lord the spot master.
Yes.
Then my lord charge sheet is exhibit my lord the P8.
Yes.
There, my lord, you must kindly see. For the first time, my lord, the vehicle number is being shown. That is KA13X528.
Yes.
On what basis, my lord, it was see? No investigating officer has been examined.
Yes.
How, my lord, he came to know that this vehicle has been involved.
Yes.
Then exhibit P7, my lord, MLC extract
Yes.
dated 1/2/2016.
Yes.
History of, my lord, the cell phone hit by unknown vehicle. At the bottom, you have to get it, my lord.
Yes.
Then, my lord, P8 case sheet also, my lord. There also you have to kindly see cell fall, fracture of so and so, so and so. That was the, my lord, Then, my lord, I take your lordship to the evidence of, my lord, the doctor. Prior to that, my lord, evidence of, my lord, PW1 injured in cross-examination may kindly be looked into, my lord. Later, I'll take your lordship to the evidence of, my lord, the Dr. Kiran. Last page, my lord. ಪಾಟಿಸವಾಲು.
Yes.
ನಾನು ಹಾಸನದಲ್ಲಿ ವಾಸ ಮಾಡುತ್ತಿದ್ದ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ನನಗೆ 35 ವರ್ಷ ಎಂದು ತೋರಿಸಿರುವ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ಫಿರ್ಯಾದನ್ನು ನಮ್ಮ ತಂದೆ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಅಪಘಾತವಾದಾಗ ನಮ್ಮ ತಂದೆ ಸಹ ಜೊತೆಗೆ ಇದ್ದರು. ನಮ್ಮ ತಂದೆ ಫಿರ್ಯಾದು ಕೊಟ್ಟಾಗಿ ಯಾವ ವಾಹನದಿಂದ ಅಪಘಾತವಾಗಿದೆ ಎಂದು ಹೇಳಿಲ್ಲ. ನಾನೇ ಬೈಕಿನಿಂದ ಬಿದ್ದು ಅಪಘಾತ ಮಾಡಿಕೊಂಡಿದ್ದೇನೆ ಎಂದು ವೈದ್ಯರ ಮುಂದೆ ಹೇಳಿದ್ದೇವೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. Then, my lord, I invite your attention to, my lord, the evidence of, my lord, Dr. PW2. There, my lord, paragraph 2. Mohan Kumar, aged 35 years, son of Bidarappa, Takka village, post Chikmagalur district, got admitted to SC Hospital, Hassan on 26/1/2016. Date of accident, my lord, is 21/1/2016. Following alleged history of self-fall, patient later got registered MLC on 1/2/2016. This is the, my lord, evidence of the doctor, where it has been specifically stated, my lord. Then, my lord, PW2, my lord, further cross-examination. You have got it, my lord?
Yes.
Yes. ವಿಚಾರಣೆ 8ರಲ್ಲಿ ಅರ್ಜಿದಾರರು ಸ್ವತಃ ಬಿದ್ದು ಗಾಯ ಮಾಡಿಕೊಂಡಿದ್ದಾನೆ ಎಂದು ನಮೂದಿಸಿದೆ ಎಂದರೆ ಸರಿ. ದಿನಾಂಕ 1/2/2016ರಲ್ಲಿ ಅರ್ಜಿದಾರ ಸಲ್ಲಿಸಿದ ಪ್ರಮಾಣ ಪತ್ರದ ಆಧಾರದ ಮೇಲೆ ಅಪಘಾತ ವಹಿಯಲ್ಲಿ ಅಪಘಾತ ವಿಭಾಗದ ವೈದ್ಯಾಧಿಕಾರಿಗಳು RTA ಎಂದು MLCಯಲ್ಲಿ ದಾಖಲು ಮಾಡಲಾಗಿದೆ ಎಂದರೆ ಸರಿ. MLCಯಲ್ಲೂ ಸಹ ವಾಹನ ಸಂಖ್ಯೆ ನಮೂದು ಆಗಿಲ್ಲ. ಅರ್ಜಿದಾರನಿಗೆ ಸಹಾಯ ಮಾಡಲು ಸೆಲ್ಫ್ ಕಾಲ್ ಇದ್ದುದನ್ನು RTA ಎಂದು ಬದಲಾವಣೆ ಮಾಡಿದ್ದೇವೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಪೊಲೀಸರಿಂದ RTA ಎಂದು ಬದಲಾವಣೆ ಮಾಡಲು ಯಾವುದೇ ಸೂಚನೆ ಬಂದಿರುವುದಿಲ್ಲ ಎಂದರೆ MLCಯಲ್ಲಿ ನಾನು ಬರೆದಿಲ್ಲ. ಅಪಘಾತ ವಿಭಾಗದ ಕರ್ತವ್ಯ ಇರುತ್ತದೆ. ಕೇಸ್ ಶೀಟ್ ನಮ್ಮ ವಿಭಾಗದ ವೈದ್ಯರು ಬರೆದಿರುತ್ತಾರೆ. ಕೇಸ್ ಶೀಟ್ನಲ್ಲಿ ಸೆಲ್ಫ್ ಫಾಲ್ ಎಂದು ನಮೂದು ಆಗಿದೆ ಎಂದರೆ ನಿಜ. ಕೇಸ್ ಶೀಟ್ನಲ್ಲಿ ವಾಹನ ಸಂಖ್ಯೆ ವಿವರ ಬರೆಯುವ ಅವಶ್ಯಕತೆ ಇರುವುದಿಲ್ಲ. ಅರ್ಜಿದಾರರ ಹೇಳಿಕೆ ಪ್ರಕಾರ ಕೇಸ್ ಶೀಟ್ನಲ್ಲಿ ಸೆಲ್ಫ್ ಫಾಲ್ ಎಂದು ಬರೆಯಲಾಗಿದೆ. ನಮ್ಮ ಆಸ್ಪತ್ರೆಯ ಎಲ್ಲಾ ದಾಖಲಾತಿಗಳಲ್ಲಿ ವಾಹನ ಸಂಖ್ಯೆ ನಮೂದು ಆಗಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಅರ್ಜಿದಾರರ ಪ್ರಮಾಣ ಪತ್ರ ಸಲ್ಲಿಸಿ ಮೇಲೆ ವಾಹನ ಅನಾನ್ ಎಂದು ಬರೆಯಲಾಗಿದೆ. This is the Malord thing. Therefore, kindly see the date Malord is shown in 1/2/2016 in a small letter which has been Malord in after that. Even then Malord, the FIR Malord I brought to your lordship notice.
Yes.
In spite of this, my lord, where all, my lord, it has been shown a non-vehicle, self-fall, then, my lord, the officer of the insurance company was also examined as RW1 to speak about these things. In spite of that, my lord, the tribunal holds that the vehicle involved is insured vehicle and thereby, my lord, the liability is fixed on the insurance company. Against which, my lord, the present appeal is valid.
Yes.
Now,
Yes,
my lord,
Mr.
I'll take your lordship through the, my lord, reasoning of the, my lord, the tribunal.
Yes, that here read. Yes.
Yes. Lord, this is very clear from the record, my lord, that even the charge sheet for the first time, my lord, the vehicle number is mentioned. In this record, Lord, I would like to, my lord, cite a ruling of this court.
Yes.
Where it is an unknown vehicle, my lord, then the investigator has to be examined.
Which is that?
Yes, my lord, one. By his lordship justice, my lord, N.K. Patil and
Satyanarayan.
Satyanarayan, my lord. Yes, my lord. Reported in, my lord, 2009 ACJ page 708. MFA 11,443 and 11,440 of 2006. Decided, my lord, on 18/7/2012 by the division bench.
Yes, Mr. Counsel, we'll send it back. You examine that investigation officer. They
Please,
can
my lord.
also, yes,
Please, my lord, remand the matter. I'll examine the.
yes, we'll send it back, Mr.
Please, my lord, please.
Lord, one thing has to be, my lord, the interest part, my lord, has to be made clear because the tribunal, my lord, is saying that no observation is made by the appellate
No,
court.
I will permitted you to raise that question before the tribunal. Let them decide.
Please, my lord, please, my lord.
Yes, thoroughly. So and so learned counsel appearing for insurance company or Mahesh or grounds secondary A to E. Counsel appearing for the respondent has contended that the claimant has contended that the accident is occur due to the negligence of rider of motorcycle bearing registration number KA 13 X528. Since claimant was unconscious, the attender who has come to that hospital has given a information that self-fall, has wrongly given information that it is self-fall.
Father is the pillion rider, my lord. He has given the. Father is the pillion rider of the motorcycle.
ಅಲ್ಲಿ ಫಾದರ್ ಹೆಸರು ಬರ್ತಿಲ್ಲ. ಅಟೆಂಡರ್ ಅಂತ ಬರ್ದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ FIR ಅಲ್ಲಿ ಇದೆ, ಅದಕ್ಕೋಸ್ಕರ ಹೇಳ್ತೀನಿ.
No, FIR ಅಲ್ಲಿ has he said I have taken him to that hospital?
ಇಲ್ಲ ಹೇಳಿಲ್ಲ.
ಅದೇ ಅದ್ ನೋಡಿದ್ವಿ ನಾವು, ಎಲ್ಲೂ ಇಲ್ಲ. ಹಂಗಾಗಿ therefore we will say that attender. Yes. The wrongly given as self fall. He further contended that since claimant was suffered grievous injury and unconscious, he is not in position to lodge a complaint immediately. He further contended that Adhikshita judgment. Further contended that on the basis of the complaint, the police has registered a FIR. After thorough investigation, the police has filed in a charge sheet. Therefore, the evidence of PW1, FIR, charge sheet and spot major clearly prove that driver of the offending vehicle is, rider of the offending motorcycle is negligent in causing that accident. To disprove the same, the respondent has not examined rider of the motorcycle bearing registration number KA13 X528. Tribunal, after considering that, rightly held that so and so is negligent in causing that accident. Heard the learned counsel for the parties, peruse judgment and award. It is not in dispute. Now I will confirm that quantum, Mahesh. Otherwise, it may enhanced again. Unmute ಮಾಡಿದಿರಲ್ಲ.
Sir, mic mute ಆಗಿದೆ.
But so far as that, everything may be kept open, because
yes, that will do it. That is, I thought that it is beneficial for you. Then it will be for him that beneficial. Yes.
Please, my lord.
Yes. Heard the learned counsel for the parties. The specific case of the claimants that on 21/1/2016 at about 9 p.m. petitioner was proceeding by riding a bike bearing registration number A18 EB7725 along with his father, who is a pillion rider, near Kalaspura Lakia Road. At that time, rider of the bike bearing registration number KA13 X528 drove the same in negligent manner, dashed against the petitioner bike, as a result of which he fell down, sustained grievous injury. Immediately after, he has been shifted to Government Hospital Chikmagalur and he has been referred to Government Hospital Hassan. The complaint has been lodged after 21 days. In the complaint, the vehicle name has been mentioned unknown. First time, the vehicle name has been mentioned in the charge sheet. Learned counsel for appellant insurance company has contended that in all medical records, it is mentioned as a self-fall. First time, the offending vehicle name has been mentioned in the charge sheet. To prove the same, they have not examined the investigation officer. He is also relied on judgment of this court, division bench of this court. This court in MFA 11443 of 2016 on 14 July 2012 para 27 akade. This court para 27 akabut is sufficient upon the appellant they have to be wearing so and so. it is very clear from the above that the evidence of investigation officer is necessary under these circumstances to give an opportunity to the parties, the matter required to be reconsidered by the tribunal afresh after giving an opportunity to the parties to examine the investigation officer and other witnesses if they required, a investigation officer and other witnesses. Accordingly, the appeal is allowed, judgment and award passed by the tribunal is set aside. The tribunal is directed to reconsider that matter afresh in accordance with law, after giving an opportunity to both the parties to adduce additional evidence and produce additional documents. Yes, parties are directed to appear before the tribunal on 22nd October
Obliged, my lord.
without any further notice. Amount in deposit is transferred to the tribunal. Yes.
Obliged, my lord.
Mic mute ಆಗಿದೆ sir.
Yes, my 22nd October appearance.
Like regarding interest, my lord, in case he succeeds, they should
No,
not.
yeah, yes, in respect, at this stage, Learned Counsel appearing for insurance company has contended that in case that claimant has succeed, the insurance company is not. No, why that they have succeeded in the earlier occasion also? It is not that.
After the remand, my lord, from the date of claim petition, my lord.
No, see, if they have.
Not during the pendency of the my lord.
No, if the claim petition is dismissed, then if it is remanded, it is different. It is allowed. Therefore, that question is not arises. If the claim petition is dismissed, they have come before that appeal. Then if we are remanded, if they succeed, it is different. Here they have succeeded.
If I succeed, my lord, then there is no question of.
Yes, yes.
Serial number 63, Nagaraja Hegde for appellant.
Amount in deposit to be transferred
Yes,
to
yes. Transfer to the tribunal.
Please.
63,
Lord, I apply for appellant.
Yes.
Case of injury, my lord.
An enhancement,
Only for enhancement.
Yes.
He was aged about 18 years.
Yes.
He was a vegetable sender, my lord. Working as and claimed 15,000 per month. The tribunal has taken 9,000. And the disability has been assessed by the doctor PW2 at 20% towards whole body disability. Since the injury fracture of D12, L3 and L4 spine injury.
Doctor goes to show that petitioner having 20% permanent physical disability in respect of his spine. Component number 3, insurance company admitted that 10% disability is to be considered to the whole body, but this case petitioner sustained injury spine 20 in respect of the whole body. ಎಷ್ಟು consider ಮಾಡಿದ್ರೆ
20% ತಗೊಂಡಿದ್ದಾರೆ sir.
ತಗೊಂಡಿದ್ದಾರಲ್ಲ
20% ತಗೊಂಡಿದ್ದಾರೆ. My only submission is, my lord, in the evidence, the doctor has specifically stated that, my lord, he has got difficulty in 50% difficulty involving one vertebral body, known with no neurological manifestation. The evidence of doctor may kindly be looked into for a moment.
No, ultimately he said that 20%.
20%, but earning capacity, my lord, so far as functional disability is concerned, my lord, since it is a spine disability.
No, that's what he has to say. Disability 20% ಅಂತಂದ್ರೆ functional disability ನೇ. ಅವ್ರು ಅವಾಗ ಏನ್ ಹೇಳ್ಬೇಕಿತ್ತು ಅಂತ ಅಂದ್ರೆ
physical disability ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
No, physical disabilities, functional disabilities, he should have said that it is 50% because of this reason. He has not said.
But in the earlier.
After taking these difficulties, he said 20%.
So far as physical is concerned,
But that,
20%.
by evidence of the doctor.
Functional disability has to be considered, my lord, in this
That
case.
is 20% is the functional disability. Physical disability 20% andre compensation ಯಾಕೆ ಕೊಡ್ತಾರೆ?
That is what, my lord.
20% functional disability lost to your earning. Therefore, that will be compensated.
Please, my lord. This
our ಏನಾದ್ರೆ 10 ತಗೊಂಡಿದ್ರೆ ನಾವು 20 ಮಾಡಬಹುದಿತ್ತು because doctor evidence is there.
My humble submission is, my lord, our division bench of our honorable high court, my lord, has held, my lord, future prospects has to be considered in this type of cases, my lord. 20% disability ಇರೋದ್ರಲ್ಲಿ
This court has
What
taken
is that? He can't do any work in the future. That's
Yes,
what
but
they said.
evidence ಅಲ್ಲಿ ಬಂದಿದೆ ಸ್ವಾಮಿ.
Doctor ಹೇಳಿದಾರ?
ಡಿಸೇಬಿಲಿಟಿ ಅಸೆಸ್ಡ್ ಅದನ್ನ ಯಾವ್ದಕ್ಕೆ ಏನೇನ್ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ. ಪೇಜ್ ನಂಬರ್ 3 ಆಫ್ ಎವಿಡೆನ್ಸ್ ಆಫ್ ಡಾಕ್ಟರ್. ಅಲ್ಲ ಬರೀ ಅದೊಂದೇ ಫ್ರಾಕ್ಚರ್ಸ್ ಅಲ್ಲ ಸ್ವಾಮಿ. ದೇರ್ ಆರ್ ಸೆವರಲ್ ಫ್ರಾಕ್ಚರ್ಸ್.
ಆಯ್ತು, ಆಮೇಲೆ ಏನು?
ಫ್ರಾಕ್ಚರ್ ಆಫ್ D12, L3, L4 and fracture of 8th rib. Fracture of
After perusal of the sheet so on to 20 so on, so it is above. ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್? ಡಾಕ್ಟರ್ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ
ಮುಂದೆ ಕೆಲಸ ಮಾಡಕ್ ಆಗಲ್ಲ ಇತ್ತು.
ಅಲ್ಲ ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರ ಸ್ವಾಮಿ ಅವರು.
ವೇರ್ ಇಸ್ ದಟ್ ಮಿಸ್ಟರ್? ನಿಮ್ದೇ ಡಾಕ್ಟರ್ ಅಪ್ಪ, ನೀವೇನು ಹೇಳ್ಸಿಲ್ಲ.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಏನೇನ್ ಡಿಫಿಕಲ್ಟೀಸ್ ಇದೆ ಅಂತ ಹೇಳಿ ಅದನ್ನ
ಡಿಫಿಕಲ್ಟೀಸ್ ಇದ್ಮೇಲೆ ಅದನ್ನ ಹೇಳ್ಬಿಟ್ಟೆ ಅಸೆಸ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ.
ಆಮೇಲೆ ಹೇಳ್ಬೇಕಲ್ಲ.
ರಿಸ್ಟ್ರಿಕ್ಷನ್ಸ್ ಆಫ್ ಮೂವ್ಮೆಂಟ್ಸ್ ಆಫ್ ಸ್ಪೈನ್.
ಡಿಸಬಿಲಿಟೀಸ್, ಸ್ಪೈನ್ ಇಂಜುರಿಯಿಂದ ಇವನ್ ಮುಂದೆ ಕೆಲಸ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ, ಇವನಿಗೆ ಇನ್ಕಮ್ ಅಲ್ಲಿ ಲಾಸ್ ಆಗುತ್ತೆ, ಅಥವಾ ಫ್ಯೂಚರ್ ಅಲ್ಲಿ ಇವನಿಗೆ ಏನು ಭವಿಷ್ಯ ಇಲ್ಲ, ಇದರಿಂದ ತೊಂದರೆ ಆಗುತ್ತೆ ಅನ್ನೋದಿದ್ರೆ ಫ್ಯೂಚರ್
ಅದನ್ನು
ಹೇಳಿಲ್ಲ.
ಹೇಳಿಲ್ಲ ಬಟ್ ಕನ್ಸಿಡರಿಂಗ್ ದ ಎವಿಡೆನ್ಸ್.
ಏನು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬರೀ ಇಂಜುರಿ ಹೇಳಿದ್ದಾರೆ?
ಅಲ್ಲ ಇಂಜುರಿ ಅಲ್ಲ ಸ್ವಾಮಿ, ನೆಕ್ಸ್ಟ್ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದಾರೆ.
ಅಮ್ಯುನಿಟೀಸ್ ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಜಾಸ್ತಿ ಮಾಡೋದು. ಸೊ ಫಾರ್ as the difficulties are concerned, my lord.
Yes.
Compression of less than 50% of involving one vertebral body. ಅದು ಪೇಜ್ ನಂಬರ್ 3 ನಲ್ಲಿ ಅವ್ರದ್ದು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ there are some difficulties ಏನೇನಿದೆ, ಯಾವ್ಯಾವ್ದಕ್ಕೆ ಎಷ್ಟು ಪರ್ಸೆಂಟ್ ಇದೆ ಅಂತ ಹೇಳಿ ಹೇಳ್ತಾರೆ.
ಆಯ್ತು, ಆ ಡಿಫಿಕಲ್ಟ್ ಇಂದ
Therefore,
ಅವಕೇಶನ್ ಗೆ ಹೆಂಗ್ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಂತ ಡಾಕ್ಟರ್ ಹೇಳ್ಬೇಕು.
That has not been stated specifically.
See, ನಿಮಗೆ 2 ಕಾಲ್ ಆಂಪ್ಯೂಟ್ ಮಾಡಿದ್ರು ಕೂಡ ಕ್ಲರ್ಕ್ ಕೆಲಸ ಮಾಡೋನಿಗೇನು, ಟೈಪ್ ರೈಟಿಂಗ್ ಕೆಲಸ ಮಾಡೋನಿಗೇನು ತೊಂದರೆ ಆಗೋದಿಲ್ಲ. ಹಂಗೆ ಅವಕೇಶನ್ ಗೆ ಹೆಂಗ್ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಂತ ಡಾಕ್ಟರ್ ಹತ್ರ ಹೇಳ್ಸ್ಬೇಕು ನೀವು. ಅವಾಗ ವಿ ಕ್ಯಾನ್ ಸಿ ಅವ್ರ ಇವನು ವಾಟ್ ಇಸ್ ಹಿ
ವೆಜಿಟೇಬಲ್
ವೆಂಡರ್ಗೆ ಬಿಕಾಸ್ ಆಫ್ ಸ್ಪೈನ್ he can't move that vehicle, he can't push. ಅದನ್ನ ಡಾಕ್ಟರ್ ಹೇಳ್ಬೇಕು.
ಅಲ್ಲ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಇವರು PW1
you are making me as in a doctor to give all this in that this thing.
ಇಲ್ಲ ಅದಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ
ಅದು ಏನು ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಯಾವುದು ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಫಿಡವಿಟ್ ನೀವೇ ಟೈಪ್ ಮಾಡತ್ತಾನೆ.
ಇದರಲ್ಲಿ ಮಾಡಿರ್ಬೋದು.
ಡಾಕ್ಟರ್ ಎಲ್ಲಿ ಮಾಡ್ತಾರ ಅವ್ರು? ನೀವು ಟೈಪ್ ಮಾಡ್ಕೊಡ್ತೀರಾ, ಸೈನ್ ಹಾಕ್ತಾರೆ. ಆಯ್ತು, ಇದರಲ್ಲಿ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಅಂಡ್
please and 48 days or 41 days he was inpatient.
ಅದು
6 ತಿಂಗಳ ಕೊಡಬೇಕಾಗುತ್ತೆ ಯಾಕಂದ್ರೆ 3 ಮಂತಿಂದ ಕೊಟ್ಟಿದ್ದಾರೆ. 3 months
earning, loss of bed rest, loss of earning during the treatment, ಎರಡು ಸೇರ್ಸ್ ಕೊಟ್ಟಾರಲ್ರಿ?
ಹೌದು ಸರ್, ಅದನ್ನ ಎರಡಕ್ಕೂ ಸೇರಿಲ್ಲ.
ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ಅರ್ನಿಂಗ್ ಕೆಪಾಸಿಟಿ ಆಯ್ತು,
ಅದು 9500 ತಗೋಬೇಕು ಸರ್. ಅಷ್ಟೇ. ಕನ್ವೇನ್ಸ್ ನರಿಶ್ಮೆಂಟ್ ಅಲ್ಲೂ ಕಮ್ಮಿ ಆಗಿದೆ. ನಾವು 10,000 ಕೊಟ್ಟಿದ್ದಾರೆ. 41 days
ಕೊಟ್ಟಿಲ್ವಾ
ಸ್ವಾಮಿ? ಅಮ್ಯುನಿಟೀಸ್ ಕೊಡ್ಲಿಲ್ಲ.
Yes, ತಗಡಿ. So and so learned counsel appearing for
ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಅಲ್ಲ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೇಳಿದೆ ಸ್ವಾಮಿ, ಅವರಿಗೆ ಮುಂದೆ ಸರ್ಜರಿ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಅಂತ ಹೇಳಿ.
ಎಷ್ಟು ಅಂತ ಹೇಳಿದ್ದಾರೆ?
ದುಡ್ಡು ಎಷ್ಟು ಅಂತ ಹೇಳುದಿಲ್ಲ ಸ್ವಾಮಿ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ.
ಏನು ಎವಿಡೆನ್ಸ್ ಇಲ್ದಾನೆ ಹೌ ಕ್ಯಾನ್ ಬಿ ಮಿಸ್ಟರ್?
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅವರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್
in that year and put it mister. There should be an evidence all these things.
ಬರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಬಂದಿದೆ, ಅವರಿಗೊಂದು ಮಾಡಬೇಕು ಅಂತ.
So learned counsel appearing for the claimant has contended that at the time of the accident he was earning 15,000 per month. Tribunal has assessed 9,000 is on lawyer side. Secondly, he has contended that due to that accident claimant has suffered grievous injury. He was inpatient for a period of
41 days.
41 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses is on lawyer side. Sought for enhancement of compensation. Raju learned counsel appearing for insurance company has contended that even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income as 9,000. Considering that evidence of doctor and injury suffered by the claimant and medical records, compensation awarded by the tribunal, pain and suffering, loss of immunities, other incidental expenses, just and reasonable. Sought for enhancement, dismissal of the appeal. Heard the learned counsel for the parties. Peruse judgment and award, and original records. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 20th/5/2016 to rash and negligent driving of driver of lorry bearing registration number GA09 U1107. Due to that accident, he has suffered the following injury. He has examined the doctor. He has assessed the disability of 20% permanent physical disability in respect of his spine. Accordingly, tribunal has rightly considered whole body disability is 20%. Even though he has claimed that he was earning 15,000, no document has been produced. Notional income has to be considered as 9,500. Multiplier applicable to that age group is 18. Accordingly, loss of future earning reassessed as follows.
9,500 into 12 into 18 into 20%, 4,10,400.
Due to that accident, claimant has suffered the above said injury. He was inpatient for a period of 45 days.
41 days.
41 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 40,000 to 75,000. Loss of income during the later period has to be granted for 6 months. Loss of earning during the treatment and loss of bed rest, together it has to be granted for 6 months. The claimant is also entitled for loss of income, loss of immunities is 50,000. ಎಷ್ಟಾಯ್ತು ಇಲ್ಲಿ 40 immunities ಕೊಟ್ಟಿಲ್ಲಲ್ಲ?
ಕೊಟ್ಟಿಲ್ಲ.
Yes, 60,000. And convenience nourishment has to be enhanced from 10,000 to 20,000. Yes.
Much obliged.
Accordingly, the appeal is allowed in part.
Second time passed over matter. Serial number 22, Nagaraj, AC, P. Ramamurthy for appellant, B. Purandara. Serial
Yes.
number 22.
None appears. Use this matter after 4 weeks. Seventeenth. ಸ್ವಲ್ಪ ಮ್ಯಾಟರ್ ಕಡಿಮೆ ಯಾಕಂದ್ರೆ 230 ಮ್ಯಾಟರ್ ಇದೆ. ಒಂದು 60 ಮ್ಯಾಟರ್ 55 ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಮೋಸ್ಟ್ಲಿ ಅದೇ ಆಗ್ಬೋದು.
ಪಾರ್ಟ್ ಆರ್ಡ್ಗಳು ಜಾಸ್ತಿ ಹಾಕೊಂಡಿದ್ದೀವಿ. ಹೌದು, ಫುಲ್ ಕಡಿಮೆ ಮಾಡಿ ಎಷ್ಟು 55,000. ಮೇಡಮ್, ಫ್ಯೂಚರ್ ಡೇಟ್ ತಗೊಂಡಿರ್ತಾರೆ. ಇಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ ಮೆಮೊ ಇಡ್ತಾರಲ್ಲ, ಸಾಹೇಬ್ರು ಎಲ್ಲ ಮೆಮೊನು ನೋಡಲ್ಲ. ಬರೋಕ್ಕಿಂತ ಮುಂಚೆನೇ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿರ್ತಾರೆ, ಅಥವಾ ಬಂದ್ಮೇಲೂ ಯಾವ್ದಾದ್ರು ಅರ್ಜೆಂಟ್ ಇದ್ರೆ ನಾಳೆದ್ ಮಾತ್ರ. ಕೆಲವೊಂದೆಲ್ಲ ನಾವೇ ಕೊಡ್ತೀವಿ. ಅಂತ ಮೆಮೊಗಳು ಈಗ ಅಪಲೆಂಟು ಫ್ಯೂಚರ್ ಡೇಟ್ ತಗೊಂಡಿದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟು ಅರ್ಜೆಂಟ್ ಆಗಿ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಮೊನ್ನೆ ಹೋದ್ಸಲ ಬಂತು, ಸಾಹೇಬ್ರು ಬೇಡ ಈ ತರದ್ದೆಲ್ಲ ಬರಬಾರ್ದು ಅಂತ ಹೇಳಿದ್ರು. ಏನಾದ್ರು ಮೆಮೊ ಮೂವ್ ಮಾಡೋದು ನಾನು ಗಮನಕ್ಕೆ ತರಬೇಕು ಅಂತ. ಇವತ್ತು ಆತರ ಜಾಸ್ತಿ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದಾರಂತೆ, ನಿಮ್ಗೆ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ರು ಸಾಹೇಬ್ರ ಮಾತು. ಹಾ ಹಾ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲದೆ ಇವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲದೆ ಅವರು ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಯಾಕಂದ್ರೆ ಸಿಟ್ಟಿಂಗ್ ಕ್ಲೋಸ್ ಆಗೋಗುತ್ತೆ ಅಂತ.